of the World Jurist Association and the World Law Foundation, Jose Luis Martinez Almeida, Mayor of Madrid, Presidents and Justices of the Constitutional and Supreme Courts of Albania, Germany, Guatemala, Iraq, Poland, Slovenia, Spain, the United States, and Uruguay, and delegates from more than 24 countries who gather here today. Ladies and gentlemen, welcome to the World Jurist Association's tribute to Anthony Kennedy, Senior Justice of the Supreme Court of the United States, and an example to all of us, defenders and promoters of the rule of law worldwide. I am Patricia Lee Rifo. I am a former president of the American Bar Association, and I am pleased to be your host today. We will start this session with the opening remarks of Javier Cremades, president of the World Jurist Association and the World Law Foundation. Javier.
Thank you. Good morning. Patricia, there is a space for you, Patricia Lee Rifo. If you want, there is a space for you here. But first of all, let me welcome all of you that come from so many different countries. Mr. Mayor of Madrid, Deborah, past president of the American Bar Association, Patricia Lee Rifo, Vivian Reding, vice president of the World Law Foundation, Egon Levitz, my friend from Latvia. I was explaining to the mayor that is the only European has been serving in the two European courts of Justice and European Court of Human Rights, and presidents of the Constitutional Courts of Dominican Republic, of Guatemala, of Iraq, of Poland, of Slovenia, and of Germany. So thank you very much. My friend Victor Olea, president of the Mexican Bar Association, my friend Roberto Valdez, the trustees of the World Law Foundations, Milton Rey Guevara, Javier Gonzalez, Gianpaolo Zambelletti, all the trustees as you are here, Luis Javier Luján, Javier Jaramillo. So Kim Quarles, vice president of the World Jurist Association. It's a big honor to have you, all of you here. And let me share with you 3 points, which we are going to do today. I think we are connecting two ideas. The first one being the campaign that started a few years ago, 60 years ago, for the rule of law, trying to federate and connect together jurists from around the globe. So we had incredible people like Charlie Ryan, like L. Warren, who believed in a world ruled by laws and not by force. And they did something at that time where the world was threatened by a nuclear holocaust, by a nuclear disaster. At that time, the world was dangerous, but probably was a bit simpler than it is today. So we have the Iron Curtain, and one side of the Iron Curtain were the good guys, the people that had the rule of law, and the other side of the curtain were the people that were restricting rights of the people, restricting liberties, and restricting human dignity. These persons, Charlie Ryan and L. Warren, decided to work together with them and to establish a campaign together with them. And they developed, Marisa, you have a place here. They develop congresses on the other side of the Iron Curtain in Moscow, in Beijing, in Berlin, on the other side of the wall, on the DDR, on the German Democratic Republic. And it was a great time because they were just campaigning and showing, first of all, that the people of law could talk to each other even if they have different systems, but secondly, that there is a better way to live, which was the rule of law. It's not a perfect way to live, but it's a system where the human being is at the center and the public power is limited in its exercise and only is legitimate if it's under the Constitution, under the laws. So that's the first point. We are continuing this campaign today. It's our generation. is the mayor, who is an attorney himself. He's a prominent attorney. Is a wall of architects of the rule of law. Professor Peter Heberle said that every citizen contributes to the construction and existence and the reality of the rule of law. So a democracy is not just run by elites. It's sustained by the support of the people. So we are in this small room, these 100 people that we are here, we're ambassadors and architects of the rule of law and need to be contagious about this idea, is that if power is not limited by laws, power will extend, will try to be perpetuated, and will corrupt. So we need a system where a constitution runs the life of a country of the citizens, a real constitution. The second point is that today we are rendering tribute to Anthony Kennedy. It's not just Anthony Kennedy. It's not himself as a prominent justice of the US Supreme Court. It's the idea that this institution, the World Jurist Association, was promoted by an American Bar Association chairman, Charlie Ryan. We have here 2 chairwomen of this association. He's still the youngest ever. I don't know if he was 35, 34 when he was elected. And L. Warren, at that time Chief Justice, he was humble enough to engage in a project that was small at the beginning. And the first Congress of the World Jurists was held in Athens in 1963. They elected Athens as a recognition to the roots, Vasilis Mortakidis, of the system of laws, of the thoughts of Aristotle and Plato and all these big thinkers that were quoted in that Congress. By the way, that Congress was opened by the grandfather of the Spanish king Felipe VI, who will be meeting with us tomorrow. So this institution, the Supreme Court, felt at that time the responsibility that, welcome Mr. President. This institution felt at the time the responsibility of being the first court on earth. For me, the second court on earth is sitting here, is the Bundesverfassungsgericht. But for sure, Supreme Court has an incredible influence. So today we will hear the speech on video of the President of the Supreme Court, of the Chief Justice of the US, John Roberts, who will connect with L. Warren at that time. So he will explain this afternoon that he's campaigning in the same way that L. Warren did. We are all doing the same thing. That's the second point. So the US Supreme Court is, as you know, not a perfect institution, but they run the largest and the most old and experienced democracy in the world, facing, by the way, almost the same threats or even bigger threats than any other democracy in the world. So that's the second point. First point, we're continuing that campaign. Second point, we're recognizing the role of the Supreme Court of the United States, which is probably a role model for not just for the achievements, but also for the threats and the mistakes as well. And thirdly, my last point is we need to connect the threats that we are engaged with, the threats that we are living today in our systems. We saw what happened in the UK with the Brexit. We saw what happened with the Prime Minister sent the Speaker of the government to the BBC, starting to say that many people say in the UK that judges are biased. And we saw the Daily Mail cover speaking about judges as enemies of the people. And we saw the reaction of the British society saying, you don't make misunderstandings to the people about the independence of the judiciary. You are attacking the rule of law. We live in a world and our lifestyle is sustained by a pillar, which is the rule of law. So you please don't do that. everybody was just reacting. We are seeing what is happening right now in Brazil, what is happening right now in the US, what is happening right now in Israel, and I don't refer, of course, to the wars, which is the most terrible thing. I am referring about the debates inside the society, the division, the complication of running a democracy, where the truth is missing, and the possibility of living in a world where public opinion is running as sovereign, the system is getting much more difficult, where polarization is killing us because it's not just dividing us, it's sometimes confronting us and bringing us even into conflict, permanent conflict. We saw what happened when the system is totally destroyed in Venezuela or in Nicaragua. We saw that a constitution, a true constitution, can be destroyed. And it's not destroyed from one shot. It's destroyed through a process. And this process had started everywhere, and we need to just, as a sickness, we need to do the good therapy. And the good therapy, in my view, is education. And the only way we can go there is that citizens get conscious that they need to defend the only systems that protect their own dignity. So that's all about what we're going to do today and tomorrow. And I hope we had good discussions, and we had the most important thing I remember, Mayor, this all started in 2017 when we had this proceso in Catalonia, very complicated. Then we called our brothers from the World Jurist to come to Madrid in 2019 to organize the World Congress. And we put the king on the center to say, okay, this is a full democracy, this is a strong democracy, and the king represents a rule of law state that has been for 40 years developing peace through law. After that, we decided to establish in Madrid the World Law Foundation and to work together with the World Jurist, which is established in Washington, D.C. From then, Madrid becomes, every 2 years, the center of a powerful meeting of powerful leaders of the law. 2 years later, in 21, we had the first Ruth Bader Ginsburg Awards. Again, with Felipe VI, who was presiding these awards. And I remember that Chief Justice from Canada, my friend Robert Wagner, came. And he said to me, you know why I came? I came because I don't know my Latin American friends, and I want to meet them and learn from them. They didn't know each other. So the Chief Justice from Canada didn't know the Chief Justice from Mexico or from Argentina or from Chile. And probably that's the same here. We have here the Chief Justices from 12 different countries, and I hope that you have the chance to do it. 2 years later, in 2023, in May last year, we had another big gathering. We offered the World Peace and Liberty Award to Andrew Young in this room. We were opening this room. Again, the World Peace and Liberty Award awardee, Felipe VI, was presiding this meeting. Our mayor was in campaign, who was elected, and but he was following what is happening. And right now, 1 year later, we're having again incredible summit of leaders of the world, of the law, of the rule of law. So very happy to have you from the Middle East, from America, from Europe, from Asia, and let's campaign. Let's work together. Let's try to help any jurist in the world to reconnect with their purpose. And their purpose is not anyone that to promote human dignity and human liberty. And the only way to do that is that we all live governed by laws, by good laws. So let me finish in Spanish. Un placer, querido alcalde. Débora, os debemos mucho a esta institución. La American Bar Association inventó esta especie de movimiento mundial para federar, conectar y animar a los juristas del mundo a que propusieran la paz a través del derecho como un modelo de vida para toda la humanidad. Y si en los tiempos de la Guerra Fría aquello era necesario, en los tiempos de esta complejidad donde las autocracias están penetrando las democracias y están haciendo muy difícil el gobierno de las leyes y están aumentando la polarización y dificultando que la opinión pública se forme a través de una información verdadera, En esos momentos, más que nunca, tenemos que recordar que la educación y la conexión con ese propósito es fundamental. Madrid, desde el año 2019, tiene una fundación mundial que se dedica a promover el Estado de Derecho y cada año está convocando a un grupo de líderes que hoy se encuentran aquí muy bien representados por presidentes de Cortes Supremas de países tan diversos como Alemania, como la República Dominicana, como Eslovenia, como Polonia, como Irak, países realmente que tienen situaciones políticas muy diferentes, pero todas tienen una constitución y tienen ese activo fundamental que deben preservar. Gracias, damos comienzo a esta sesión y tienen, como digo, por delante 48 horas para seguir conociéndose, seguir conectando, aprender unos de otros y seguir promoviendo el Estado de Derecho en el mundo. Muchas gracias.
Thank you, Javier. You always inspire us when you remind us the purpose for this gathering every year. Our guest of honor, Justice Anthony Kennedy, wanted to welcome all of you here this morning, and we have video remarks from him at this time. Could you play the tape? Thank you.
Greetings from Washington, D.C. You and your host are most gracious to ask me to add these few words of welcome as you meet in the wonderful nation of Spain with its ancient traditions of pride and achievement and its present-day unyielding commitment to the idea and the reality of freedom under law. His Majesty the King of Spain honors and enhances this opening session and your Congress by his gracious friendship and support of your association and of. Since your last meeting, it has been my honor and pleasure to converse as a friend and fellow professional with Javier Grimades, who presides over this Congress. Thank you again, Javier, for your many courtesies and your valued advice and suggestions. At first, it may seem ironic that your hosts have asked me to welcome you from thousands of miles away. And yet, in another sense, this is symbolic of your mission and our mission and purpose to reach out to all nations as we seek to inspire a renewed commitment to the judiciary, to the bar, and to the legal academy, a renewed commitment in them to respect the law and the human dignity that the law must protect. At the time of the framing of the American Constitution, James Madison had a list of books that Congress should acquire as part of creating what we now call the Library of Congress. Among those books was the book Law of Nature and Nations by Hugo Grotius, who wrote in the Netherlands in the late 16th century. Grotius, in turn, drew upon the scholarship of Francisco de Vitoria, who taught and wrote in Spain in the early 16th century. De Vitoria's defense of the human rights of native peoples in what is now South America influenced Grotius and many other scholars throughout the centuries. For those of you who enjoy teaching or maintain a close interest in the legal academy, it's interesting that Francisco de Vitoria was a dynamic and witty professor who enjoyed taking questions from his students during the classroom lectures. These references to ancient times are simply one example of how the rule of law must be a collective endeavor drawing upon the wisdom and learning of all who seek to understand how best we can govern. That endeavor is one that the World Jurist Association advances through meetings like this Congress, like your Congress, which begins today. All of us hope that as you meet here and as we converse over the great distances, we will become even closer as friends, and that we will renew our commitment always to advance the rule of law in the nations of the world. It is then a pleasure to add these words of greeting to the welcome already given to you by your splendid hosts. Best wishes for an inspiring and productive session here in Madrid. Thank you.
We thank Justice Kennedy for those warm opening remarks, and we look forward to hearing from him later today as well. It is now my great privilege to introduce my dear friend and law sister, Deborah Enix Ross, the immediate past president of the American Bar Association. Deborah.
Gracias. Buenos dias. That's all of my Spanish. I like to tell people I understand enough Spanish to get into trouble, but not enough to get out of trouble. So we don't want any trouble here today. Thank you, President Cremades Javier, for this invitation to speak at this extraordinary event. And a tribute to U.S. Supreme Court Justice Anthony Kennedy. So as has been said, I stand before you as the immediate past president of the American Bar Association, which is the world's largest voluntary organization of lawyers, judges, and legal professionals. And it is an honor and a privilege to be here with my sister in the law, truly a sister, Patricia Lee Rifo, who, as you know, is a past ABA president. In February 2020, shortly before COVID, the World Law Foundation came to the ABA's Washington, D.C. office, our headquarters, to present Justice Ruth Bader Ginsburg with its Peace and Justice Award. The ABA was proud to host this special event, not only for our joy in honoring Justice Ginsburg in her presence, but also because the event was a homecoming for the World Law Foundation and the World Jurist Association. These now independent organizations, as we've heard, came forth from the World Peace Law Through Law initiative of ABA President Charles Rines in 1958. President Rine is also famous for his other signature initiative known as Law Day, a day recognized every year on May 1st, when in the US, school children and citizens, bar associations, and judicial systems throughout the US celebrate the rule of law with educational and community events. Law Day has thrived ever since President Rine's vision 65 years ago, and we're thrilled to experience here today the continuing of those ideas through this World Peace Law initiative. The ABA joins nations and bar associations everywhere in standing forthright for the rule of law. The ABA Rule of Law initiative promotes justice, economic opportunity, and human dignity through the rule of law. The ROLI, as we call it, was established in 1990. It was meant to be a short-term pro bono project to advise on new laws and constitutions in a handful of Central European countries after the fall of the Berlin Wall. But today, our efforts through volunteers and staff are part of a global organization operating in more than 50 countries on 5 continents. And why do I mention Rowley? Because I'm thrilled that we are honoring Justice Anthony Kennedy, who served as one of our representatives on the ABA Rowley. So the connection between Justice Kennedy and the rule of law is deep and true within the ABA. We are so fortunate to have had him involved in our efforts, because one of the core values of the ABA is to advance the rule of law by increasing public understanding and respect for the rule of law, the legal process, and the role of the legal profession, not only in the United States, but throughout the world. So let me thank all of you. As friends, we come together at the World Jurist Association, first for your hospitality, but for your important work and programs that we are doing here today. It is important that all of us throughout the world stand together to promote justice under the rule of law, and I am proud to be a part of this conversation. Thank you for this opportunity.
Thank you, Madam President. And to close these opening remarks, it is our great honor to welcome Jose Luis Martinez Almeida, the Mayor of Madrid. Welcome, Mr. Mayor. The floor is yours.
Presidente de la World Jurist Association, querido Javier, presidente del Tribunal Constitucional Federal de Alemania, Stephen Harvard, vicepresidente del World Law Foundation, Vivian Reding, presidenta de la Bar Association y expresidenta de la Bar Association, autoridades, juristas, representantes de diversos tribunales constitucionales en el mundo, señoras y señores, permítanme decir que es un honor para mí, como alcalde de Madrid, poder inaugurar estas jornadas, estas 48 horas apasionantes en las que se va a debatir precisamente sobre la base y la esencia de la convivencia en la que organizamos nuestras sociedades y, por tanto, la primacía del Estado de Derecho, el rule of law, y más en un mundo en el que la incertidumbre es constante. Posiblemente no hemos vivido en un mundo tan incierto, con tantos peligros y numerosos interrogantes desde la finalización de lo que se denominó la Guerra Fría, y sin embargo, teniendo pocas certidumbres, hay una que es absolutamente esencial si queremos seguir progresando como sociedad y si queremos seguir fortaleciendo nuestra democracia, que es precisamente la vigorización y el fortalecimiento del Estado de Derecho. Y por tanto, querido Javier, a quien tengo que agradecer especialmente como alcalde de Madrid y a ti como madrileño que pasees el nombre de esta ciudad por todo el mundo en defensa del Estado de Derecho, estas 48 horas que se van a desarrollar a partir de este momento es un motivo de esperanza y de confianza en el futuro del conjunto de la humanidad, por 2 razones. En primer lugar, por el increíble, permítanme que se lo diga, talento jurídico que hay reunido en esta sala y, por tanto, por el increíble talento que está aquí reunido para diseñar un futuro y un mundo mejor. Y, en segundo lugar, porque el mensaje que se transmite al conjunto de la ciudadanía y, por tanto, sobre la necesidad de seguir trabajando sobre la base de la convivencia, sobre el Estado de Derecho. Y por eso, para la ciudad de Madrid, como digo, es un honor poder inaugurar estas jornadas. ¿Por qué? Porque nunca debemos dar por supuesto el Estado de Derecho, la democracia o la Constitución como cúspide de nuestro ordenamiento jurídico, sino que cada día tenemos que saber que son más los enemigos precisamente de este modelo de convivencia y, por tanto, que cada día tenemos que incrementar aún más el esfuerzo que cada uno, desde nuestra posición en la sociedad, desde la posición en la que ocupemos, debemos hacer, porque no dar nada por supuesto es el camino más corto, más eficaz y mejor para poder seguir incrementando precisamente nuestra confianza en el Estado de Derecho y, por tanto, nuestra confianza en el futuro como sociedad. Y por eso, frente a ataques que suceden en todo el mundo y de los cuales también, desgraciadamente, hemos sido testigos en los últimos tiempos en España, frente al señalamiento de autoridades judiciales, frente al debilitamiento de la arquitectura institucional, es necesario que alcemos, tal y como hace la World Jurist Association, tal y como lleva haciendo tantas décadas, Javier, la World Jurist Association, la voz del Estado de Derecho y, por tanto, el grito del rule of law como la clave, digo, de toda nuestra convivencia. Y para eso, nada mejor que tener símbolos, nada mejor que tener referentes, nada mejor que tener personas como Justice Kennedy, que son las que nos guían y nos ayudan en este camino. El homenaje que hoy se tributa a este juez, a este servidor público, a esta persona que ha hecho del servicio a los demás a través del derecho el motivo esencial de su vida, nos convoca a todos y, por tanto, también nos alienta y nos inspira a todos en el cumplimiento de nuestro deber y de nuestras funciones. El mensaje del cual acabamos de ser testigos, profundamente emocionante, creo que para todos los que hemos estado en esta sala, nos da la fuerza necesaria para poder seguir progresando y para que desde la World Jurist Association, así como la World Law Foundation, podáis seguir haciendo este trabajo por el que el conjunto de la sociedad siente, Javier, hacia vosotros una deuda impagable de gratitud e, insisto, más aún en los tiempos difíciles e incluso oscuros que estamos viviendo en numerosos lugares en el mundo. Y es que esta trayectoria de más de 30 años en la Corte Suprema de los Estados Unidos se puede entender única y exclusivamente de que cada hecho juzgado tiene circunstancias diferentes y, por tanto, no tiene un voto preconcebido y predeterminado, sino que hay que estudiar cada caso para que se cumpla el lema de la justicia, que es dar a cada uno lo suyo. Y por eso me gustaría expresarle al Justice Kennedy on behalf of the law-abiding city of Madrid, congratulations and many thanks for your work, your defense of liberty, and your profound and independent belief in justice paved the way for the new generations of jurists who deeply believe in individual liberty and the rule of law. Es un homenaje, por tanto, no solo de la World Jurist Association, sino también de la ciudad de Madrid, siempre al juez Kennedy, pero también a todas aquellas personas que en cualquier lugar del mundo luchan por preservar nuestra democracia y nuestro Estado de Derecho, porque no hay esfuerzo en un mundo tan incierto como el que vivimos más encomiable que precisamente ese. Muchísimas gracias a todos.
Thank you, Mr. Mayor. You honor us with your attendance and your welcoming remarks today. We will now start with our first panel of today's session regarding the independence of the judiciary and the rule of law. I am to give a kind reminder to our speakers that you are each limited to 7 minutes. That was a kind reminder. That way your moderator will not have to interrupt you. So thank you for that. Let me please, as we rearrange ourselves for just a moment, welcome to the podium Mojdrag Đorđević, President of the Supreme Court of Slovenia, please to the podium, and our panelists, Adrian Vasquez, Chairman of the Committee on Legal Affairs of the European Parliament, Faik Zeydan, the President of the Supreme Judicial Council of Iraq, Hector Perez Aguilara, President of the Constitutional Court of Guatemala, Holta Zaka, President of the Constitutional Court of Albania, John Perez Brignani, Magistrate of the Supreme Court of Uruguay, and Malgorzata, Manauska, First President of the Supreme Court of Poland. Please welcome our panelists and our moderator.
Can we start? Yes. First of all, I would like to thank you for the invitation and for the honor to be present at that so distinguished and eminent event. As a newcomer, I would like first very briefly introduce myself. My name is Miodrag Đorđević. My position is President of the Supreme Court of the Republic of Slovenia. I'm career judge sitting on the bench for 39 years, at the Supreme Court for 21 years. I'm dealing with commercial cases. I'm expert on insolvency law. I have PhD on insolvency. I'm member of INSOL, International Insolvency Institute. I'm help focal point. That means that I'm contact person to Council of Europe for education of legal professionals on human rights. Now it's better, okay. Thank you. So, I will start with my keynote speech. Ladies and gentlemen, I'm extremely honored to address you today in honor of the distinguished, I can say legendary jurist and judge, Justice Anthony Kennedy. It gives me a great pleasure to pay tribute to him, especially as a few years ago in Ljubljana, the capital of Slovenia, I had the privilege of meeting him in person. As we begin this discussion on the dependence of the judiciary, allow me to underline a fundamental truth. The rule of law cannot thrive without independent courts. Therefore, their independence should be respected, protected, and defended, not only by the state and social institutions, but by all those in position of power, for the sake of their own legitimacy. Emphasizing the independence of the judiciary and judges is of paramount importance, because it is a cornerstone for establishing and upholding the rule of law as a principle enshrined in our constitutions for the protection of human rights and fundamental freedoms. It is important to recognize that the independence of the judiciary is granted not only to protect the judges themselves, but also to ensure the integrity of the rule of law. With this in mind, it becomes clear that safeguarding the independence of the judiciary is not just a duty, but a profound responsibility, especially for those of us who work professionally within this system. Far from being a privilege of judges alone, independence is a right of citizenship that guarantees the impartiality of judicial decisions. The independence of the judiciary is a fundamental value and the cornerstone of any democratic society. The judiciary is the guardian, the bulwark of the rule of law. It is therefore imperative to strengthen the judiciary as a safeguard for the protection of citizens' rights against encroachments by the state and other special interest groups. As the eminent Slovenian professor Dr. Kranjc noted, a weak and dysfunctional judiciary means the end of the structured society and can only serve the interests of those who seek to evade the rule of law. In their endeavors, judges constantly strive to make the right legal decisions, to strengthen and shape the legal framework, thereby embodying the moral authority of society. However, a judge does not have moral authority by virtue of their position alone. Rather, it is through their diligent work, actions, and personal qualities that they achieve or establish moral authority. Judges must be aware of their responsibilities and act responsibly. Their ethical behavior, sense of justice, personal integrity, and professionalism are indispensable for making fair and equitable decisions. As Leonid Pitamic, a renowned Slovenian lawyer and legal philosopher, and the first dean of the Faculty of Law in Ljubljana, aptly put it, we cannot create, distribute, or find justice if justice is not within us. A judge's commitment to society is paramount. They must have broad life experience and an open mind to understand the complexities of social dynamics. It is imperative that a judge should remain committed to supporting the independence of the judiciary as a whole, protecting it both individually and institutionally from any undue influence and control outside the purview of the law. In addition, a judge must have the unwavering integrity to rule according to his conscience and in accordance with the law, even in the face of possible internal or external pressures. Only a judge with sufficient courage can act autonomously, maintaining personal independence and resisting the influence of external factors. In this situation of the pressure, it is expected for judiciary to respond, especially in the situations when fundamental social values are at stake or when the rule of law requires support. In particular, the Supreme Court judges whose words have additional significance and impact are expected to speak out. The judiciary and the media are central and complementary institutions in democratic state governed by the rule of law. As an integral part of society, the judiciary recognizes that public criticism of the work of the courts is allowed. In a democratic society, the public is entitled to criticize the judiciary, and such criticism is seen as a legitimate means of ensuring accountability within the judiciary and of the judges themselves. It is incumbent upon the judiciary to take account of reasoned and substantiated criticism, however harsh or direct it may be. On the other hand, the judiciary must respond to unfounded, generalized, divisive, and politically motivated criticism, as well as to the respectful or inappropriate pressure. In a conclusion, I would like to emphasize that both the judiciary and the media must be independent in order to effectively serve the legal functions of the state. Only independent judges can administer justice impartially and in accordance with the law. Similarly, journalists, especially those who are trusted by the public, must operate independently to fulfill their role as watchdogs, providing an additional stronghold for the rule of law and constitutionalism, alongside the relevant institutions. Indeed, both the judiciary and the media should contribute to social order and peace, and, as stated by the Slovenian jurist Dr. Merz, to the achievement of social consensus and social cohesion. Furthermore, whether as members of these institutions or as citizens, we should strive for a just world. Our actions should be guided by the well-being of people and the impact on their lives. As Mahatma Gandhi said, there is a higher court than court of justice, and that is the court of conscience. It supersedes all other courts. Thank you for your attention. Now I will give the floor to the other speakers, to this, you will do this. To the distinguished speakers and experts from other countries. My keynote speech was more general. I expect from the other speakers to be more precise or to express their experience or the problems in their own countries. So, and because I'm the moderator, I should kindly ask them to respect the time limit of the contributions for the sake of time frame of our panel and for the smooth running of the event. So I will give the floor, just a second, to Mr. Faik Zaidan, the President of the Supreme Judicial Council of Iraq. Please, the floor is yours.
Ladies and gentlemen, good morning. Is it okay? No, I prefer here. Ladies and gentlemen, good morning. I'm sorry my English is not good and Spanish also is not good. Therefore, I will speak in Arabic and I hope we have a good interpreter. Ladies and سيدات والسادة الحضور المحترمين، صباح الخير. شكرا جزيلا للسيدات والسادة في الجمعية الحقوقية العالمية على دعوتنا للمشاركة في هذه الاحتفالية المهمة، والتي تعتبر فرصة سعيدة للقاء والتعرف على زملائنا القضاة والحقوقيين لتبادل الأفكار في المواضيع ذات الاهتمام المشترك عند الحقوقيين. وبهذه المناسبة أقدم التهنئة للقاضي السيد أنتوني كينيدي لمنحه ميدالية الشرف الممنوحة من الجمعية الحقوقية العالمية. اسمحوا لي قبل الدخول في أصل موضوع الحلقة النقاشية أن أعطيكم فكرة موجزة عن تاريخ القضاء في العراق. جميع المصادر التاريخية تذكر أن أول محكمة في التاريخ هي محكمة بوابة معبد دب لال ماخ سنة 2113 قبل الميلاد في مدينة أور جنوب العراق، حيث كانت المحاكمات تقام في المعابد لقدسية المحاكمات والوقوف في باب الآلهة، وتخصص إحدى بوابات المعبد للمحاكمات، وتحفظ نسخة من المحاكمات وتقرير عن الدعوة داخل المعبد. كذلك تشير المصادر التاريخية إلى أن أول وثيقة قانونية في التاريخ هي قانون الملك أور نمو للفترة من 2013 إلى 2096 قبل الميلاد. ثم أصدر الملك البابلي حمورابي قانون حمورابي المشهور والذي يعتبر أول قانون متكامل بين الأعوام 1750 إلى 1792 منتصف القرن السابع عشر قبل الميلاد. وبموجب هذا القانون ظهر لأول مرة مبدأ الاختصاص المكاني للمحكمة في التاريخ، ووجد نظام التقاضي، المدعي والمدعى عليه والشهود. هذه الخلفية الموجزة لتاريخ القضاء العراقي، وعبر مسيرة تاريخية طويلة لا أود شغل وقتكم بها، انتهت إلى صدور أول قانون للسلطة القضائية المستقلة تماما عن السلطتين التشريعية والتنفيذية سنة 1963 في العراق، حيث تولى رئيس محكمة التمييز التي تعتبر هي المحكمة العليا في النظام القضائي العراقي رئاسة القضاء. لكن هذا الإنجاز المهم للقضاء المستقل تعرض إلى تغيير من قبل النظام الدكتاتوري في العراق الذي سيطر على السلطة سنة 1968، حيث ألغى هذه الاستقلالية وربط القضاء إداريا بالسلطة التنفيذية بوزير العدل الذي يعتبر بطبيعة الحال هو جزء من الحكومة. لذا فقد القضاء جزء من استقلاله الإداري. وأنا شخصيا عندما كنت قاضي لإحدى المحاكم المهمة في العاصمة بغداد، قدمت بحقي أكثر من شكوى إلى رئيس الدولة، لكني نجوت بأعجوبة من إجراءات الرئيس القاسية في حينها باعتباره رئيس دكتاتوري. بعد تغيير النظام السياسي في العراق سنة 2003 تمكن القضاة من الضغط على الجهات المختصة والعودة لاستقلالية السلطة القضائية بشكل كامل عن السلطتين التشريعية والتنفيذية بموجب الدستور، وكما كان عليه الحال عام 1963، حيث تولى رئيس محكمة التمييز باعتبارها المحكمة العليا في العراق منصب رئاسة مجلس القضاء الأعلى الذي يدير القضاء في العراق بكل تفاصيله سواء من الناحية الإدارية أو القضائية، ويتمتع بميزانية مستقلة. بفضل هذه الاستقلالية التامة تمكن القضاء في العراق من فرض مبدأ سيادة القانون رغم التحديات الكثيرة التي واجهتنا في هذه المهمة. على سبيل المثال، عندما كنا نتولى محاكمة الإرهابيين من تنظيم القاعدة فقدنا 67 قاضي قتل من هذا التنظيم الإرهابي، و179 موظف من العاملين في القضاء. لكن مع ذلك حقق لنا مبدأ استقلال القضاء التام عن السلطتين التشريعية والتنفيذية حرية اتخاذ القرار في القضاء العادي أو القضاء الدستوري رغم انزعاج الكثير من الأحزاب السياسية والشخصيات النافذة من هذه القرارات. لكن بفضل استقلال القضاء الحقيقي لم نتأثر بهذه الانزعاج، واستمر القضاء في أداء مهامه في تعزيز سيادة القانون. شكرا جزيلا.
Thank you for your informative contribution. It was very interesting because we don't have a lot of experience with your country. Now I would like to give the floor to Hector Hugo Perez Aguilera, the President of the Constitutional Court of Guatemala. Please take the floor.
Buenos días a todos y a todas. Agradecemos los guatemaltecos el espacio que se nos brinda para compartirles reflexiones respecto a la importancia y la independencia judicial en el contexto político y especialmente de la independencia de los jueces de la justicia constitucional. La virtud del mundo político es el derecho constitucional y la independencia del juez constitucional es la garantía de la democracia. Para defender los principios consagrados en la Constitución de forma responsable, imparcial e independiente, proveyendo de certeza al ordenamiento político jurídico del país. Por ello, es muy importante reflexionar en torno a la independencia judicial constitucional como principio fundamental de la democracia sobre la responsabilidad que tal independencia conlleva y sobre los principios democráticos y republicanos que rigen el Estado constitucional de Derecho en nuestro país, que como jueces constitucionales estamos llamados a resguardar y a garantizar. Guatemala es un Estado libre, independiente y soberano, que se organiza para garantizar a sus habitantes el goce de sus derechos y libertades, siendo su sistema de gobierno republicano, democrático y representativo. El ordenamiento jurídico guatemalteco regula la independencia de poderes en el artículo 141 de la Constitución, indicando que la soberanía radica en el pueblo, quien la delega para su ejercicio es sus organismos legislativo, ejecutivo y judicial, siendo la subordinación entre cada uno de ellos prohibida. En esta división de poderes corresponde al organismo judicial la importancia de impartir justicia de conformidad con la Constitución y demás leyes de la República. Por su parte, el artículo 203 de la Constitución Política de la República de Guatemala sobre la independencia del organismo judicial y potestad de juzgar refiere que los magistrados y los jueces son independientes en el ejercicio de sus funciones y únicamente están sujetos a la Constitución y las leyes del país. Asimismo, se establece que la función jurisdiccional se ejerce con exclusividad absoluta por la Corte Suprema de Justicia, así como por los demás tribunales que la ley establezca, tal como la Corte de Constitucionalidad. A su vez, se norma que ninguna otra autoridad podrá intervenir en la administración de justicia y que los tribunales de justicia, en toda resolución o sentencia, deben observar obligadamente el principio de que la Constitución Política de la República de Guatemala prevalece sobre cualquier ley o tratado. Por otro lado, el artículo 268 del mismo cuerpo legal regula la función esencial de la Corte de Constitucionalidad, siendo este un tribunal permanente de jurisdicción privativa cuya función es la defensa del orden constitucional, que actúa como tribunal colegiado con independencia de los demás organismos del Estado y ejerce funciones específicas que le asignan la Constitución y la ley de la materia. Los tribunales constitucionales deben defender su independencia frente al poder político, no solo por ellos mismos, sino porque su independencia constituye un derecho fundamental de todos los ciudadanos y de la democracia. En este sentido, la justicia constitucional constituye un elemento esencial para garantizar la libertad, la división de poderes y sobre todo el respeto de los derechos fundamentales, siendo su principal objetivo defender la soberanía materializada en la Constitución, elementos básicos de una democracia. Es de hacer notar que Guatemala fue el primer país de Latinoamérica en introducir en su ordenamiento interno un tribunal constitucional. La experiencia que se tuvo en la aplicación de la justicia constitucional regulada en las constituciones de 1945 y 1965, que permitió perfeccionar la materialización de la Corte de Constitucionalidad en la Constitución Política de 1985, siendo revestida de total independencia el elemento más importante para su consolidación. Por lo que en esta última Constitución se establece como tribunal permanente, totalmente independiente y autónomo como un órgano de control constitucional. La Corte de Constitucionalidad goza de independencia funcional, administrativa y económica. También los magistrados que la rigen y que la integramos. Una vez designados, somos totalmente independientes respecto del órgano que nos designó, libres para expresar opiniones sin que sean perseguidos por ellas, inamovilidad de sus funciones, derecho de antejuicio, la facultad de inhibirse de conocer casos específicos y de emitir votos razonados. Ha sido la independencia del Tribunal Constitucional la que ha permitido el mantenimiento del orden jurídico constitucional y la democracia del país. Un ejemplo de ello fue la sentencia del 25 de mayo de 1993 por la que se declaró inconstitucional el decreto que contenía las normas temporales de gobierno que pretendía centralizar en el organismo ejecutivo a los otros dos organismos del Estado, manteniéndose el orden constitucional frente a medidas de extralimitación de poder. La Constitución es garante de la independencia judicial constitucional y de manera que pueda desempeñarse la función de forma objetiva e imparcial. Toda vez que no es objeto de la justicia la administración del poder, sino la restitución de los derechos fundamentales, dentro de ellos los civiles y políticos que le hayan sido violentados a un individuo. Considero también importante mencionar algunos compromisos asumidos internacionalmente que refuerzan el principio de independencia judicial, como lo son los principios básicos relativos a la independencia de la judicatura, adoptados por el 7º Congreso de las Naciones Unidas sobre prevención del delito y tratamiento del delincuente, celebrado en Milán en 1985, y confirmados por la Asamblea General en el mismo año. Estos principios establecen que la independencia de la judicatura será garantizada por el Estado y proclamada por la Constitución o la legislación del país, debiendo todas las instituciones gubernamentales y de otra índole respetar y acatar la independencia referida. Asimismo, establecen que los jueces debemos resolver los asuntos que conozcamos con imparcialidad, basándonos en los hechos y en la consonancia con el derecho sin restricción alguna y sin influencias alicientes, presiones, amenazas o intromisiones indebidas, sean directas o indirectas. El principio de la independencia judicial autoriza y obliga a la judicatura a garantizar que el procedimiento judicial se desarrolle conforme a derecho, así como el respeto de los derechos de las partes. De esta manera es posible indicar que uno de los principios básicos, si no fundamental, que garantiza el acuerdo y adecuado funcionamiento de la administración de justicia es el principio de independencia judicial. La Corte Interamericana de Derechos Humanos ha sostenido que uno de los objetivos principales que tiene la separación de poderes públicos es la garantía de la independencia de los jueces, siendo así que el objetivo de la protección radica en evitar que el sistema judicial se vea sometido a posibles restricciones indebidas en el ejercicio de su función por parte de entes ajenos. En consecuencia, este análisis sobre el marco normativo de la independencia judicial nos permite establecer que sin importar el contexto político que se viva, la justicia siempre debe ser impartida con total y absoluta objetividad e imparcialidad. En tal caso, Guatemala ha sido de conocimiento público los casos relacionados al proceso electoral recién celebrado, que fueron presenciados ante nuestro tribunal y presenciados por el mundo. Al respecto y para los efectos de la presente disertación, quiero manifestarles que como octava magistratura conocimos y resolvimos cada uno de los expedientes, observando en todos ellos los principios de objetividad, imparcialidad y sobre todo apego a derecho, manteniendo un mismo criterio y revistiendo de certeza jurídica la situación política del país con el fin primordial de salvaguardar el derecho de voto de cada ciudadano, así como la alternabilidad del ejercicio del poder establecida en nuestra Constitución. Como vemos, la justicia, en especial la justicia constitucional, no puede estar sujeta a ningún contexto político, pues de ser así, perdería su razón de ser, como lo es el de proteger a las personas contra las amenazas de violaciones a sus derechos. En nuestra calidad de jueces constitucionales, estamos llamados a respetar y a hacer que se respete la Constitución Política de la República de Guatemala y como tales continuaremos velando porque cada acción de la que tengamos conocimiento se ajuste a los cánones establecidos en nuestro ordenamiento jurídico a efecto de continuar preservando el orden constitucional. A manera de conclusión, es posible decirles que la independencia judicial es un pilar básico de toda democracia y sobre todo un derecho fundamental de las y los ciudadanos. Agradezco a cada uno por la atención brindada y ha sido un verdadero gusto poder compartir con ustedes este pequeño mensaje y un especial mensaje del pueblo guatemalteco y agradecimiento a todo el mundo por esa atención que tuvieron en estas últimas elecciones, de donde podemos decir salimos triunfantes y hubo alternabilidad en el poder. Y recientemente estuvo en Madrid nuestro presidente de la Constitución Política de la República de Guatemala, el señor Bernardo Arévalo, haciendo los acercamientos necesarios para velar porque nuestro país prospere y siga prosperando, aunado con los apoyos internacionales que lógicamente también necesitamos. Muchísimas gracias y que Dios los bendiga.
Thanks for a very substantiated contribution. Now I should excuse a little bit because I made one little omission and I would like to fix it. I would like, as a moderator probably is expected, to introduce a little bit the speakers, so I will do it now. The first speaker, Mr. Faik Zidane, is the president of the Supreme Judicial Council and also chief of the Federal Court of Cassation. He got the PhD on general law, which I found very important, with doctoral thesis on control of the constitutional judiciary on the constitutional limits among authorities. So it's very reliable and important speaker. The second speaker, Mr. Hector Hugo Perez Aguilera, he is presiding magistrate of the Court of the Constitutionality from 23 to 24, and also titular magistrate of the Court of Constitutionality elected by the Higher University Council of the University of San Carlos de Guatemala for the period 2021 to 2026. He graduated from the Universidad de San Carlos de Guatemala and got the PhD from the Universidad Autónoma de Barcelona, Spain. So I will turn on to the next speaker. The next speaker is Madame Holta Zacai, the president of the Constitutional Court of Albania. She got the scientific master's degree in securities and financial regulations at Georgetown University in the United States within the Fulbright program. At the moment, he is expert for human rights, children's rights, family law, banking law, and securities. A little strange combination, but anyway, promising. And I would like to give the floor to her, please.
Thank you. It is a little bit strange to hear about your CV in a certain way, but it's a little bit complicated. I started as a human rights activist and then as a lawyer, and then I moved to banking and securities because I thought that I should provide also for my family. The passion for human rights didn't pay much. Now is the great combination of all my experiences at the Constitutional Court. So anyway, I decided to speak seated because I think this will be a conversation. I mean, the principle of rule of law and independence of judiciary, it's not a novelty. We share, I guess these are the principles of universal value that we share basically among each other, no matter what language we do speak. However, coming from a country that was once part of the Eastern European bloc, probably I would highlight some historical facts and some challenges that are very peculiar, but nevertheless, they share the same importance in terms of achieving when we can. So going back to, having said that, we started at 1991. We didn't have the constitution. So we had the constitution before, but we didn't have the constitution until 1998. So for this period after the fall of totalitarian regime, we just have constitutional dispositions. However, at that time, the Constitutional Court was still the final interpreter of those terms, of those dispositions. And because of the fragility of democracy status in the country, the Constitutional Court tried and elaborated jurisprudence that basically interpreted these norms. Based on a very important principle that we had at the time in these dispositions, which was the Republic of Albania is a legal and democratic state. That's all we had. However, the court interpreted matters related to freedom of organization of political parties, superiority and binding nature of constitutional court decisions, organization and functioning of judicial power, conflicts of competencies between organs of public power, role of lawyers in democracy, right to private property as one of the main important issues that follow the transition period, right to fair trial. However, we have to say that the court failed to elaborate and define in a comprehensive manner the elements and indicators that determine the measuring level of respect of rule of law principle at that time. The Albanian Constitution of 1998, the one that we have now, provided among other principles that the law constitutes the basis and boundaries of the state's activity. During almost 30-year experience and history, Constitutional Court has influenced to a great extent the development of democracy by elaborating this notion in abstract control, and I would quote two very important rulings that we had from the court, stating that the rule of law principle implies ruling of law and avoidance of arbitrariness in order to respect and guarantee the human dignity, justice, and legal certainty. And another one, which are the main paramount decisions we have, is that the rule of law, being one of the basic principles in a democratic society, constitutes an independent constitutional norm. Therefore, its violation is sufficient basis for repealing a law on unconstitutional grounds. However, when it comes to individual complaints review, the court has been referred to the principle of rule of law, also when examining, underlying that everyone's right to fair trial before an independent and impartial court established by the law derives and originates from the principle of rule of law. This right, the fair trial, should not be restricted artificially, and its implementation should not be impeded unreasonably. The individual's rights against the unlawful actions of other individuals or state institutions should not be protected only formally. Such protection should be a meaningful and effective one in reality. In this view, the constitutional jurisprudence has elaborated also the principle of separation and balancing of powers, adoption of laws in conformity with the Constitution, respecting of hierarchy of norms, activity of executive bodies based only on laws, guaranteeing of fundamental rights and freedoms, continuity and consistency of constitutional jurisprudence, principle of legal certainty, which is also the one that is most elaborated in individual complaints. I'm sure in many countries is. Within that principle, the legal certainty, the court has elaborated these elements. accuracy, clarity, and stability of the legal order, protection of legal expectation and non-violation of acquired rights, obligation to enforce final court decisions, avoidance of legal gaps, vacuums, prohibiting the application of retroactive laws except for the favorable criminal law, etc. In this regard, for the principle of separation and balancing of powers, the court has emphasized that three central powers should be exercised not only independently, but also in a balanced way. This is achieved by means of constitutional solutions that guarantee mutual control and a certain degree of balance between the powers without infringing or interfering with each other's competencies. Although these powers are separated in terms of functional autonomy and independence, in the exercise of duties assigned by Constitution, they are balanced by respecting, encouraging, supporting, and controlling each other. Independence of judicial power. This is one principle that the court has paid special attention as one of the main pillars of the rule of law. The court has elaborated as principles the fact that the court have exclusive right to render justice, and no other state institution or public official can exercise this function. It is this very function that actually determines not only the position of judiciary within the system of state power institution, but also the status of the judges themselves. Article 145 of the Constitution has provided that judges are independent and subject only to the Constitution and laws. And in line with the constitutional provision, interference in the activity of court and judges is prohibited. In the court's jurisprudence, the independence of judiciary is understood as substantial independence, which means the freedom of courts to render justice and decisions which are not based on the interest of any other branch of power. Structural independence, which is related to the way an institution is established or composed. Organizational independence, which includes the internal administrative structure of the courts. Financial independence, which implies autonomy in drafting its own budget and approval by Parliament, having adequate and sufficient funds to achieve its mission and its duties. And personal independence, which requires appointment of judges based on objective criteria, immunity, economic guarantees, career guarantees, the transfer and disciplinary system in place, all and equal for everybody. The court has considered also a number of cases pretending the violation of judiciary independence, such as the transfer of judges, exams of judges, salary of court clerks, salary of judges and prosecutors, organizational rules and authority of judicial conference and high judicial council, judges' leaves, authorities of court chancellors, administration of judicial power, criteria for the selection and appointment of the Supreme Court judges, etc. In addition, the independence and impartiality of judges and prosecutors in the context of fair trial is not a privilege, it's a duty. While impartiality refers to the judge's attitude in relation to the cases and parties involved in the process, independence implies not only a certain attitude towards the exercise of judicial function, but also a certain position or relationship with the other powers, especially the executive branch of power, that does not allow for interference. In this perspective, the court has elaborated the term independent considering the way the judges are appointed and their mandate's term. The guarantee of the term of office and unchangeability of that mandate is paramount in protection of the judge from the influence of political forces. Probably you have heard about the justice reform in Albania. I think it's, at least in the region, is a very well-known process. So although I mentioned so many principles that have been elaborated by the Constitutional Court, however, Albania suffered from it was impossible to ensure independence, full independence of judiciary because of two main elements. The constitutional formula for the election of judges, composition and organization of self-governing bodies of judicial power, and the level of corruption in the country. Such situation required urgent and radical measures. In 2016, Albania adopted a justice reform package that aimed to guarantee the rule of law, independence of the justice system, as well as to restore the public faith in justice system institutions. But too much independence, you know, it's not always good, or too much independence still needs control. So that was the whole concept of the justice reform. In that perspective, new constitutional formula were approved both for the composition of self-governing bodies of judges and prosecutors, as well as on the procedure for selection and appointment of judges, aiming to detaching this process as much as possible from political actors, trying to ensure a transparent process based only on the candidate's merits. The new constitutional amendments provided also for re-evaluation of all current judges and prosecutors, included judges of Constitutional Court, which the process which was comprised the evaluation of assets, personal integrity, and proficiency. It should be stressed that this process was not an easy one. It led to a substantial reduction of judges and prosecutors, which caused delays in the court proceedings. The Constitutional Court itself was unable to render decision due to the lack of necessary legal quorum for almost 3 years. You can imagine what happens to a country without a Constitutional Court. I would like not to comment on it, but it's something that everybody can imagine. So many laws were passed, and no constitutional review was possible at that time. However, we have a fully formed bench now, and all the judges are selected and elected based on the new formulas. I would like to point out one last topic, which is the Rule of Law Index. Referring to the index of World Justice Project for 2023, Rule of Law in Albania is ranked on the 91st among 140 countries, which is 2-level decrease actually as compared to the previous index. So although all these achievements and all these, let's say, efforts, we still don't see progress. Well, I was curious to see the indicators for such ranking, and I saw inter alia that there was also a limitation of public power by the judiciary, measures, quoting, measures whether the legislative bodies have the independence and the ability in practice to exercise effective checks on and oversights of government. It was like pointing the finger, actually, to the Constitutional Court. And with many of you I've met also previously, we're facing a phenomenon in Albania, which is really the judicialization of politics. All the laws, almost all the laws, are brought to the Constitutional Court for constitutional review. And probably that was also part of this indicator when they tried to rank us 2 levels below. However, I hope that that we can improve it and make it better. But probably the number itself showed it was considered within this indicator. Anyway, I don't want to go longer. I hope I'm within, so I know. I just want to finish by saying that the rule of law is one of the fundamental principles. It is actually the very cornerstone of justice, providing opportunities that support social peace, governance, and respect for fundamental rights. Nevertheless, the rule of law will always be evolving as long as the public powers, individuals, and civil society interact and promote the development of its dimensions. Thank you.
Thank you for your very detailed contribution. It was interesting, and because we are also from the region, it was interesting to hear the experience of the other country. So we are in the middle somewhere. We have 3 speakers more and half an hour, so I will give the floor to Mr. John Perez Brignani, Magistrate of the Supreme Court of Justice from Uruguay. He is Doctor in Law and Social Sciences, representative of the Judicial Branch in the Advisory Council of Electronic Certification Unit, and also of the Regulatory and Personal Data Control Unit. He has qualifications on human rights, freedom of expression, and protection of journalists. So the floor is yours, please.
Muy buenos días. Es para mí un honor participar en este homenaje al ex juez de la Suprema Corte de Estados Unidos, el doctor Anthony Kennedy. Sobre la independencia del Poder Judicial. Sin un Poder Judicial independiente, realmente no puede hablarse de que hay Estado de Derecho, ni menos aún democracia. El Poder Judicial debe ser totalmente independiente, no solo de cualquier poder político, sino también debe darse la independencia económica que generalmente carece en casi todos los países. En mi país, por ejemplo, independencia económica no existe, dependemos del Poder Ejecutivo y del Poder Legislativo, y generalmente la escasez de recursos es amplia. Ahora, la justicia, para que sea una justicia realmente efectiva, debe empezarse por el proceso de selección del juez y los procesos de calificación de esas, para que entren los mejores, no solo que entren los mejores, sino que se capacite con una mentalidad que puede ir evolucionando entre la jurisprudencia. Si una jurisprudencia que no avance con las medidas que van tomando las tecnologías y todo, no vamos a tener realmente una justicia. El juez es independiente de todo poder, pero debe también una responsabilidad, porque tiene que ser un juez que ejerza su ministerio con ecuanimidad y dentro del ámbito de la ley. Debe tener como norte que lo principal de la prestación del servicio de justicia es la persona. A su vez, el servicio de justicia debe ser absolutamente transparente, porque la transparencia es lo que le va a dar legitimidad. Se advierte muchas veces que el poder es cuestionada la legitimidad a veces del Poder Judicial, porque realmente no se comprende o no se difunde realmente la tarea que realmente cumplimos. El Poder Judicial tiene una amplia esfera de actuación que no se ve y que tiene sumamente importancia. Por ejemplo, por un Poder Judicial independiente operan hasta calificadoras de riesgo y le dan préstamos a los países. Eso, sin embargo, no es visto cuando se le dan los recursos al Poder Judicial. Es importante también, en mi país no existe Tribunal Constitucional, nosotros tenemos todas las funciones. Es importante también que los jueces de primera instancia, de tribunales, cada vez se abran más la mente a aplicar los puntos constitucionales, las normas constitucionales a los casos concretos. Lo ideal es proteger, la función del Poder Judicial es proteger a la persona. Es la última barrera contra el avasallamiento de los restantes poderes del Estado. A su vez, opera como un contrapeso de los restantes poderes, y para ello debe operarlo con ecuanimidad sobre todas las cosas. Bueno, muchísimas gracias.
Thank you for your contribution. Now the floor is on Margareta Manowska, as I can recall correctly, the first president of the Supreme Court of Poland, adjudicating in the civil chamber with PhD in legal science at the Institute of Civil Law at the University of Warsaw. So please.
Dear colleagues, time is running. And to begin, let me express my thanks for the invitation to this conference and the opportunity to address you. The topic of this panel is independence of the judiciary and the rule of law. Contrary to what it might seem, this topic is certainly not easy. When assessing the status of the rule of law, two aspects should be taken into consideration. The first one refers to lawmaking. For the concept of the rule of law to be assessed, it is important to know what kind of law is being enacted. We know many examples from the past when laws violated human rights or even led to the discrimination or extermination of certain social groups. Therefore, in assessing the status of the rule of law, it's vital to know what kind of law will be enacted and then observed. This in turn leads us to the question, who is entitled to claim that the enacted law is unjust? In cardinal matters, of course, modern legal systems have mechanisms for assessing the constitutionality of specific provisions of law. What raises doubts, however, is the assessment of the quality of the law with reference to more common issues of lesser importance. The second aspect of the assessing the status of the rule of law is how the law is applied by courts. I am the judge. Taking into account that courts exercise a review of administrative decisions, all cases may ultimately end up in court anyway. The courts are also responsible for imposing ultimate understanding of the law. Justice Oliver Holmes once said that the law is what the courts say it is, and his words remain relevant today. His remark, although formulated with reference to common law, is also somewhat applicable to countries with statutory law. The courts are categorized as the third branch of government by virtue of their function of final adjudication of disputes and their function of reviewing administrative decisions. The authority, of course, has a clear advantage over the executive branch and even the legislature. Although the courts do not review the work of the parliament, it is up to the courts to decide about the content of the legal norms that are ultimately applied. Undisputable, the judiciary, which engages in the administration of justice and has a controlling function over public authorities, should be endowed with the attribute of independence. The ensures that the law will be applied in a way that is free from pressure and undue influence from other authorities. On the other hand, however, a total lack of control over judges creates the risk that the rule of law may turn into the rule through law or even the terror of law, with the third branch of government turning into judiciocracy. This was pointed out as early as 1787 by a writer nicknamed Brutus in America, who said that the lack of constitutional control over the judiciary would turn the Supreme Court into a tyrant and oligarch, thus overwhelming the other branches and distorting the tripartite balance of powers. With such a position of the judiciary, judges may turn more towards power than law when making their decisions. In other words, they will be more interested in exercising power than in adjudicating cases. They will become Caesars. Brutus asked, "Isn't it the same case that judges in their long robes have the same thirst for power as congressmen in their long coats?" The issue at stake is not about judges violating the law, but about manipulating the law. Indeed, before a court applies the law, it must first interpret it for instance, carry out a thinking process to clarify the content and meaning of a particular legal provision. The interpretation should be consistent with the spirit of the legal norm. Sometimes, however, excessive judicial activism distorts the sense of the legal norm, giving it, in fact, a completely different meaning. In Poland, legal scholars developed the concept of a rational and lawful judicial decision that has been accepted for a long time and plays a fundamental role in judicial practice. Jerzy Wróblewski, the author of this concept, emphasized that interpretative restraint in the sphere of public law implemented through the primacy of linguistic interpretation is the best guarantee of the rule of law. Wróblewski's concept claimed as an objection to the practice pursued by part of the Polish judiciary during communist rule, when functional interpretation was abused and courts invoked vague phrases or even communist axiology in their rulings. There were well-known cases when citizens were expropriated without adequate compensation so that the communist government in Poland could make investments. There were also cases of judicial crimes during the communist period, primarily during the martial law of 1981 to 1983. As we know, times have changed, and fortunately, communism has become a thing of the past in Europe. Does this mean that Wróblewski's theory is also a relic of the past? Well, of course it's not. Modern times have brought risks that make this concept continuously relevant for three main reasons. Firstly, rapid social change, development of the civilization and the needs of commerce have triggered a crisis in the formula of statutory law, which has now kept pace with these developments. This in turn means that the functional interpretation plays an important role in the application of the law, and this can sometimes lead to the degeneration of the legal norm being interpreted. Secondly, contrary to what it might seem, in addition to its undoubted benefits democracy poses, certain risks related to the sense of universal freedom. The right to freedom of expression should be seen as a basic human right. However, I personally follow the so-called old school of judging, which promotes the idea that this right must be limited when it comes to judges. A judge should not speak out in the mass media, even on important social issues. A judge should not reveal his or her political preferences or views. Indeed, a judge speaks through judgments and their reasons. In order for the rule of law to be preserved when the law is being applied, it is important for the judge to believe that they respect the law, including the citizens' right to a court, and above all, to know that they are perceived by citizens as impartial. The third reason why the rule of law may be under threat in the process of the applying the law is the influence of the media and the community, sometimes even turning into pressure. Personally, I have been a judge for 30 years, and I have witnessed this phenomenon, which has unfortunately intensified recently. The common thinking is, the majority is right, and if you think otherwise, you will be criticized and stigmatized. This phenomenon encourages judges to interpret a legal norm in a way that remains within the mainstream of commonly held views and attitudes. Indeed, to stand up against this phenomenon, a judge must show a great deal of mental toughness. But on the other hand, democracy and the rule of law cannot restrict people's right to have their own opinion and to express it without fear. In the case of judges, this is achieved through their rulings. In conclusion, let me say that in my view, the challenge for the rule of law in modern democracies lies in maintaining a mutual balance of competences among the different branches of government. This applies equally to the courts, which rule on the basis of the law and within the limits of the law without imposing a particular vision of reality through law. In the case of the courts, however, we face the eternal dilemma: who will judge the judge? The idea, however, is not to have an authority that would exercise some kind of superpower over the three branches of government. Instead, it is about promoting the idea that judges should assume an attitude of restraint in their interpretation of the law, in their statement, and their influence in the community. I believe that the rule of law can be maintained not through institutional influence, but through the social sciences, such as sociology, pedagogy, or psychology, and through shaping the right attitudes. Thank you for your attention.
Thank you for interesting contribution. With one remark. From my point of view, the judiciary is not the third branch of power, but one of the three equal and equivalent branches of power. And the other remark is, the difference is we are the judicial professional, but not political powers. But we are also one of the powers. Thank you. And the last speaker who joined us recently, is Mr. Adrian Vasquez Lazara, the chairman of the Committee on Legal Affairs of the European Parliament. So I will kindly ask him to join us. No, he is not here? He is not here. Okay, then my mistake. So I would like to thank all the speakers, the distinguished guests, for their valuable contributions, and also to the audience for the attention. But we are not yet out of time, so we have some time for the comments or the questions. So please, now the floor is yours. It's also, if some of the speakers wants to comment or to add something, now it's the time. Only 5 minutes. No? Okay.
I just want to thank you, everybody, for your contributions, and I think we need to make a break in order to start the new panel at 11:30. But I would like to make a question for you, particularly, and also for you in Iraq and Poland. So, first thing is, international opinion is not always probably well informed, and sometimes we hear doubts about the independence of the judiciary, both in Poland and Iraq. And I would like to, what could you tell us about, for example, some scenarios where you showed independence regarding the legislative or the judicative. So it's something where you could explain that you were controlling the powers, either executive or judiciary. And the same for you, not with Tusk. Tusk is, but with the former government, where can we see these events of independence? Thank you.
شكرا جزيلا. الحقيقة استقلال القضاء في العراق احنا نعتقد انه استقلال حقيقي عن السلطتين التشريعية والتنفيذية، وهذه الاستقلالية كانت واضحة بشكل خاص بعد 2003 في كل الأزمات السياسية اللي شهدها البلد على أثر الانتخابات التي أجريت. على سبيل المثال مؤخرا كان هناك صراع كبير جدا بين القوى السياسية على من هي الجهة التي لها حق تشكيل حكومة على سبيل المثال، فكان القضاء الدستوري موقف شجاع وأصدر قرارات لم تعجب الكثير من القوى السياسية، لكن بالنتيجة هي قرارات نافذة كان لها دور مهم في تشكيل الحكومة الحالية. كذلك كان أحد الأقاليم أو الإقليم هو الوحيد الموجود في العراق، إقليم كردستان، يصدر النفط بدون موافقة الحكومة المركزية. القضاء الدستوري أصدر قرار وأبطل جميع هذه العقود وألزم حكومة إقليم كردستان في شمال العراق بأن يتم تصدير النفط من خلال الحكومة المركزية، وهذا أيضا أزعج الكثير. قبل حوالي شهرين أثيرت عدد من الاتهامات على رئيس البرلمان العراقي مثلا، والقضاء العراقي القضاء الدستوري أقصد أصدر قرار بعدم أهلية رئيس البرلمان أن يبقى بمنصبه رئيس البرلمان العراقي، وألزم البرلمان العراقي على انتخاب رئيس جديد للبرلمان. هذا دليل على قوة واستقلالية القضاء بصرف النظر عن رأي السلطتين التشريعية والتنفيذية. شكرا جزيلا.
Jako sędziemu nie wolno wdawać się w dysputy polityczne, nie będę więc oceniać działalności rządu ani tego, ani poprzedniego.
As a judge, I cannot be politically involved and I cannot say any political opinion about the former government, neither the present government in Poland.
Historia wskazuje, że rządy się zmieniają, a sędziowie powinni być niezawiśli i niezależni zawsze.
The history shows us that the governments are changing and the judges should always be independent.
Niezależność i niezawisłość wyrażają sędziowie w Polsce za pomocą oczywiście swoich orzeczeń i ich uzasadnień.
Their independence of judges in Poland is shown in their rulings and the reasoning of the rulings.
I oczywiście pojawiają się różne opinie na temat praworządności w Polsce, w szczególności jak chodzi o postępowania dyscyplinarne przeciwko sędziom.
And there are some opinions about rule of law in Poland, especially concerning the disciplinary proceedings on judges in Poland.
Jak obejrzałam statystykę postępowań dyscyplinarnych i takich postępowań, które mogłyby być uznane za motywowane politycznie, były 3 i skończyły się niczym, czyli nie dotknęły sędziów.
When I reviewed the statistics of those proceedings, disciplinary proceedings, there were 3 of them which one could only 3 of them which one could perhaps say that it was politically motivated, but the 3 of them, all 3 of them ended without any consequence for a judge.
Sędziowie w Polsce od 1989 roku mają przez cały czas pełnię niepodległości, niezależności, a najlepszym przykładem jest to, że słychać ich na świecie i w Europie bardzo głośno. Dziękuję.
Since 1988, Polish judges has total liberty And the best example of that is that Polish judges are perfectly heard, their voices are perfectly heard all over the Europe. Thank you very much.
We can conclude. Thanks once more.
Thank you for that extraordinary panel. We don't often have the opportunity to hear such distinguished jurists from around the world on such an important topic. Before we take a very short break, allow me to also take a moment to thank those who have collaborated with us for this event. They are listed at the far side there: Madrid Vivo Foundation, Unir Online University, Lynn and Alexa Rogers, AmCham Spain, Kia Motors Spain, the Muslim World League, and Latin America Invest. We will now take a short break. The facilities are out the back door and to your right, and we will ask you to return, please, in 7 minutes at 11:30. Thank you so much. Is no longer than 7 minutes, she says kindly, so that your wonderful moderator does not have to interrupt your remarks. So I am delighted to welcome Victor Aleo, trustee of the World Law Foundation, president of the Mexican Bar Association, and our panelists who have joined us on stage: Diego Aria, former president of the UN Security Council; Dina Josefina Ochoa Escriba, Justice of the Constitutional Court of Guatemala; Gresa Kaka Nemani, President of the Constitutional Court of Kosovo; Kaori Matsumoto, member of the World Jurist Association; Rainier Arnold, professor at the University of Regensburg; and Ricardo Rios Ferrer, President of the National Council of Mexican Lawyers. Welcome to you all, and I give you the podium, sir.
Hi, good day for all. We have a great panel, great speakers, and I just want to thank, first of all, Javier Cremades from the World Jurist Association, president of it. Javier, thank you for the invitation, as always, and also for the World Law Foundation, and obviously from the panelists. We have a great panel and a very interesting subject like freedom of speech, democracy, and rule of law. So the panelists were presented, and I would like to start making a keynote speak about this subject. I will do it in Spanish because we have a lot of Spanish-speaking panelists, and I think it would be better. De inicio, es pertinente dejar plasmada la importancia de este tema que nos ocupa, sobre la libertad de expresión, que sin duda es un derecho fundamental. Constituye un presupuesto indispensable para la protección de otros derechos fundamentales y para el funcionamiento de la democracia en conjunto. En efecto, mientras la dimensión individual consiste en el derecho que le asiste a toda persona para buscar, recibir y difundir informaciones e ideas de cualquier índole y a través de cualquier medio, su dimensión social consiste en el derecho colectivo que le asiste a la sociedad en su conjunto a tener acceso a la información y las ideas de otras personas. Si, por ejemplo, un periodista no puede hacer una publicación, la afectación alcanza a la sociedad entera que queda privada de conocerlo. Teniendo en cuenta lo anterior, la Comisión Interamericana de Derechos Humanos ha reconocido que aun cuando toda persona ya sea natural o jurídica, tiene derecho a la libertad de expresión, el ejercicio de ese derecho por parte de periodistas y medios de comunicación, la llamada libertad de prensa, reviste particular importancia y goza por ello de una protección especialmente reforzada. En otras palabras, a los periodistas y a los medios de comunicación les corresponde una función esencial para el funcionamiento de la democracia, que es mantener informada a la ciudadanía y promover la discusión sobre asuntos de interés general y de controlar la manifestación primaria y principal, que es la libertad de expresión. A su vez, dicha Comisión Interamericana ha considerado que las sanciones penales respecto a cualquier expresión de interés público resultan contrarias a la convención correspondiente y ha sostenido además que las condenas civiles en estos mismos supuestos solo son procedentes cuando la persona cuya expresión es objeto de juicio haya emitido una información falsa que produjo un daño ilícito, sabiendo que la información era falsa o con manifiesta negligencia en la búsqueda de la verdad. Finalmente, las autoridades judiciales en Latinoamérica han reconocido que el derecho a la información pública está debidamente resguardado y en ese sentido todos los habitantes de la región tenemos derecho a solicitar y acceder en forma oportuna, completa y fidedigna a la información que repose en los archivos en poder del Estado. Sin embargo, tengo que referirme desde luego a mi país, en el que hay que reconocer el deterioro constante en las condiciones de trabajo de los periodistas e informadores, lo que ha despertado inclusive la atención internacional. La situación de los comunicadores debe comprenderse a la luz de la impunidad y la falta de confianza en las instituciones de seguridad y justicia prevalecientes. El reciente diagnóstico del World Jurist Justice Project, sobre el Estado de Derecho en México sitúa a mi país en uno de los lugares más bajos del mundo en su índice global. Periodistas e informadores laboran en condiciones difíciles y precarias. Los datos de dicha encuesta lo señalan con elocuencia. Un número alarmante de los entrevistados opinó que la censura se ejerce desde el interior de los medios de comunicación y un número casi equivalente opina que también se ejerce por elementos o agentes externos. No sorprende entonces que por séptimo año consecutivo se nos califique como un país no libre en materia de libertad de expresión. El periodismo en México se ha convertido en blanco de los grupos de poder y para las mismas empresas de comunicación. La libertad de expresión es un derecho cuya importancia radica en la democracia, en el derecho a estar informado, en conocer la realidad de los hechos y sobre todo en la libertad de ejercer una profesión indispensable para el crecimiento de una sociedad en democracia. Tenemos últimamente pruebas de una gran presión hacia los periodistas independientes. Los intimidan a ellos y a sus patrones. A otros los someten a demandas judiciales y a los demás simplemente los matan. Esa es nuestra realidad lamentable y de ahí que nos motiven este tipo de eventos tan relevantes y sobre todo con expertos de la talla de las que integran este panel. Termino planteando la idea de que la libertad de expresión es el pilar básico de la democracia, pero también esencialmente del Estado de Derecho, que debe prevalecer en todo el mundo y que precisamente es una de las tareas fundamentales de la World Jurist Association. Muchas gracias. So we can continue with the panel. First of all, Diego Arria, he's from Venezuela, and he was president of the UN Security Council in 1992. Dear Diego, desde tu experiencia internacional en esta y otras materias que son de todos conocidos, nos permitirá abrevar ahorita tus comentarios al respecto de tus conocimientos sobre el particular. ¿Nos podrías dar tu opinión general de tan atrayente y complejo tema sobre la libertad de expresión y sus consecuencias en relación a la democracia y al Estado de Derecho?
¿Tú quieres que en lugar de mi charla te conteste esto?
No, lo que tú quieras.
No,
lo que tú quieras. ¿Quieres pasar o quieres hacerlo desde tu...?
Yo prefiero pasar.
Pues, adelante. Te ayudo.
Gracias. Espero no tener los papeles en la mano.
Sí, muy bien, muy bien.
Well, I was asked two things. One, to speak in English. And the second one, not to speak more than 6 minutes. I will speak 5.5 minutes to make sure I wrote my points in order that I don't get too enthusiastic. And I will try also to answer Arturo's question at the end. You know, there's an old saying that the diplomats think twice before saying nothing. I'll do my best to do the contrary. We all know in this audience that the existence of the pillars of freedom of speech, rule of law, are fundamental to have democracy, but they must coexist simultaneously. The rule of law, el imperio de la ley, for most of you in general, is a matter of debating its abuses, its distortions, but not about the real collapse of the countries. I know you have very valid concerns regarding freedom of expression. I think Arturo was extremely candid and sincere, precisely bringing that point, and I will make also some comments. In dreadful contrast, the absence of these pillars are a matter of survival for millions of people in Cuba, Nicaragua, and in my own country, in Venezuela. They are not of simple academic interest to us. They are not a threat. They are a monstrous reality, a very painful one. To give you an idea, in the last 10 years, 8 million of my people have, which is 1/4 of the Venezuelan population, have to flee the country. Actually, not Venezuela, to flee from a narco-military dictatorship called Maduro. This is the greatest exodus in the history of the Western Hemisphere. This month is my 10th year since I was given an order of arrest by the dictatorship. I had to pay the price. I denounced Chavez before the International Criminal Court, and the price was the confiscation of my property and an order of arrest. This narco-military dictatorship turned one of the wealthiest countries in the world into a monstrous human catastrophe. And the people are the victims precisely of the absence of the rule of law, of the freedom of speech, and of course, of democracy. Even in a country like Mexico, the most important in the region, our very distinguished moderator, I read, he said once, he quoted Magistrate Cosio, that a country that doesn't have independence of the judicial system ceases to exist. But then Victor added something. He said, and that should be not only a matter of concern for the lawyers, this should be a matter of concern for the whole society in general. And that's one of the reasons that I feel so privileged, Victor, to be here today. With so many prominent people here present, I cannot pass the opportunity to say a few words on the state of rule of law in my country. Last Friday, actually at 3 o'clock, March the 1st, the Appeals Chamber of the International Criminal Court at The Hague approved a crucial step in the fight against impunity, denying the Venezuelan regime's appeal against the trial, allowing to continue investigations into the crimes of against humanity committed by the dictatorship of Maduro. And, very important, his chain of command. The dictator and his accomplices now face the court chief prosecutor, who has been interviewing for years the crimes against humanity, arbitrary detention, torture, rape, sexual violence, and persecution committed by civilian authorities, by police members, the armed forces, and pro-government individuals. During this long judicial process, Javier Cremades' personal commitment, generosity, and support has become another pillar to the rescue of our freedom. Querido Javier, we are indebted to you. Estamos en deuda contigo. Muchas gracias. To conclude, so many political events have been happening all over the world that we may have forgotten the meeting between Xi Jinping and Vladimir Putin in February 2022, when they signed an agreement, which I would like to quote something of that agreement that in a way relates to your question, Arturo. Democracy is a universal human value, Putin and Jinping says. There is no one-size-fits-all template to guide countries and establish democracy. Russia and China, they say, as world powers with rich cultural and historical heritage, have long-standing traditions of democracy, which rely on 1,000 years of experience. Russia and China, as world powers with this experience, believe that the universal nature of human rights and its protection is a shared responsibility of the international community. Translation of this agreement. Pay attention. We will act according to our own policies, as well as by the United Nations Security Council, where we have veto power. As a former member of that institution, I saw as a witness how well they abuse this privilege. Queridos amigos, there is a lot of food for thought in the public agreement between Xi Jinping and Putin and his junior partner, Vladimir Putin. In fact, a banquet. Thank you.
Thank you for your words, dear Diego. Then we have Dina Josefina Ochoa. Una pregunta a reserva de lo que tú tengas preparado sobre el tema, obviamente. ¿Cómo percibes a la libertad de expresión desde la óptica de una prestigiada ministra de la Corte Constitucional de nuestro país hermano Guatemala?
Muy bien. ¿Puedo pasar?
Sí, claro.
Lo haré con cronómetro. Contestaré tu pregunta al final de mi exposición. Muchísimas gracias, buenos días a todos y a todas. especialmente a la Asociación Mundial de Juristas. Muchísimas gracias, Javier, muchísimas gracias a todos los que están permitiendo que nuestro país, y especialmente yo como mujer y como magistrada de la Corte de Constitucionalidad de Guatemala, pueda participar. Básicamente el panel se trata sobre democracia, Estado de Derecho y libre expresión. Yo quisiera hablar y enfatizar sobre que todos y todas compartimos sueños, retos y especialmente una visión de la democracia. Esta democracia pues fue acuñada hace muchísimos años por los atenienses para implantar precisamente un estado de gobierno en donde las decisiones eran tomadas únicamente por los ciudadanos hombres, donde las mujeres y los esclavos no eran parte de esa ciudadanía, y mucho menos el derecho a expresarse. Esta historia ha venido teniendo cambios sustanciales, transfigurándose lentamente por las propias mujeres, luchando por una de las manifestaciones más severas, como es la discriminación, construida precisamente por prejuicios y estereotipos irracionales que se han instalado dentro de la cultura, dentro de actitudes y comportamientos en donde se ha obstaculizado nuestro desarrollo. Por ello, los derechos humanos han sido determinantes para garantizar los derechos fundamentales por medio de instrumentos internacionales en donde ha sido enfático esa prohibición y esa erradicación de la discriminación. La historia evidencia que las propias mujeres hemos tenido que construir nuestra ciudadanía del siglo XIX, llamado el siglo de la libertad en la lucha por los derechos civiles y políticos, surgiendo un nuevo tiempo en los derechos humanos y el derecho. Precisamente la declaración, quiero hacer énfasis aquí, la Declaración de los Derechos del Hombre y del Ciudadano es un referente de la exclusión a la vida democrática de las mujeres. Y por ello recordamos a Olympia Wobosz, que fue una precursora del feminismo y que fue guillotinada precisamente por proponer la Declaración de los Derechos de la Mujer y la Ciudadana. Con lo cual se reafirma que en esos espacios públicos únicamente les pertenecen a los hombres y que las mujeres no debemos de alzar la voz. En la historia, las sufragistas, en un antecedente importante en el movimiento por esa ciudadanía, por esa democracia y por esa expresión, exigieron la participación de la educación, especialmente que tuvo impacto en la región americana. Y en particular en Guatemala, quien en ese contexto ha tenido cambios políticos, propuso en 1821, el Día de la Independencia, el voto universal únicamente de los hombres. En 1829, el voto de los hombres igualmente, que tenían 23 años, y los analfabetos hombres con voto público. Hasta en 1965 se lograron cambios trascendentales para que las mujeres pudieran tener esa participación. En la década de los 40 y de los 50 del siglo recién pasado, se inició a reconocer ese derecho de esa ciudadanía a través de la constante y persistente lucha de esas mujeres por expresar la importancia de esa votación, lográndose hasta en 1945 el voto de las mujeres únicamente alfabetas. 20 años después, en el 1965, se logró el voto universal para hombres y mujeres. Estos avances han sido pues posibles gracias a los derechos humanos internacionales, en donde se ha ratificado la Convención sobre los Derechos Políticos de la Mujer en 1959, que permitió cambios en nuestra normativa nacional. Este recorrido en el tiempo de las mujeres, en el fortalecimiento de la democracia, esto es reciente. Sin embargo, se ha trabajado de forma persistente en cambios al sistema legal guatemalteco para gozar precisamente de esa ciudadanía plena a través de la ratificación de la Convención sobre la eliminación de todas las formas de discriminación en contra de la mujer. Este instrumento ha sido un instrumento rector de estos cambios hacia organizaciones de mujeres activistas, la academia, que ha logrado avances de reformas y que hicieron la lucha para el cambio de la legislación civil, en donde se concebía a las mujeres en mi país en condiciones de únicamente familiares. No se podía incursionar en otro lugar o menos en un trabajo formal, ya que esto estaba concebido únicamente para los hombres y tenía que tener el permiso del esposo si así era. También el trabajo que tenían asignado era el trabajo del hogar. Las expresiones para reivindicar aspectos también en el orden penal, laboral, la maternidad han sido difíciles, básicamente en el orden penal, porque pues antes en nuestro país se sancionaba a las mujeres, no así a los hombres en algunos delitos, básicamente en el concubinato, en el adulterio. El derecho de expresar y disentir de las formas en que el derecho de las mujeres se ha venido atendiendo. La academia fue rectora para fortalecer esta manera innovadora a las capacidades de las mujeres para contratar y establecer herramientas teóricas y prácticas que le permiten la eficacia de algunas leyes. Tenemos la ley contra el femicidio y otras formas de violencia contra la mujer, en donde tenemos nuevos conocimientos, cambios de paradigmas en el ejercicio de esos derechos humanos. Los avances de empoderamiento para poder hacer viable las propuestas fue posible gracias al apoyo de una cooperación internacional e incidir en el ámbito de la política. Se hicieron propuestas ante el Congreso con la finalidad básicamente de evitar la antidiscriminación existente. Como les decía, en el orden penal hay varias normas discriminatorias que fueron eliminadas en el ordenamiento jurídico por medio de acciones de inconstitucionalidad, con lo que fue posible cambiar, como les decía, el delito de adulterio, el de concubinato, el perdón del ofendido, pero en esos procesos hubieron muchísimas voces que fueron muy importantes, precisamente las voces de las mujeres. Y finalmente quisiera expresar que la incidencia de las mujeres ha permitido contar con nuevas legislaciones y creo que si hacemos un recuento de la historia, lamentablemente las mujeres no hemos tenido ese derecho de expresión y considero que el derecho de expresión de una persona también tiene límites. Creo que todos los seres humanos, hombres y mujeres, deben de ser respetados en sus condiciones. Lamentablemente, y así lo digo, existe a veces muchos espacios en donde los funcionarios públicos hemos sido objeto, y especialmente las mujeres, de estereotipos y de formas de discriminación. En mi país, es un país democrático en donde existen ese espacio a los medios de comunicación y no a todos los funcionarios podemos hacer pues esas expresiones porque lamentablemente las malutilizan en algunos espacios públicos. Hemos sido, porque puedo decirles que sí hemos sido objeto de discriminación, he sido objeto como jueza constitucional de esas formas y esos estereotipos. Pero les podría contar, creo que ya tengo el final del tiempo, pero voy a decir algo. Fui una de las primeras, o fui la primera jueza de un tribunal de femicidio y en los espacios nos decían como burla las paquitas. Esto es un estereotipo de una persona que cantaba en contra de los hombres. Creo que todos y todas merecemos respeto como mujeres y hombres y como ciudadanas y ciudadanos. Muchas gracias.
Muy interesante, Dina Josefina. Muchas gracias por tus palabras. Now we have Mr. Rainer Arnold, professor of the prestigious Regensburg University. Professor, may I ask you a question? And in your opinion, which are the main constitutional parameters of freedom of speech related, obviously, with democracy and also to the rule of law?
Thank you very much. May I start?
Sure.
Yes. Dear Excellencies, dear colleagues, ladies and gentlemen, first of all, I want to thank very much to the President of the World Law Association, Javier Cremades, for having invited me. So it's not the first time that I'm here, but it's always a very precious occasion for me. Well, our panel refers to three fundamental constitutional issues: freedom of speech, democracy, and the rule of law. These three issues are not separate issues. They are interconnected. One depends from the other. And I speak now first on the integration of this issue in modern constitutionalism. And I want to say that I try to speak on normative reality, not on political reality, because these both phenomena are often different. First of all, the basic value of constitutionalism is dignity of human dignity. This is the most fundamental value, and it's of universal importance. And human dignity is in the focus of constitutionalism, and we could also say, and I often say, constitutionalism is anthropocentric, is focused on man, on human being. And freedom, the principle of freedom is closely connected with human dignity. There is no freedom without human dignity, and there is no human dignity without freedom. The principle of freedom of the individual is inherent in human dignity. And what is important, this is the principle of freedom. While human dignity is not restrictable, cannot be restricted, cannot be weighed out against other constitutional values, but freedom, of course, is in principle existent and is restrictable, of course, for necessary needs of the community. There is and there are restrictions of freedom. These restrictions, what is important under the view of human dignity is that freedom remains the principle, and that the restrictions of freedoms, which of course, do exist and must exist, are exceptions which must be legitimized. And the legitimation of a restriction of freedom is that it is indispensable, is necessary for a legitimate aim. And now, I would say worldwide, there is an instrument which indicates a frontier between the principle of freedom and the restriction. This is a principle of proportionality. And so if a restriction is proportional in all its dimensions, and if the restriction does not destroy the very nature of the freedom, then it is legitimized. And democracy is a form of freedom. It's political freedom and self-determination. So human dignity requires also the existence of democracy. And we have in the jurisprudence of rather many courts, also in the German, of the German Federal Constitutional Court, it's clearly said that democracy is very close and to dignity and cannot be separated. Well, the third aspect is that human dignity and the principle of freedom attributes to a human being by the quality of being human. This means that equality, non-discrimination and equality is an absolute requirement also of human dignity. So we see three basic values of constitutionalism and of course freedom. If I speak of freedom, freedom is specified by fundamental rights. And these fundamental rights either written in a constitutional text or not written, unwritten, but the efficiency of the protection of the individual, the efficiency requires that we recognize also unwritten fundamental rights. I think it does not matter whether it's written in a text or not, but the finality is, the basic finality is to protect the individual, and the protection must be efficient. And so there are fundamental rights now for the dangers on liberty, on freedom in the present and emerging in the future. They will come out and be formulated by the judges. The rule of law is a bridge between these constitutional values and the institutions of a state. Over this bridge, these values go into the institutions. They have to apply it to the individuals in their practical world. The institutions have to be conform with the basic principle of the Constitution, and they have to realize these values in concrete cases by application of the Constitution. And well, the rule of law is highly important. It's universal, as it's already been said, with full right. And rule of law means transforming these values, dignity, freedom, and equality in its specifications to the individuals themselves. And the rule of law has, of course, various dimensions. One dimension is that law must be effective, must be well understood. So law must be clear, must be determined, must be stable, must create confidence in law. And so retroactive laws are very problematic in criminal matters. They are forbidden all over the world, but also retroactivity is against the stability of law, and so it is problematic. And the second form is it's not only the form, not only formal rule of law, but also substantial rule of law. It means that the rule of law recognizes and transports the values of the Constitution to the political world, to the individuals themselves. I must also, one more aspect is what we call in Germany and open statehood. I must say that, for example, one specific important freedom aspect is, of course, freedom of speech. But freedom of speech is not seen only from a certain constitution. If I heard how you defined this from your view of Mexico, I could say this is also the view of Germany, more or less. So, well, but now what I want to say is that fundamental rights are now have to be interpreted in an international way. And in Germany, for example, our federal court jurisprudence says that the German fundamental rights have to be interpreted in the light of the European Convention of Human Rights. This means Strasbourg Court and jurisprudence has a great influence how to understand our national German fundamental rights. And beside that now, also, they have to be interpreted in the light of the European Union Fundamental Rights Charter. So there is a convergence. It's, I think, an expression of what you said, and I adhere to this really, that these basic values are universal. They are not respected in all the countries, but this does not deter us to say they do not exist or they are very weak. No, I think they, in ideas, they are very strong. And so you find them all over the world. And also I was confirmed by also your interventions that universality indeed exists. And our Constitutional Court has also accepted the universality. I think it is so. So I do not want to speak in detail on the freedom of speech. I can refer to our key speaker today. It is rather the same, of course, it's traditional, but the fundamental ideas are the same and they are universal. And to express your opinion, to get information in a sufficient way that you can form your opinion, and that all the communication media of today, they are under the protection of freedom of speech in a larger sense. And we have not only privileges from that, we have also dangers from that. We know this with internet, so with hate speech, with now many other things, fake news, all this influences on electoral campaigns and all these matters. So we have, of course, and this is my last word, the state or the public power has not only the obligation to protect this liberty, yes, to give this liberty, but also to protect against dangers resulting from these freedoms. And so in the European Union, for example, now we have the Digital Services Act, which makes the practice better to block out news speeches which are not real speeches, which are based on hate or on hatred, on aggression or whatever, or on fake news. So the truth is in the middle of freedom of speech. Thank you so much. Excuse me.
Professor, we're really honored to have with us Gresa Kakanimani, President of the Kosovo Constitutional Court. Your opinion on these matters and subject about freedom of speech and democracy and rule of law, please.
Thank you very much. Thank you, Mr. Olea. Distinguished fellow panelists, esteemed participants, President Cremades, President Harbath. It's very difficult to take the floor after the professor, but I will take a chance to say a few words about what I believe to be some of the threats and opportunities to democratic values in the world right now. First, let me add again that I feel truly honored and inspired to be among all of you today. And while each of us comes from a different legal and constitutional traditional and experience, the topics of this panel, freedom of speech, democracy, and rule of law, represent issues of common interest and concern to all of us. These values are the bedrock of our constitutional system, and the same are represented also in the constitution of the youngest state in the European continent, that of the Republic of Kosovo. While these three core values reflect our common and shared values, the constitutionalization of the same, namely their effective and practical interplay in our societies, also faces common threats. And this is not only a result of security concerns primarily related to the war in Ukraine in the European context, but also one other factor, which is the rise of far-right populist political forces, including as a result of some of the threats that are related to freedom of speech, and including fake news that Professor Reiner mentioned, and leading subsequently to governments with authoritarian tendencies. In the few minutes allocated to this intervention, I choose to focus on this factor because it affects both the rule of law and freedom of expression, and consequently our common democratic values, because in fact it begins with affecting the core principle of separation and balance of power, and mostly to the detriment of the independence of the judicial branch. As the case law of the European Court of Human Rights reflects, in the last decade, the number of cases finding violation and emphasizing the essential principle of judicial independence has increased. These cases have been primarily, of course with exceptions, rendered in countries in which the new governments embarked into significant rule of law reforms, although designed to affect and or diminish the independence of the judicial branch, and equally the freedom of speech and or expression, as the respective governments adopt policies that are at odds with these key values, as well as the plurality of opinion. In some instances, it was ultimately the constitutional courts who have acted as safeguards and played a safeguard role in this respect, and in some others, it was the case law of the European Court of Human Rights. The youngest democracy in the European continent is not immune to these problems. While Kosovo reflects a very successful state-building story and example, including in terms of a very vibrant democracy, the recent years have also have been marked with two tendencies. Rule of law reforms, which are at odds with the concept of judicial independence more often than not, as well as introduction of policies which introduce complex licensing requirements and or interference with the selection of management bodies of public broadcasters, affecting thus the plurality of media and freedom of speech. These tendencies are certainly widespread to various extents in the region as well. While I'm choosing to focus only on this challenge, certainly, and many others were raised by my esteemed colleagues, and only for the purpose of initiating a discussion which we will have subsequently, I would like to also emphasize that this situation also paradoxically enables for an opportunity for the judicial branch and an opportunity to strengthen the interplay between the division and balance of power. The tension between the branches of government, the tension between the judicial branch and the executive branch reflects that democracy is working. And the courts play a primary role in this respect, either through abstract control or individual control of human rights, pushing back on laws and policies which affect the core rule of law values, including the independence of the judiciary, as well as human rights and fundamental freedoms, including the freedom of speech and expression. While Kosovo is a unique case because it's not yet a member of the European Union, it's not yet a member of the Council of Europe. And this means that our public authorities are not subject to the supervision authority of the supranational courts. Its judicial system has played a pivotal role in safeguarding these values through referring to principles that derive from the case law of the European Court of Human Rights, referring to principles that derive from the case law of the Court of Justice of the European Union, as well as the common denominator deriving from the constitutional traditions of the liberal constitutional democracies. Of course, a great source of inspiration is also the Federal Constitutional Court of Germany. For example, some reason for optimism, I guess, to finish in a positive note. Recently, a lower level court in our republic has issued a suspension order to a government decision which withdrew the license of one of the media outlets. Similarly, the Constitutional Court has recently declared unconstitutional the government's efforts to reform the way that the public management bodies of public broadcasters are done. Equally, recently declared unconstitutional a very significant reform in terms of the prosecutorial council, which was designed to add interference of the executive branch into the decision-making of the prosecutorial system, emphasizing thus the importance of division and balance of power and the judicial independence. The rule of law, and I'm not saying anything new with this, is certainly essential to our human rights and fundamental rights protection. And judicial branch is, in my view, the branch of government that plays the most significant role in this respect. On the other hand, the freedom of expression is the beginning of all freedoms. And here, I would simply go by quoting Justice Anthony Kennedy, whom we're all honored to have been gathered here to pay tribute to, who has famously said, "The First Amendment freedoms are most in danger when the government seeks to control thought or to justify its laws for that impermissible end. The right to think is the beginning of freedom. And speech must be protected from the government because speech is the beginning of thought." Taking into account the limited time available for brief remarks, and I don't want to go beyond the time allocated, I would just like to emphasize once more that I only chose one aspect of the threats but also opportunities to our democratic values. And I'm fully aware that this is certainly a very complex and multi-layered discussion, which I am very much looking forward to subsequently have. Thank you for your time and attention.
Thank you, President. Very interesting, your point of view. Now we have it's a pleasure for me to announce we have here with us a very important lawyer from Mexico also, Ricardo Rios Ferrer. He's president of the General Council of Mexican Bar Associations. Ricardo, hemos escuchado las palabras de nuestra jueza constitucional de Guatemala, del gran Diego, de la presidenta de la Corte Constitucional de Kosovo, sin duda la del profesor. Y ahora me gustaría preguntarte y que nos dieras tu punto de vista o tu visión de cuál es el estatus actual y el futuro de la libertad de expresión, desde luego en términos generales, pero también en México, Latinoamérica. ¿Qué nos puedes comentar al respecto? ¿Quieres pasar?
Many thanks to the World Jurist Association. Javier Kermades, thank you for this opportunity. Victor Olea, President of the Mexican Bar Association, thank you. It's an honor sharing this panel with all of you, my distinguished colleagues. Today we're gathering to review certain matters that are common to all of our countries. These attain to freedom of speech, democracy, and the rule of law. In particular, in my country, Mexico, these three matters are under siege as we speak. There are several constitutional bills submitted by the President to the Mexican Congress, whereby, for instance, they're planning to limit the constitutional review powers of the Supreme Court and to subject the Supreme Court and, in general, the judiciary to the review of the legislative power. They're also planning to have the magistrates of all levels in the judiciary to be publicly elected. Freedom of speech is also being hunted in Mexico as well with these reforms, but also by a constant daily criticism and attitude from our president. Just to give you a couple of examples. About 2 years ago, the president criticized a journalist who was critic of his government, and he did so on a daily basis. Our president has this morning mass media meetings where he defends his projects, but also attacks his perceived enemies. He attacked this particular journalist to the point that later, few months later, he was attacked with a shower of bullets. Fortunately, he was not harmed because his car was blindado? Yeah, armored. And obviously the president said that the government was not behind it, but you could see the thread of how such an influential wording from the president could provoke someone else to perform these attacks. Just a couple of weeks ago, the New York Times made an investigation on the relationship between the drug traffickers funding political campaigns, in particular those that were giving money to the current party in power, Morena, our president's party. When this report came out, the president showed it in these daily meetings called the mañaneras, because they're in the morning, and he deliberately named the journalists, but in particular the personal data of those journalists, their telephone numbers, etc. The next day, another journalist in that same forum asked the president whether he was okay by revealing those personal data from those journalists of the New York Times. And he said, yes, and I would do it again. And the reason why is because, quote unquote, he basically said, my moral authority and the political authority of the president is above the law. So I think this wording from our president summarizes what we have been living through in Mexico, but that certainly has some other expressions and reflections throughout our region and indeed throughout the world. These expressions basically point towards a trend of autoritarismo, that sees the liberty of expression and democracy as an obstacle for their ideology and the way they want to implement their ideology. What we have seen, basically, in essence, is that, as we know, the democracy basically legitimizes the organs of the state that have the power to produce laws and legitimate acts. In doing so, those norms, those laws become valid and are fortunately controlled constitutionally by the judiciary, thereby creating this constitutional regularity. The problem that we have seen is that we are looking more towards what is being called an abuse of the state of the rule of law. It's what in certain Anglo-Saxon countries they called the rule by law, and not just the rule of law. And the rule by law is basically a manipulation of the instruments that already exist in the Constitution and in the laws. And this manipulation is done deliberately in order to simulate the compliance with those rules and proceedings, but the substance has terrible legal effects and in many cases violate the Constitution. The abuse in the rule of law is also reflected in the limitation of the freedom of speech. As you know, the freedom of speech is really also a reflection of the freedom of thought, as you have said. And this is extremely important because if we are not free to express ourselves, then we'll keep our thoughts to ourselves, and therefore there will be no dialogue, no conversation. We will be frightened to express our thoughts, and the only thought available throughout society will be those of the government who will be imposing a way of thought. Silence could become our worst enemy. Basically, and I'll end with this final thought, basically, the struggle that we are facing, that we're presenting, it's a battle that just by presenting battle will make a difference, but it's of the essence to try to impede this trend of diminishing democracy, this trend of abusing the rule of law, and this trend of reducing and limiting not just the liberty of expression, but the liberty of thought. Thank you very much.
Thank you very much, Ricardo. And finally, we have a member from Japan of the World Jurist Association, Kaori Matsumoto. Kaori, do you want to mention the brief overview of the guidelines and tests applicable for determination of legitimacy of the restrictions of the freedom of speech, please? Could you come up? Oh, you here? Sure.
Yes, thank you so much. So it's a great honor. Can you hear me? It's a great honor and privilege to meet with all distinguished panelists and the guests. And thank you so much for inviting me here. Before I was working in the United Nations Office on Drugs and Crime as a crime prevention and criminal justice officer. And there I was in charge of establishment of the Judicial Cooperation Network for Southeast Asia region. And it was established in 1 year and expanded beyond the 12 Southeast Asian countries. And now the member includes from the US and also European countries, Pacific, and other Asian countries too. So from this point of view, I really see a lot of value that the distinguished jurists come here and talk about those important topics related to rule of law. So thank you so much. And after hearing all those, there is a saying in Japan, like teaching Buddhism to Buddha. That is exactly my situation now. But okay, but please allow me to highlight some key legal instruments and helpful tools related to the freedom of speech and expression. So since it was abuse of the rule of law and it's reinforced in limit on the freedom of expression, and this was mentioned by President Ricardo, yes. And also the connection of freedom of speech and freedom of thoughts. It was also mentioned by President Ricardo, President Gressa as well, and so also Professor Leiner too. I believe at this timing it would be helpful to clarify the fundamental rules about regarding the limitations and restrictions on freedom of expression and speech. So there are some key cases regarding that, and also the threshold tests often used based on the case law, as well as the guideline made by the OHCHR. So please allow me to mention those briefly. First of all, freedom of expression is enshrined in Article 19 of the Universal Declaration of Human Rights. It is also influenced in a number of international, regional, and national legal instruments, declarations, as well as observations by various treaty bodies, and in UN reports and resolutions. Those include Article 19, Paragraph 2, of the ICCPR and Article 10, Paragraph 1 of the European Convention of Human Rights. So according to Article 19 of the ICCPR and the UN Human Rights Committee's General Comment number 34, the freedom of expression includes the media freedom and other rights of journalists, cultural and artistic expression, teaching, and religious discourse too. Also, the right covers communications that are both oral and written, and all modes of communication, including audiovisual, digital, and internet-based communications. And on the other hand, the freedom of expression is a non-absolute right, which means it can be legitimately restricted in certain circumstances. The limitation on the freedom of expression is, for example, stipulated in Article 19, Paragraph 3 of the ICCPR and Article 10, Paragraph 2 of the European Convention on Human Rights. Also, Article 20, Paragraph 2 of the ICCPR requires states to prohibit certain severe forms of hate speech. That was also mentioned by Professor Leiner. It is of great importance to have certain standards and guidance to correctly interpret those restrictions to the freedom of expression. In this regard, I wish to highlight some key tests and case laws, as well as guidelines for such interpretation of restrictions to the freedom of expression. Those include tests used under Article 19, Paragraph 3 of the ICCPR, tests used under Article 10, Paragraph 2 of the European Court of Human Rights, and its cornerstone case law, Handyside versus UK case, which is one of the first and the most important case laws in relation to the freedom of speech, as well as the sixth threshold test of the Lavat Action Plan for examining if the speech will amount to the hate speech stipulated under Article 20, Paragraph 2 of the ICCPR. So first, under Article 19, Paragraph 3 of ICCPR, a four-part test is used to assess whether such a restriction is justified. First, the restriction must be provided by law. Second, it must pursue a legitimate aim. And third, it must be necessary to protect a legitimate aim. And then fourth, the extent of the limitation must be proportionate in pursuit of the identified legitimate aim. Then, what can be the legitimate aims? The ICCPR provides an exhaustive list of legitimate aims. First, the rights or reputations of others. Protection of the rights or reputations of others. Or second, the protection of national security. Third, the maintenance of public order. Fourth, public health or morals. We also have to ask, does the restriction respect the principle of equality? Is it non-discriminatory? Members that limit freedom of expression in discriminatory manner, or measures that limit freedom of expression in a discriminatory way will fail the test of proportionality. So whether the restriction is made in a discriminatory manner or not is considered as one aspect of one criteria for the necessity and proportionality test. Only all of these criteria are met, restriction on the freedom of expression is permissible. A similar test applies to the right to freedom of expression under other legal instruments. As you know, the European Court of Human Rights has a cornerstone case on the freedom of expression in 1976, Handyside versus UK case. Although the court found that the case itself did not violate the right to freedom of expression, the judgment read as a whole sets a strong general standard for the protection of the right to freedom of expression. In particular, the paragraph 49 has become a cornerstone of freedom of expression jurisprudence. Let me read the paragraph 49 as it includes so many important dictums. Citation, freedom of expression constitutes one of the essential foundations of such a society, one of the basic conditions for the progress and for the development of every man. The freedom of expression is applicable not only to information or ideas that are favorably received or regarded as inoffensive or as a matter of indifference, but also to those that offend, shock, or disturb the state or any sector of the population, such are the demands of the pluralism, totally different meaning. Pluralism, tolerance, and broad-mindedness, without which there is no democratic society. This means, amongst other things, that every formality, condition, restriction, or penalty imposed in the sphere must be proportionate to the legitimate aim pursued. So proportionality principle appears here. The Handyside case has been cited by a number of courts around the world as one of the most important judgments in freedom of expression cases, and it is applied up until today. Taking the handy-side judgment into consideration, restriction test on the protection afforded by Article 10, freedom of expression of the European Convention on Human Rights are, first, threshold, if an interference is a freedom of expression exists. Second, if the interference is prescribed by law. And third, pursues one or more legitimate aims. And finally, fourth, if it is necessary in a democratic society to achieve these aims, which is very similar to the test under ICCPR. As set forth in Article 10 of European Court of Human Rights, freedom of expression is subject to exceptions, which must, however, be construed strictly, and the need for any restrictions must be established convincingly. This was made further clearer in Stoll versus Switzerland case, and also in Maurice versus France case. In relation to the hate speech, so I wish to mention the hate speech as well. The freedom of expression also has limitations stipulated in Article 20, paragraph 2 of the ICCPR. In order to interpret such restriction in light of its object and purpose and protect the freedom of speech, it is very important to have certain standard in distinguishing between permissible speech and speech that may amount to the hate speech. So what would be the hate speech? In this regard, as a useful international guideline, I wish to mention the Labat Plan of Action, which is developed by the UN Office of High Commissioner on Human Rights, OHCHR, through its expert workshops. It suggests a high standard for defining restrictions on freedom of expression, incitement to hatred, and serves as practical legal and policy guidance to states on interpretation and implementation of Article 20, paragraph 2 of the ICCPR. The Labat Action Plan makes several recommendations to states, civil societies, media, companies on how to best deal with any tensions that may arise between freedom of expression and the prohibition of incitement to violence. It has the 6 threshold test to understand whether a certain statement meets the threshold of incitement to hatred or not. First, the social and political context. Second, status of speaker. Third, intent to incite the audience against the target group. Fourth, content and the form of the speech. Fifth, extent of its dissemination. And sixth, likelihood of harm, including imminence. So it is a helpful guideline and summarized in one paper. I understand that the Labat Plan of Actions threshold test is translated into 32 languages by OHCHR in cooperation with Facebook. So I have it here if you want, maybe with the help, yes. And one of the good practices of utilizing the Labat Plan of Action threshold test is in 2021, Facebook's oversight board referred in several decisions to the Labat Plan of Action, using its 6 threshold to assess the capacity of speech to create a serious risk of inciting discrimination, violence, or other lawless action. So as conclusion, what kind of latitude human rights bodies would give on restrictions on freedom of speech is restrictive. This point has been repeated in so many cases since a democratic society is built on the ability of people to express their views, and there is an important demand of pluralism. Thank you so much.
Thank you, Kaori. So we finished our panel. Thank you very much to all, Kaori, Professor, Greta, Ricardo, Diego, and Dina Josefina. Thank you very much. I ask for an applause for them. And Patricia.
Well,
Thank you, and please join me in thanking all of our moderators and panelists from this morning. Before we leave, I have two very important things to say. The first is with regards to your lunch. Your lunch will be served both in the back and in the front. There will be standard seafood and vegetarian options available to you, so I hope you will enjoy your lunch. The second important announcement is with respect to these things. Do not leave the center with them. If you are going to leave the center, please drop your device off and pick up a new one when you return this afternoon, when we will convene in this room again precisely at 3:30. So please be here early enough to be in your seat for our 3:30 start. Thank you. And we will begin with what I know is going to be an extraordinary conversation on the rule of law and legal certainties in current democracies. A reminder to our speakers that we have until 4:20 to complete this panel, so I will kindly ask that everyone adhere to the time limits. First, I would like to make sure that all of you have in your hand a bookmark, either in English or Spanish or French or Portuguese. Yaki, have those been distributed? Those were sent by Justice Kennedy to all of you, and if anyone is missing your bookmark, please raise your hand. I didn't get mine, so I'm raising my hand, and our team will bring some in and distribute them to you. It was a quite wonderful thing for the Justice to do. I'm not sure if I'll get one or not, but I'm going to keep my hand up just in case. Thank you, Deborah. Thank you, Deborah. Secondly, to the press, as we proceed with this next panel, I will kindly remind you to turn off your camera during the remarks of Justice Stephen Harbath, as his speech is not to be recorded at all. And now I'm going to try this in Spanish, so please do not laugh at my bad pronunciation. Pedimos de la prensa que por favor apague las cámaras durante la intervención del magistrado Stephen Harbath, ya que su discurso completo no puede ser grabado. Was that close?
Agradecemos a los medios, por favor, a apagar sus cámaras al momento en el que vaya a hablar el presidente Harbath, ya que su discurso completo no puede ser grabado. Gracias.
My apologies for my terrible, terrible Spanish pronunciation. And now I am very honored to call to the stage our keynote speaker and moderator, President Edgils Levitt, who was the president of Latvia from 2019 to 2023, and judge of the European Court of Justice from 2004 to 2019. I also invite our panelists, Matea Ceto, President of the Constitutional Court of Slovenia, and Stephen Harbath, President of the Federal Constitutional Court of Germany. And Senior Justice Kennedy will provide his remarks on video.
Dear colleagues, end of the 90s, beginning of the 2000 years, there was an intention to widen the democratic participation, so-called democratization of democracy. The colleague from Guatemala told us the earlier stage of democratization of democracy. The first voters were only male taxpayers, then all males, then literate women, then all women, and now all formally are participating. And the second wave of the democratization of democracy means to invite all the social groups to participate in politics. Also because not all the percentage of voters is 50 to 70%, so not all, but there are activists and our political parties are saying, come into democracy and participate. And this expansion of, or democratization of democracy, element of democracy, has not, so to say, is not really reflected also in the quality of democracy, in the quality of the democratic decisions. And we can see that especially through digital media, so social networks, also such political agendas are promoted, which would be very difficult to be promoted in the system of certain filtration through parties, filtration through responsible press. So to say, not all ideas which we are exchanging in our kitchen are ready to be discussed in the parliament, in the public. Now it is possible. And therefore, this quality of democratic discourse, I would say, democratic debate, is problematic. And one of the problematic issues of this discourse is that with a wave and with the idea of equality on participation, of course, the focus is put to the restrictions of democracy by rule of law, by the courts, by constitutional courts especially. And there are many discussions also in the academia whether whether such kind of restrictions are still democratic, and whether this outsourcing of certain competencies to the courts, to the independent agencies, especially in the European Union or in the European Union as such, or where I'm speaking now about the European Union, where the voter has relatively not so direct influence to the decisions of the European Union, has not created a certain frustration, and this frustration is used by populists, or the populists are making this feeling of frustration in political money. And they are in all, or in most democratic states, we can see that there are such populistic movements which are challenging exact this classical relation between democracy and rule of law. The problem is how to deal with that. And first problem discussed also in academia, but also in a broader public, is whether it is good or bad. So to say that what in the broad public is discussed, and such kind of ideas are immediately or relatively direct transformed in political decisions. And the ideas of the populist movements, rather right-wing but also left-wing populist movements, are the ideal to restrict or to representative democracy, which are filtering the ideas, to rather to direct democracy without or very weak filters. And whether this kind of politics is an achievement or, on the other side, as we are saying, like backsliding of our state order. So we can then see that this kind of populist politics are relatively short-sighted, and there is not possible to have a strategy which is necessary for democratic states in the current world, in the global world, where democracy is also not only challenged from inside, from populist movement, but also from outside. Only there was some colleagues said that only 1/3 of the world population are living in the real democracies. On 2/3 are living in non-democratic states, and the tensions between these two worlds are increasing. And I think it's very dangerous because then the resilience of our political order, democratic constitutional state, will go back, and our order will become rather fragile. I will stop here, and maybe we can ask what to do. What is possible to do? For example, we heard that in Germany there already is in prevention of possible, so to say, populistic majority. There should be some changes in constitution which will hinder, so to say, the attack to the constitutional court, the position of the constitutional court. Maybe we should come back to the idea of during and this immediately after the Second World War, the idea of self-defending democracy, of militant democracy in English, or Wehrhafte Demokratie in German. But this is, consists of two situations: when the problematic political forces are in minority, so the anti-democrats are in minority, it's more easier. But how to do with when they are in majority, when they control the parliament, the government? I think we should also think in these terms. So I will stop here. I will give now the floor to the President of the German Constitutional Court, Mr. Habert, and this concept of Wehrhafte Demokratie, or militant, or rather I would say self-defending democracy. In Latvian, saying self-defending, it sounds better as militant democracy. Maybe this idea could be used also in this crisis, or other ideas how we can how we should go out from the crisis. The colleague said that she managed Spanish to go into trouble, but not out of trouble. Now we are going into trouble, but we maybe will manage go out of trouble in this discussion. Thank you. Yeah, please, then. Yeah. Ah, yes. Yes. So, excuse me. So, we have three panelists, except me, also Mr. Anthony Kennedy, Justice Kennedy. We are paying tribute to him. And first, before discussing the trouble with democracy and rule of law, we will hear the video of Justice Kennedy. What is his opinion, his thoughts? What is rule of law? What is rule of law? Anthony Kennedy. Please video.
Greetings once again. These are some informal remarks of the kind that we usually have when we have a discussion together, where you can ask questions, make comments. But let me address you for just a few minutes on a subject that may inspire you to have a further conversation among yourselves. You've received a rule of law bookmark, which we sent to you. The origins of this date back, some 20 years, when I was on one of my short teaching visits to China. We were at a university, and my best recollection is that it was Renmin University. And of course, like many judges, my beginning was somewhat pompous, saying, "I'm here to tell you about the rule of law." And one student raised his or her hand, and there were probably 500 or 600 students in the room, and said, "What does the rule of law mean?" And it had never occurred to me to define it. And so my answer was that it's in 3 parts. And later, the United Nations asked me to write it down, which we did, and it's been translated into many different languages. That should not keep you from telling me in later correspondence, if you choose, that it's incomplete or unclear, or that it should be supplemented. We wanted it to be short, so that we could think about the rule of law. And as you know, it's been translated into many different languages, which we hope you have at your conference. The first precept, and there are 3 parts. The first one is that the law is superior to the government, and the government is bound by the law. And this means officials at the lowest level who must obey the law. The law shouldn't be secret. Now you might say, well, what if the law is unjust? Stalin killed millions of people. What if he said, well, this is the law as I gave it? Mussolini made the trains run on time. But that's not the law as we do know it or as we ought to know it. And a government that uses law as a monopoly to direct its citizens' lives can be terrifying. So the first paragraph, in effect, asks us to read further and indicate what should the law say. And that brings us to the second paragraph. And a key part of it is that the law must respect the dignity of persons, of all persons. To begin with, that's an essential cornerstone for us to have a conversation with each other. You know, Americans talk often about the Constitution, and we think of the Constitution with a capital C. A capital C to indicate we're talking about the Constitution that was drawn in Philadelphia in 1787 and enacted in 1789. The Constitution that defines us as a people. You can't talk to an American lawyer for very long, or an American citizen, we hope, without hearing about the Constitution. It defines us as a people. And it does preserve what we seek to express in paragraph 2, the dignity of all persons. Now, writings about the dignity of all persons are nothing new. Mencius, who was a Confucius student, wrote thousands of years ago. You've heard me say before at your conference, perhaps in New York, that Mencius has the same relation to Confucius as Plato did to Socrates. You wouldn't have heard much about Confucius, or nearly as much, if it weren't for Mencius. You wouldn't have heard about Socrates, or nearly as much if it hadn't been for Plato. But in any event, Mencius, centuries ago, gave this question, posed this problem. A stranger from a distant part of the nation is walking through the countryside and goes by a farmhouse. It has a well, a water well, and he sees a little child crawling up the wall of the well and ready to fall in. Does he have a duty to run and rescue that child? This writing shows that in ancient China, there was a recognition that each person has a morality, a moral sense, a moral decency of his own, of her own. And that is what we try to capture in paragraph 2. The dignity of persons is essential to the rule of law. John Locke explained that you can't have a civic dialogue unless you respect the voice and the personhood and the natural rights of your fellow citizens. In the American and Anglo legal tradition, the Magna Carta is of tremendous importance. It was in the year 1215. Before then, most every legal documents, and there were some wonderful constitutions, were written in a way that the state gave the persons certain rights. Magna Carta said, no, 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 no. Persons already have rights. It's persons who give the directions to the government, not the other way around. That's the meaning of Magna Carta. And this bookmark seeks to reflect that. The last, and we could go on and on about the meaning of dignity and what law must mean. It doesn't mean that Stalin can kill thousands, millions of people, because there's a human dignity there. Then we say that the law must be accessible. My law clerk is here listening to us, one great prerogative of members of the judiciary, the federal judiciary in the United States, is that we have wonderful young people working with us for a year as our law clerks. And he made the comment to me that lawyers are ambassadors to the law. And it seemed to me that this is a very apt description of the purpose and function and duty and aspirations for lawyers who meet with their clients. They are ambassadors to the law. Javier Cremades, by his leadership of this great Congress, is a splendid example of this. Thank you again, Javier, for making this association and its dialogues and its meetings so accessible to all of us, accessible to each other. There's a book on the law of the American legal history, of American legal history. It's in its 5th edition now by Kermit Hall, American Legal History. And if any of you are interested, it looks like a great big, and it is a great big long book. It looks like a great big long book, and it is. But it dates from the Middle Ages and goes through modern times. This is in the 5th edition by Kermit Hall. And they're very short sections and paragraphs summarizing so much of what our legal history is. And one of the quotations he has is from a writer who said, "We must not be deaf to the voice of justice." And one of the reasons that you meet here, one of the reasons that so many of us are proud of your association and value it so highly, is that you know we must not be deaf to the voice of justice. Do we know what justice means? Not altogether. This is an adventure, an ascent, as I've said before, an avenue, a path that we find together over time. It is sometimes difficult to see injustice in your own times. But that is what the law is designed to counter. And that is what your association has as one of its great purposes. So once again, we wish you well, and please be assured of the high respect that so many of us have for you, for who you are, and for what you do to preserve the rule of law. We meet here as friends, you meet here as friends, and we hope that friendship becomes even closer over time. And we hope that between this Congress and your meeting in the Dominican Republic, we can talk often about how the association might better bring the idea of justice and the rule of law to every nation. Best wishes, and thank you very much.
Lawyers are ambassadors to law. Thanks to Justice Kennedy for his thoughts on the essence of rule of law. And now I will give the floor to Judge Herbert from Bundesverfassungsgericht, Constitutional Court of Germany. Thank you.
Thank you very much. But even if democracy could work without liberty, we did not want a system of democracy without liberty. Because exactly what Justice Kennedy said, that the old understanding that the state does not grant the rights to the individual, but the individual has the rights regardless of whether those rights have been granted by the state. That system can only work if the majority, if the democratic majority cannot do anything it wants to do. And for that reason, there is a close relationship between liberty and the rule of law. Unfortunately, some try to argue that the rule of law is a danger to liberty. But what is true is exactly the opposite. Without the rule of law, there is no liberty. If the majority can say what you have to say, what your religion is, what your dignity is, then liberty does not exist. And I think this is the most important task we have, to make clear wherever we are, to explain those relationship between democracy, liberty, and the rule of law. And of course, that is difficult in the times in which we live. I think it's difficult. I do not believe that we really understand what happens in Western societies completely. I think there are some hidden mechanisms, hidden processes we do not really fully understand. But we see that the trust of people in institutions, that the trust of people in the competence of the Western system to solve the problems the states and the societies are confronted with, that trust is lower than it used to be decades ago. Of course, we have a lot of problems because many ask, would we be better off in an authoritarian world than in the Western model? But I think we have to make clear that our heritage by the Enlightenment cannot work in the present and in the future without the rule of law. There is no democracy without the rule of law. There is no liberty without the rule of law. And if we make clear that those ideas are inextricably linked to each other, I think then we have the chance to convince people that we have to defend the rule of law.
Thank you very much. And now the President of the Slovenian Constitutional Court, Mr. Aceto. Thank you.
Thank you very much, President Levits, and also knowing that we just have 7 minutes before we absolutely need to break. Allow me to encompass you all in a general greeting to the dear fellow servants and friends of the law. I say fellow servants because we all share the aspiration, that is the common theme of this conference, that the law should rule. And we have heard from Justice Kennedy what that means. And actually, just to comment at the beginning, very briefly, I think his 3 points, I actually recognize them in the symbols of Lady Justice, Justitia, as the embodiment of the law. The sword of justice, they're not the rule by law of a government above the law, but the rule of law, which also binds the government. Protecting the dignity and the rights of all, and affording them access to justice, a mechanism by which to enforce those rights. The modern-day liberal jurisprudence would summarize this as the commitment to the notions of entitlement, justice, and rationality. And it is a very common endeavor that we all know and share. We sometimes see it challenged to different degrees of severity, but we absolutely do share it across the globe. And what I want to do today, because I think the responsibility for the challenges, of course, falls down on the three actors in the triad of those directly concerned by the operation of the law: the courts themselves, the political branches of government, and the general public. And of course, it starts with the courts doing our job properly, and we've talked about this morning: the independence vis-a-vis the political branches, impartiality vis-a-vis the parties to the case, and objectivity or neutrality vis-a-vis the applicable law and one's own, judge's own conceptions and worldviews. And of course, there are open attacks, either by populist movements, by the political branches, which may wish to openly attack the courts or ignore the rule of law. And there may be more or less insidious ways of trying to obviate the requirements of the rule of law. But what I wish to add as a footnote to all these discussions is a few ideas, snapshots of the ways in which the rule of law is challenged even by the well-intentioned governments, by those which do not wish to undermine it, but nevertheless perhaps do or challenge it, at least in ways which are problematic. We've heard some of them already, I think, this morning. President Zachai mentioned the idea of judicialization of politics, of translating political conflicts into justiciable cases which are then brought before the courts. And of course, the courts must and do dispose of those cases as well, but they do come with the cost. Another example, I think, is the one where the moment of crisis, which President Levits also mentioned, comes about, when the governments, the authorities would sometimes say the rule of law should take a step back and not be a hindrance to an effective regulatory response to a crisis. We've seen this with COVID, for instance, recently, when the rule of law requirements in states which were more or less all of us caught ill-prepared for the realities and the challenges of COVID, struggled to come up with constitutionally permissible ways of reacting to the pandemic. But we've even seen it before. We've seen it 25 years ago, after 9/11, when the established standards of human rights protection, the protection of privacy, data protection, free movement, and other rights, have been challenged with a renewed, bolstered sense and commitment to security. And that re-establishment, recalculation, recalibration was also termed by some regression in the standards of the protection of human rights, which is again a topic currently also actively discussed, including the controversial Dobbs decision in the States and the implications of that decision for revisiting other, perhaps, elements and rights in the way the jurisprudence has dealt with them. So there is that element, and of course, for the proponents of those rights, that is problematic in itself, but it also confronts us with this reality, and I think both my co-speakers have already mentioned this, that there are constitutional values we earnestly and rightly hold, which may be in competition with one another. The similar concept to the security of post-9/11 world in Europe, European Union, the area of freedom, security, and justice, is a concept of three values that perfectly soundly work as each on its own, but may be somewhat uneasy bedfellows. And the same with values in Article 2 of the EU Treaty and the constitutional underpinnings that President Levits has mentioned: human rights, democracy, and the rule of law. So what is, for the final 2 minutes, what are the courts to do? The important thing we can do, and we should do, is to keep doing our job properly. We should not be engaged in politics. I am reminded a little bit of what Mr. Aria said when he mentioned this morning the discussions between Putin and Xi Jinping. We absolutely should not engage in that sort of thinking and rhetoric, and I was reminded of what the president of the Constitutional Court of Russia said before Russia's departure from the Council of Europe, when he said, not all rights of the European Convention on Human Rights should be given full effect in Russia because some of them are simply not compatible with the Russian soul. I will leave that there. But I will finish on a hopeful note, and I will go back to the States. I welcome Justice Sotomayor, because sometimes a crisis is also a moment for reflection and a moment to actually to try and develop something. And for the courts, I'm often reminded, and I will use it again, I think most of you may have heard it at one point or another, but there was a wonderful statement once put forward by Martin Luther King Jr. in a different setting, in a different context, but one that always gives me hope, also for law and the operation of the law. He said, "The law cannot change the hearts of men, but it can change the habits of men if vigorously enforced. And if vigorously enforced, over time, the attitudes will change as well. And perhaps in the long term, the hearts themselves may change as well." So as we go back home and we continue doing what we've been doing and we hope for the best, we certainly won't see it overnight. But as judges, what we can hope for is the long term. I thank you very much.
So thank you, Judge Aceto. Welcome, Madam Justice Sotomayor. I will conclude. I will conclude thanking Judge Herbert, Judge Aceto, and Justice Kennedy. And we can only say that we, as lawyers, are convinced that rule of law is necessary as an infrastructure in order that we can work. But we should convince also as a people outside. Also because now there are certain arguments that they are saying just rule of law is too restrictive for democracy. But as Judge Herbert rightly said, rule of law is the basis that the democracy can function. And also this argument, we should be more loud in order to convince the people. Thank you very much, and all the best for you.
Thank you. Thank you.
Thank you for that wonderful program. Please stay in your seats if you would and give us 2 minutes to rearrange the stage for just a moment. Thank you. All right, we are ready to proceed with the highlight of today, the ceremony to bestow the World Jurist Association Medal of Honor on Justice Anthony M. Kennedy, Senior Justice of the Supreme Court of the United States. First, we want to start by setting a bit of context and learn about the history of the World Jurist Association. So if we could play the video. Thank you.
Years, faced with the threat of a nuclear holocaust, a few good men set in motion a singular initiative in favor of peace. It was July 1957 when, on the occasion of a gala hosted in London in honor of the American Bar Association, its president, Charles Rhine, the Chief Justice of the United States, Earl Warren, and Sir Winston Churchill agreed to create a program to promote world peace through law, the rule of law against the use of force. It's at that moment they decided to launch what would later be called the World Jurist Association. Years later, in 1963, Charles Rhine and Earl Warren, in their tireless struggle for human rights, inaugurated in Greece the first World Congress of Law. Numerous presidents of Supreme and Constitutional Courts from different countries throughout the world, general attorneys, egregious lawyers, and eminent professors, a group of more than 3,000 jurists centered around a single purpose, defined by President Kennedy in his message to the Assembly: It gives me great pleasure to send greetings to the First World Conference on World Peace through the Rule of Law. This conference represents 5 years of effort and brings together lawyers and judges from overseas from 100 countries in the attempt to develop and strengthen the legal machinery that must form the basis for peaceful relations among all nations. 2 years later, Lyndon B. Johnson inaugurated the Second World Congress in Washington, whose organizing committee was chaired by Presidents Truman and Eisenhower. 25 more assemblies of this kind, organized by the World Jurist Association, have taken place since then in various countries worldwide. Thousands of men and women united in this formidable association to promote peace through law throughout the world. 3 world statesmen were also honored years ago with the World Peace and Liberty Award. Sir Winston Churchill, René Cassin, father of the UN Declaration of Human Rights, and Nelson Mandela. In Madrid, within the framework of the 26th World Law Congress, the largest association of jurists in the world, King Felipe VI of Spain is awarded the World Peace and Liberty Award for his defense of democratic and constitutional values that has presided over the 40 years of greater freedom and prosperity throughout the history of his country.
In February 2020, the World Jurist Association and the World Law Foundation, chaired by Javier Cremades, present the World Peace and Liberty Award to U.S. Supreme Court Justice Ruth Bader Ginsburg. Upon the passing of the U.S. Supreme Court Associate Justice, the World Jurist Association, along with Professor Jane Ginsburg, decided to confer the Ruth Bader Ginsburg Medals of Honor to female jurists who have promoted the rule of law and gender equality throughout their careers.
I would like to first of all acknowledge and celebrate the creation by the World Jurist Association of the Ruth Bader Ginsburg Medals. Not so much because we were just awarded the medals, but because it is a very effective way to promote the legacy of a giant on the shoulders of whom we all stand. Not only did she consistently and resiliently promote the equality of all before the law and the defense of the rule of law, but she was also a magnificent agent of change for good in society and in the world. The WJA is part of the contemporary history of the struggle for a world ruled by law, not by force.
For the first time, this award that many consider the Nobel Prize of Law is not given to a person. The World Jurist Association awards to them the World Peace and Liberty Award as its 2021 World Law Congress. Congratulations, people of Colombia.
For 60 years now, the WJA has worked to strengthen the rule of law around the globe so we can build a peaceful, more inclusive set of societies where the rights of all are respected.
Freedom, equality, rule of law. And here we are in the midst of it. Here we are. Can we? And none of us knows. None of us knows. All we know is that we can try. All we know, as you said, we can do our best. That's it. That's it. But that's what you're trying to do. And that's what you've been trying to do in this organization for quite a few years. And that's what you have quite a lot of people going out and actually doing it. So we have 3 languages where they produce a challenge. And we are in a building where they tried to meet it. And we are in an organization that itself is trying to meet that challenge. And all I can say is thank you for recognizing me as a part of it. Thank you.
You may ask what the World Jurist Association is doing here at the United Nations today. We are here because we share President Kennedy's belief that law is the strongest link between humanity and freedom. We are here to bolster the rule of law, to lay claim to the hard work of lawyers and judges and jurists across this country and around the world who risk imprisonment and torture and death every day, day after day, day after day.
5 outstanding women will be receiving the Ruth Bader Ginsburg Medals of Honor.
A world ruled by law and not by force is the key mission of the World Jurist Association. Promoting the rule of law worldwide is a key enabler for progress in all other policy areas.
Andrew Young is a powerful voice of peace.
So I want to thank you for your faith in justice and your willingness to work for peace.
On behalf of the World Jurist Association, welcome again to New York.
What an honor to receive this award on behalf of the European Commission. And this on the occasion of the 60th anniversary of the World Jurist Association, a network of jurists that would defend fundamental rights and the rule of law across the world as a contribution to global peace. 60 years on, you are still faithful to your foundation and your principles. And I want to thank the World Jurist Association not only for this recognition, but for your enduring service to all humanity.
This is a consequential moment, and it calls for thoughtful leadership and strong institutions. And I cannot think of a better embodiment of those than Ursula von der Leyen and the European Commission. You show us how respect for the dignity of all leads to the strength to protect peace, no matter what. And this is what we honor today.
I would like to pay tribute to 2 jurists from the US who, together with Sir Winston Churchill, set out to mobilize the international legal community in order to promote the rule of law over the rule of might. To this purpose, they founded the World Jurist Association. The legacy of these 2 men, Charles Ryan and Earl Warren, must be preserved and handed down to future generations.
The American Bar Association is enduringly proud of the contribution of our former president, Charles Ryan, in founding the World Jurist Association, and it is my honor to introduce again the president of the World Jurist Association and the president of the World Law Foundation, Javier Cremades. Javier.
Thank you. President of the Constitutional Court of Spain, Sonia Sotomayor, Juan Luis, acabo de llegar, Juan Luis Cebrián. All my dear friends, President of the German Constitutional Court and President of Dominican Republic Constitutional Court, President of Slovenian Constitutional Court, President of the Guatemala Constitutional Court, of the Albanian Romanian Kosovo Constitutional Court, Slovenian Supreme Court, Polish Supreme Court, distinguished trustees of the World Law Foundation, dear Patricia, dear Deborah, dear Vivian, President Levitz. It's amazing and it's very emotional to see the impact that this recognition has in a true hero of the rule of law. So Anthony Kennedy is 94 years old, and he's still full of passion. And his passion is set up in these bookmarks about the rule of law. He said to be contagious, to be to be living in a world ruled by laws and not by force, and to be living in a world where every human being has an oxygen, can breathe in an atmosphere that can protect their dignity, their freedom, their being as a human, as a member of this family, we human beings. So what we are doing today is, as King Felipe said in New York a few months ago, is to continue this campaign of remembering what is the purpose of a real society: fair treatment for equal citizens. And this starts by limiting the power by the Constitution, by the laws. So it is very critical that not just we members of the legal community, but every citizen understands that there are their own rights, and the Constitution is the only way to protect themselves from the abuse of power of anyone who has a power. So what we are doing today is learning from that generation that started this program when the world was at risk at war. We are not anymore at risk of war. We are at war. We have different wars. And this threat should be fought only by the rule of law. That was the weapon that these three gentlemen imagined almost 65 years ago. And they used the word pierce the iron curtain, perforar el telón de acero. So the iron curtain was there, but there was a way. And they started to talk. And they started, we had lunch 2 hours ago with the president of the German Constitutional Court, and we remember in 1985, 4 years before the fall of the Iron Curtain, this community of lawyers, judges and professors, they went to, that time, Eastern Berlin, Berlin East. So it was divided, the city was divided, the country was divided, the world was divided. But we control our relationships, and we decided at the time to establish, they decided to establish relationships and work together with countries like Russia, like China. That's what we want to keep doing, to be persons of peace through law. Anthony Kennedy is a person of peace. He's a free person that found a purpose and work. His whole life has been devoted to that purpose, which is to promote the rule of law. But if you are a tax lawyer, if you are a district judge, or if you are an associate professor in a university in Turkey, or whatever, you are also an architect of the rule of law. You are an ambassador of the rule of law. So we quoted this morning Professor Heberle, without the participation and adhesion of the community, there is no rule of law. We can have the best constitution, the best courts, but if people are not supporting and adhering the decision of the courts and the drafting and the provision of the laws, it is not going to work. So today, the threat is not anymore on the other side. The threat is inside, and not just Spain, but US, UK, Israel, Brazil, anywhere the discussion, Mexico, is about the rule of law. So the Japanese, we had this morning a Japanese speaker. The Japanese invented what they called quality circles. It was after the Second World War, and it was part of their miracle. Quality circles mean let's focus and let's repeat what works. Don't focus on what doesn't work. We need to correct what doesn't work. We need to penalize what doesn't work. But we don't want to establish the conversation about what doesn't work. Let's focus on what works. And that's the purpose, to make and organize this tribute to Anthony Kennedy. He could be a person that works for us. So it has been very complicated to organize this. 3 videos from Anthony Kennedy, one in the opening. We just heard another one about his concept of the rule of law. Now he's going to speak via Zoom. John Roberts' participation through video. You all came from different countries, president of the Constitutional Court flew yesterday night. He's flying today night. So very complicated. You are coming from different countries, 25 different countries in this room. But it's worth, because we found someone can be an inspiration. Someone who is really a role model of integrity and devotion to the rule of law. So let's go on. Let's try to connect not just with the ideas of Anthony Kennedy, but with the personality, with the person of Anthony Kennedy. We did that in 2020 with Ruth Bader Ginsburg. I don't agree with everything that Ruth Bader Ginsburg thought. I don't agree with everything, probably with nobody, even not with my wife, especially with my wife here, Arancha. But I really admire them, and I love them, because they were really role models. I was handing to Sonia Sotomayor the book that we are very proud to have translated into Spanish, my own words. And I was sharing that with with President Herbert. That is very interesting, because you learn a new life. You learn someone who came with a Hampton family, coming from all over, from the Eastern Europe, as a Jewish member of a family, and how the system works. Social system, educational system, legal system, and you learn her struggle to find a path in life, her struggle to make something that of impact for others as well. So she had a purpose. Probably at that time we didn't talk about purpose as much as we do today. She had a purpose from the beginning. Anthony Kennedy, he had a purpose from the beginning. We will see that in the video that we have prepared for him. And I said to the incredible staff of the World Jurist, what about these old images? You know, we don't see them very clear. I say, no, but we should put them, because this guy is not who he is today, it's what is today, and what he has done from the early years of his career. So let's enjoy these few minutes where we're going to be celebrating his life. I remember his emotion when he came to New York, to the United Nations building, to be with us in the World Congress of July 2023. You saw there was the President of the European Commission, you saw the Prime Minister of Canada, different head of states from Latin America. What he wanted was to meet the king, the Spanish king, because something that you don't have in the US, you don't have a pope and you don't have a king. We don't have a pope, but we have a king. And you also mentioned to me what the impact that he really makes. So we are very lucky to have Anthony Kennedy with us. He wanted to be here, and tomorrow the idea was the king would be handing the medal to him. So 3 weeks ago he called me, and he told me, Javier, you know, I had all the tickets, my wife, my grandson. I cannot move easily from one room to another, so I cannot come. So then I suggested the idea. Candido told me, Sonia is going to be here on the 4th of March. What a coincidence. And I told Anthony, call Sonia and ask her to receive it for you. And so he did. And Sonia is here, very, very grateful. We're very, very happy. You represent the same thing that he represents in a different way. And we all follow what you're doing. We all respect you, admire you. I told you, you're a public figure, at least among us. And very happy to have you here, and very also humble that you are coming here to receive an award, not for you, for Anthony Kennedy. This express how is the collegiality in your court and how is your heart. So thank you very much, and let's go on. Thank you very much.
We need to pause for just 1 minute to move furniture. Video next. Ready for the video? Okay, all right. We're going to begin with a video clip that will put us in mind of why Justice Kennedy is so incredibly deserving of this important award. You can run the video. Thank you.
Un cordial saludo a todos los participantes presentes en este evento especial en Madrid, and greetings to leaders and friends of the World Jurist Association as you award the WJA Medal of Honor to Justice Anthony M. Kennedy of the Supreme Court of the United States. Justice Kennedy is a fitting honoree for WJA because he is a tireless and committed advocate for the rule of law as the path toward world peace. In 1963, he started practicing law in his hometown of Sacramento, California. The same year, Earl Warren, one of my predecessors as Chief Justice of the United States, helped lead the inaugural Congress of the WJA. Tony Kennedy became a judge 12 years later, in 1975, and over nearly a half-century on the bench, he has exemplified commitment to the highest ideals of the law. Like WJA, Justice Kennedy has worked to foster common cause across borders. He has traveled around the world to learn, to teach, and to help build an international community of respect for courts and the judicial process. He is a good listener who has remained curious and humble despite his towering contributions in the United States. And the WJA has chosen a fitting day to honor Justice Kennedy. 235 years ago, on March 4, 1789, the new Constitution of the United States came into effect. Justice Kennedy has been a guardian of that founding charter throughout his career. Today, I join you in celebrating him as a model of judicial decency and a champion for the friendships and cooperation that bind lawyers, judges, and other citizens of countries around the world. Congratulations and thank you to the WJA. Congratulations and thank you to Justice Kennedy.
Hello, I'm Mary Smith, President of the American Bar Association. My thanks to the World Jurist Association. On behalf of the ABA, I am pleased to continue our collaboration with the World Jurist Association, an alliance ignited by the peace through law vision of former ABA President Charles Rhyne. The WJA was born from the belief that the world should be governed by law, not by force. With the tide of autocracy surging around the globe, the WJA's dedication to this belief is more critical than ever. I also want to thank the World Jurist Association for highlighting judicial independence and the rule of law at today's tribute to Justice Anthony Kennedy. I want to congratulate Justice Kennedy for receiving this honor and for his commitment to the promotion of peace through law and the rule of law as a guarantor of freedom. Justice Kennedy's tenure on the Supreme Court exemplified a steadfast dedication to judicial independence, and his meticulous balancing act between individual rights and governmental powers not only fortified the judiciary, but also paved the way for a more just and harmonious society. I extend my best wishes for a truly inspiring event.
I look forward, and I know Judge Kennedy is looking forward, to prompt hearings conducted in the spirit of cooperation and bipartisanship. I'll do everything in my power as president to assist in that process.
I share with you, Mr. President, and with each member of the Senate, an abiding respect for the Supreme Court, for the confirmation process, and for the Constitution of the United States, which we are all sworn to preserve and to protect. Thank you, Mr. President.
Thank you.
It is the purpose of your meeting and of this meeting to enhance that discourse and to find better ways for all of us to make sure that the rule of law does not slip away, that it does not slip away through direct attack or through indifference.
It's thought. It's central to our American tradition. It's central to the idea of the rule of law. And that is that there is a zone of liberty, a zone of protection, a line that's drawn where the individual can tell the government, beyond this line you may not go. The whole lesson of our constitutional experience has been that a people can rise above its own injustice, that a people can arise above the inequities that prevail at a particular time.
We are united in this idea that we have a moral framework that we share and that unites us in the rule of law. Every judge, every day, in every case, must ask himself, must ask herself, who am I? Why am I about to rule this way?
Remember that the essential feature of separation of powers, which is that there is a politically accountable branch of the government in the Congress, and a non-politically accountable, except in the most indirect sense, in the courts.
Our obligation is to define the liberty of all, not to mandate our own moral code. Liberty gives substantial protection to adult persons in deciding how to conduct their private lives in matters pertaining to sex. I do not think that there is a choice between order and liberty. We can have both. Without ordered liberty, there's no liberty at all. And one of the highest priorities of society is to protect itself against the corruption and the corrosiveness and the violence of crime.
The fact that even though he identifies as a conservative Supreme Court justice, he was the swing vote in a number of incredibly important cases over the last several decades.
Humans are fallible, we tend to err, but law and literature both show us ways in which we can progress and mend our ways.
Your duty in every case is to ask, why are you doing what you're about to do? What are the reasons? And even if you've done it 100 times, you have to ask what those reasons are again and see if they are still valid. That's what you must do. It's introspective. And you owe that. You take an oath that you're going to listen to each side. And if you make up your mind in advance, you're not following that oath.
Just minutes after Justice Anthony Kennedy announced his retirement.
Thank you, Mr. President.
After 30 years serving on the Supreme Court, the moderate and many times key swing vote for liberals says he'll leave at the end of July.
I can be so strong and so certain of my views.
We must care about the rule of law. We must care and teach the meaning of human rights, which is the heritage of freedom. Thank you very much.
Please join me in welcoming back to the podium Stefan Harbart, President of the Federal Constitutional Court of Germany, to the podium to deliver the laudatio for Justice Kennedy.
Dear President Cremades, Justice Sotomayor, President
Conde Pompeo, ladies and gentlemen, and above all, esteemed Justice Kennedy. There is no doubt that anyone who belongs to Anthony Kennedy's generation has experienced a great deal of fascinating things. This also includes the experience of something one can describe as bilocality, or being in two places in the world at the very same time. Today, both at home and at the other end of the world in Madrid at a ceremony in one's own honor. Justice Kennedy, I would like to first extend my very best wishes to you for your continued and speedy recovery. And let me also express my sincere thanks to Justice Sotomayor for joining us in Madrid for this special occasion today. Today we celebrate and honor a jurist who is among only a small group of justices with a tenure of over 30 years on the Supreme Court of the United States of America, and who, according to countless contemporaries, has shaped the court term for term like few others in its long and distinguished history. In short, today we honor an exceptional, indeed a truly great jurist. I wish to also extend my thanks to the World Jurist Association for hosting this conference and ceremony. It was with greatest pleasure that I accepted the invitation of the World Jurist Association to offer this tribute today to Justice Kennedy. It might be somewhat surprising that this tribute be given by someone who belongs to both a different generation of jurists, one which, at the time Justice Kennedy took his oath of office, was still in secondary school, and to a different continent. The decision of our hosts to entrust today's appreciation to a younger generation from a different part of the world is no doubt a sign of the exceptional impact of Justice Kennedy's legal legacy on jurists all over the world, no matter where they are, no matter which generation they belong to. That was not, however, the only reason why I immediately accepted the WJA's invitation to present this award to Justice Kennedy. I was a student in the constitutional class at Yale Law School in the fall of 1999 when I first came into contact with the incredibly impressive opinions of Justice Kennedy. At that time, it was unthinkable for me that I might one day have the chance to meet him in person. When we did, in fact, meet in his office 2 years ago at the Supreme Court, I was all the more impressed by Justice Kennedy's amiability, warmth, and attentiveness as we discussed world affairs and the state of the rule of law. Once again, Justice Kennedy, thank you very much for that unforgettable experience. When Anthony Kennedy was born in Sacramento, California, on the 23rd of July, 1936, the Second World War was yet to come. The charms of a small city with a fascinating history and rich cultural and social life, perhaps also the proximity to storied wine regions, have contributed to his lifelong attachment to his hometown. Even today, he lives in the home that once belonged to his parents. His parents, an attorney and a teacher respectively, both provided inspiration with regard to his eventual career. Sacramento's status as the capital of the state of California introduced Anthony Kennedy early onto public service, and not just through his politically minded home life. As a high school student, he was the youngest page in the Californian Senate. When the then Justice Kennedy on the Supreme Court had to reflect on the counter-majoritarian difficulty, he was able to draw on this earlier glimpse into the inner workings of the legislative branch. Anthony Kennedy studied at Stanford University in his native state, California, and kept his bachelor's degree with a year at the London School of Economics. In 1961, after exchanging the Pacific for the Atlantic coast, he obtained his law degree from Harvard Law School. Not long thereafter, Anthony Kennedy, who had spent a year serving in the National Guard and was working as an attorney, took over his father's well-established and flourishing law practice in his hometown after his father's untimely death. From this time period, Anthony Kennedy knows of the human stakes involved in legal proceedings from personal experience, which likely influenced his disinclination for all forms of dogmatic rigidity. The brilliant lawyer was also drawn to teaching in addition to the practice of law. In 1965, he began teaching constitutional law at the McGeorge School of Law in Sacramento and continued this work until 2019. He was an enthusiastic and inspiring professor and is, with 54 years of teaching, the longest-serving professor at the McGeorge School of Law, which, thanks to his efforts, has developed into a widely known and highly regarded law school. The work of Anthony Kennedy has been honored with, just to name a few examples, the Anthony Kennedy Endowed Fellows Program at McGeorge and the Justice Anthony M. Kennedy Library and Learning Center at the Robert T. Matsui United States Courthouse in Sacramento. In 1975, at the age of 38, Anthony Kennedy was appointed on the nomination of President Gerald Ford to the United States Court of Appeals for the Ninth Circuit, at the time the youngest appointee ever to a federal court of appeals. In 1988, Anthony Kennedy was nominated by President Ronald Reagan under somewhat challenging circumstances as an Associate Justice of the Supreme Court of the United States, and he was overwhelmingly confirmed by the United States Senate with a vote of 97 to 0, with the average tenure of a Supreme Court justice being about 16 years. Such a term of office is not so difficult to imagine for those of us justices elsewhere who are appointed for fixed terms. It pales in comparison, however, to Justice Kennedy's tenure. For over 30 years, he served as an active member of the United States Supreme Court. If I were merely to list the most well-known decisions of the Supreme Court during Justice Kennedy's tenure, it would take so much time that we would seriously endanger the further progress of this ceremony today. Even just limiting the decisions to only those on which the international news media reported on the opinion of Justice Kennedy, the list is impressively long. Not even a multi-day symposium would be enough to cover all the significant chapters of such an exceptional biography in the requisite breadth and depth. And any attempt at packing everything into a brief summary is ultimately bound to fail. Dear Justice Kennedy, there are just simply too many extraordinary moments and aspects in your life. So I hope you will forgive me if I, somewhat at the expense of our honoree, limit these remarks to a few highlights of his far-reaching jurisprudential influence and concentrate on the topic of freedom of speech, Justice Kennedy's role at the Supreme Court, and the substantial impact Justice Kennedy has had outside of his home country. It could well be said that freedom of speech is a favorite legal topic of Justice and Professor Anthony Kennedy, who has reminded us that freedom of speech includes criticism of the state and that democracy requires a tolerance of words or ideas that may be viewed as repellent. Or, as he put it himself, inconvenience does not absolve the government of its obligation to tolerate speech. The freedom of individuals from state limitations is a thread that runs throughout Justice Kennedy's opinions. As a well-read individual Anthony Kennedy has compiled a list of works originally intended for his grandchildren that is dedicated to the subject of freedom. The works on this list range from Plato to Mark Twain and even include a number of Hollywood movies. They all have the common theme that, in the words of Chief Justice John Roberts, liberty is not merely freedom from restraint, but requires the exercise of both individual conscience and public responsibility. The words of Justice Kennedy from a meeting of the Salzburg Global Seminar, "We all are trustees of freedom," is still today a timely admonition. The unprecedented media attention to Justice Kennedy's announcement that on the 31st of July 2018, he would be ending his active status on the court reverberated around the world. This was not only due to the groundbreaking decisions of the Supreme Court during his tenure, among them cases concerning discrimination against homosexual persons, the application of the death penalty for juvenile offenses, the freedom of religion, and many more. The public reaction was due not least to the fact that Justice Kennedy, who had been acknowledged by his colleagues at the court as one of the most consequential jurists in recent years, was viewed in the public eye as a justice who, throughout many terms of the Supreme Court, occupied the median and whose position was thus decisive for countless decisions. According to the calculations of one of his colleagues, Justice Kennedy authored more than 500 opinions, many for the court and others as a concurrence or a dissent. They offer an almost unfathomable wealth of judicial analysis in all matters of cases. Justice Kennedy's opinions have been debated in countless law reviews as well as in the papers of record and many other fora. In an extensive profile of the early years of his tenure, the New Yorker dubbed him the agonizer. With this moniker, which alludes to the agony of a jurist that is either unseen or little understood by the general public, the article identified both the heavy burden and, perhaps unwittingly, one of the most integral aspects of judicial service and a testament to judicial responsibility. In 2012, Justice Kennedy was on the cover of the world-famous Time magazine, we saw it, which described him simply as the decider. This characterization may also be a reflection of Justice Kennedy's commitment to the duties and the function of the judiciary, which he has always done with verve and passion. From the perspective of the international legal public interested in the case law of the Supreme Court, the characteristics of Justice Kennedy's jurisprudence that stood out were, beyond the sheer statistics, his impressive rhetorical gifts and the manner in which his opinions trace the decision in a case back to the ironclad principles of the Constitution, which naturally makes them especially instructive. In the words of Justice Elena Kagan, quote, "What makes Justice Kennedy such an important figure, his independence, his integrity, his unique and evolving vision. Far from swinging between positions defined by others, Justice Kennedy has consistently chartered his own course," end quote. The loyalty of a judge to the law alone was something that Justice Kennedy made clear to the public by emphasizing that judges must sometimes reach decisions that they do not personally agree with in order to respect the law and the Constitution. The esteemed recognition that Justice Kennedy receives far beyond the borders of the United States of America, something accorded to very few jurists worldwide, is not just on account of his illustrious career in the US justice system. The source of this worldwide esteem is the outstanding service he has rendered to the international legal community over the decades. Even as a young attorney, Anthony Kennedy worked on cases that spanned international borders which was by no means a matter of course for a law firm outside the major cities in those days. As a judge on the Court of Appeals for the Ninth Circuit, the then Judge Kennedy seized the opportunity to see the world beyond the water's edge by accepting an appointment to serve as supervisor of the territorial courts of the United States in the South Pacific. In a number of his opinions for the Supreme Court, Justice Kennedy steadfastly, even in the face of criticism, nudged the perspective of the Supreme Court of the United States towards, as he put it, the values we share with a wider civilization and some underlying common shared aspiration existing across different legal systems. And I fully agree, glancing back and forth between one's own legal system and a foreign one, reflecting on the similarities and on the differences, is a fruitful way of developing greater insight into one's own law. Comparative law makes it temporarily possible to observe one's own legal system from a distance. The view from the outside allows one to get a better grasp of one's own law and provides the court with a reservoir of arguments. More powerful still may have been Justice Kennedy's advocacy for the rule of law on countless missions and teaching engagements outside his home country. Shortly before his appointment to the Supreme Court, Anthony Kennedy began his decades-long participation in teaching the summer program of his McGeorge School of Law in Salzburg, Austria, presumably combining this summer job with visits to the famous Salzburg Music Festival. Justice Kennedy's tenure also took place during a time of great upheaval in the world. With the fall of the Berlin Wall, if I may use this as a shorthand to describe how the world has changed since the end of the 1980s, there was an urgent need for guidance on constitutional law in many places in the world, for which Justice Kennedy, with great generosity, volunteered his time and expertise. The rule of law would become an overarching theme in his life. Justice Kennedy exalted, defended, and explained the rule of law not only to citizens of the United States of America, but also as an emissary in the wider world, whether it be at the Salzburg Global Seminar of American Studies or traveling with the International Judicial Relations Committee of the United States Judicial Conference. The descriptions of his lectures as fascinating, even mesmerizing, are no doubt due, in addition to Justice Kennedy's conviction for the importance of the rule of law for freedom, to his rhetorical gift for being able to engage people directly. Justice Kennedy has also been able to demonstrate his people-oriented pragmatism on the international stage. He crafted a bookmark with a succinct, readily understandable definition of the rule of law, which has been translated into many languages and adopted for use by a committee of the United Nations. I have already mentioned that Justice Kennedy incorporates what at first glance may appear to be contradictory qualities into a collective example of a truly great jurist. One final supposed paradox should also be addressed. In view of his legal brilliance and breathtaking career, it is especially noteworthy that time and again his contemporaries do not hesitate to highlight Anthony Kennedy's demeanor as a person, his unfailing civility, obligingness, and geniality. Justice Kennedy embodies the best of characteristics, in particular the constant respect for divergent viewpoints as the foundation on which freedom of speech and opinion can take place, public discourse can succeed, and democracy can flourish. His admonitions as to the significance of civility and rationality in political debate ring especially true in these turbulent times that the world has experienced in the years after Justice Kennedy's retirement from the court. Ladies and gentlemen, Anthony Kennedy has dedicated his life to jurisprudence and to public service, and has made the rule of law the subject of this WJA's conference, which has been full of stimulating discussions, his life's work. He has championed the rule of law with limitless, in the very sense of the word, enthusiasm and spirit. We say to you, Justice Kennedy, from the heart, thank you. Thank you for serving as a role model for jurists all over the world. Dear Justice Kennedy, on behalf of myself and for all of us, congratulations on receiving the Medal of Honor of the World Jurist Association. We wish you good health, together with your family, your wife, your children and your grandchildren, and the opportunity for future exchanges with you, hopefully soon again in person. Dear Justice Sotomayor, it is now my great honor to invite you to the stage to accept the Medal of Honor on behalf of Justice Kennedy.
I'm sorry.
Do you want him to speak?
Yes.
He's on a video conference.
Oh, so I should wait?
Do you want to? No, go ahead and then he speaks.
Oh, okay. All right. Thank you. I acknowledge and greet the distinguished president of the World Association of Jurists, Dr. Javier Cremades, fellow presidents and judges of courts of different countries, presidents of the ABA and of international bar associations, eminent professors and jurists, authorities and friends. Estoy encantada de estar aquí con ustedes y es un honor de poder recibir el premio en nombre de mi colega Justice Anthony Kennedy. Él tiene un tremendo respeto por esta asociación y sus miembros y sé que él quiere mucho estar con ustedes personalmente. The justice's doctors, for health reasons, however, advised him not to make this trip to Spain, as was his fervent wish. He told me to tell you that he will see you in Santo Domingo. Justice Kennedy is a dear friend of mine and a man who reveres the rule of law and the men and women who devote themselves to upholding its values. I express my congratulations to my friend Justice Kennedy for the award of the Medal of Honor of the World Jurist Association in recognition of his entire career, which he spent dedicated to strengthening and defending the rule of law and judicial independence as guarantor of peace, freedom, and the dignity of human beings. Now, you know the symbolism of him receiving this award. This organization was started, as you know, by Earl Warren, one of the most famous Chief Justices of the Supreme Court in the 20th century, and by the first president of the ABA, Charles Ryan. They reflected, through their motto, peace through law, their deep belief that the rule of law was the guarantor of peace. I am also proud to participate in this ceremony in the auditorium of the World Jurist Association and the World Law Foundation, which bears the name of another one of my friends, Ruth Bader Ginsburg. These are justices who have fought for the guarantee of fundamental rights, equality, and freedom of all citizens. I respect you all for your commitment to continue upholding the rule of law as the only alternative to the rule of force. And to this end, it is imperative to guarantee the supremacy of the Constitution and the independence of courts as the backbone of the law. Without them, the most essential rights and freedoms of our societies are seriously endangered. As His Royal Majesty King Philip VI emphasized when he received the World Peace and Liberty Award in 2019. And as history teaches us, quote, without respect for the laws, there is neither coexistence nor democracy, but insecurity and arbitrariness. As Justice Anthony Kennedy always reminded us, under the umbrella of the rule of law centered on the dignity of the human being, quote, the law is superior to government and obliges government and all officials to comply with its precepts. Let me, Justice Kennedy, convey the very warm greetings from His Majesty the King Philip VI, with whom just this morning I had the opportunity to hold a private meeting. And he was very excited to be able to greet you personally when you were in the UN. He remembers you very fondly. Congratulations, Tony. Congratulations to the World Jurist Association. Gracias otra vez a ustedes por todo lo que hacen por el Estado de Derecho. Thank you.
All right, it is now my high privilege to welcome, hopefully through the miracles of modern technology, live from the United States Supreme Court, our extraordinary honoree, Justice Anthony Kennedy. Justice Kennedy, you have the floor. Thank you, Justice Kennedy. And now I ask to the stage as witnesses to the bestowal of the award, Justice Candido Conde Pompido, President of the Constitutional Court of Spain, President Javier Cremades of the World Jurist Association, President Harbart of the Federal Constitutional Court of Germany, and my high privilege to welcome Justice Sonia Sotomayor, Associate Justice of the Supreme Court of the United States, who is accepting the award on behalf of Justice Kennedy. President Cremades, as you bestow the World Jurist Association Medal of Honor to Justice Kennedy, for his commitment to the independence of the judiciary and the defense of the rule of law in America and worldwide. Thank you, Justice Sotomayor, for receiving this honor on behalf of Justice Kennedy. President Pompido.
I'm going to speak Spanish. Excelentísima señora Sonia Sotomayor, magistrada del Tribunal Supremo de los Estados Unidos. Excelentísimo señor don Javier Cremades, presidente de la Asociación Mundial de Juristas. Excelentísimos señores presidentes, vicepresidentes, magistrados y magistradas de los tribunales constitucionales supremos y supranacionales que nos acompañan. Miembros del Comité Organizador del Congreso Mundial de Derecho, autoridades, señoras y señores. Quisiera empezar mi intervención señalando la satisfacción que supone para mí encontrarme con todos ustedes en la clausura de la sesión inaugural y en la antesala del próximo Congreso de la Asociación Mundial de Juristas que celebrarán el próximo año 2025 en la capital de la República Dominicana. Y en este acto tan entrañable en que se ha producido un homenaje al excelente magistrado don Anthony Kennedy. Agradezco sinceramente al presidente de la asociación, don Javier Cremades, su amabilidad por invitarme a participar en este evento que reúne a prestigiosos juristas y operadores jurídicos de todo el mundo. Asimismo, hago extensivo este agradecimiento al comité organizador del evento y les felicito por su trabajo. Y, por supuesto, me gustaría trasladar mi felicitación a mis colegas del Poder Judicial de la República Dominicana, país en el que siempre me encuentro como en casa y quienes tendrán el honor de organizar el próximo Congreso. Un cometido tan ambicioso como el de organizar un Congreso Mundial siempre es causa de admiración por los desafíos que entraña, y hablo desde el pleno conocimiento porque el Tribunal Constitucional Español se ha embarcado en una aventura similar tras nuestra elección como anfitriones del 6º Congreso de la Conferencia Mundial de Justicia Constitucional, que tendrá lugar el próximo año 2025 en Madrid y que reunirá a los más altos representantes de las jurisdicciones constitucionales de 121 países. Teniendo en cuenta lo anterior, valoro con afecto y reconozco con aplauso la labor continua de la Asociación Mundial de Juristas, que viene desarrollando desde hace más de 60 años, siempre con el firme objetivo de fomentar el diálogo cooperativo sobre la paz mundial, el Estado de Derecho y el sistema de justicia. Estas son algunas de las razones por las que lamento no haber podido acompañarles durante las sesiones de trabajo que han mantenido en el día de hoy, pero como quizá ya sepan, este evento ha coincidido con el acto organizado por el Tribunal Constitucional, en el que hemos tenido el honor de contar con la participación especial de la magistrada del Tribunal Supremo de los Estados Unidos, la señora doña Sonia Sotomayor. Casualmente, este año la Asociación Mundial de Juristas ha decidido otorgar la medalla de honor al magistrado emérito del mismo Tribunal Supremo de los Estados Unidos, don Anthony Kennedy. Dada la imposibilidad del magistrado de participar personalmente, le hemos visto y quiero acompañarle en este aplauso y felicitación que le ha dado todos los personales presentes en este momento. Aprovecho para transmitirle mi más sincera enhorabuena por este galardón en el que se le reconoce más si cabe su trayectoria profesional en el mundo jurídico a nivel internacional. Con ello, el magistrado Kennedy se une al elenco de grandes juristas estadounidenses que han recibido esta distinción y, por qué no decirlo, también al Tribunal Constitucional, porque la asociación en el año 2019 otorgó la medalla de oro al propio Tribunal Constitucional con carácter colectivo para todos sus magistrados en la Asamblea General celebrada en Málaga. Señoras y señores, el lema de la Asociación Mundial de Juristas, la paz a través del derecho, me genera una pequeña reflexión. La paz es una cuestión que, entendida más allá de su sentido negativo, como ausencia de conflictos, también nos incumbe a los operadores jurídicos siempre dentro de los límites de nuestras propias competencias, ya sea a través de la creación o aplicación de las normas, o mediante su interpretación o control. Todos los operadores jurídicos afectamos e incidimos en la protección del Estado de Derecho y los derechos fundamentales y con ello en la resolución pacífica de cualquier tensión social. Al fin y al cabo, toda la historia de la humanidad no es más que una larga marcha para la solución de conflictos desde la fuerza hasta el derecho. El derecho como instrumento de solución pacífica de conflictos es el que acaba creando precisamente el Estado de Derecho y la independencia de los tribunales. Un ejemplo de ello es la Constitución española, nuestra ley de leyes, que el pasado 6 de diciembre cumplió 45 años y que es un tesoro jurídico más valioso que tenemos los españoles. Desde este espíritu, España ha llegado a ser una de las más consolidadas y abiertas democracias del mundo. El constituyente previó expresamente que el consenso que dio lugar a la Constitución podría derivar también en debates, contrastes y puntos de vista enfrentados propios de las sociedades democráticas plurales y abiertas. Y de esta preocupación nació la necesidad de establecer normas vinculantes para todos los poderes públicos y la creación del Tribunal Constitucional que actualmente me honro en presidir. En este sentido, el Tribunal Constitucional de España es consciente de la responsabilidad que la Constitución le encomienda como intérprete supremo y guardián jurídico, guardián de la libertad, como se expresa en el frontispicio del Tribunal Supremo de los Estados Unidos, que se refiere precisamente a Justice, Guardian of Liberty. Señoras y señores, vemos que el Estado de Derecho, el imperio de la ley y la paz son conceptos estrechamente ligados. Somos conscientes de que no puede existir democracia ni paz sin disfrutar de los derechos humanos, como tampoco puede haber tal disfrute sin el respeto escrupuloso de la Constitución y de la ley democrática. Como condición necesaria para alcanzar el más alto nivel de protección del Estado de Derecho, los operadores jurídicos, los órganos judiciales y los distintos poderes tenemos la obligación de preservar la separación de poderes y la independencia judicial. La independencia judicial es la base de la confianza en los tribunales y constituye una garantía con la que deben contar los ciudadanos para la resolución pacífica de los conflictos. Solo garantizando esta independencia transitaremos por el camino adecuado hacia la paz y hacia la convivencia social en libertad. Queridos colegas, termino ya. Nuestras instituciones se han esforzado por alcanzar la preeminencia de la ley sobre la arbitrariedad, la preeminencia de la pluralidad sobre la exclusión y la preeminencia de la igualdad sobre la desigualdad. Creo firmemente que los juristas y los operadores jurídicos necesitamos confiar en el derecho y en la legitimidad de su misión y esta confianza solo se puede alcanzar cuando la ley resulta producto de la razón y es consentida por todos, cuando la ley se revela útil y cumple su función ordenadora, cuando la ley es apreciada como un factor de progreso y de paz social, y, en definitiva, cuando la ley preserva y promueve los derechos del ciudadano y al mismo tiempo favorece al conjunto de la sociedad. Continuemos esforzándonos por no perder este legado que la Asociación Mundial del Derecho está empeñada en reforzar de manera continuada, y debemos todos agradecérselo y a su presidente, aquí presente, don Javier Cremades. Debemos mejorar y enriquecer nuestro legado de siglos que ha construido el Estado de Derecho, teniendo siempre presentes nuestros principios y valores constitucionales en nombre y en beneficio de todos los ciudadanos. No cabe, por tanto, ninguna duda de que el derecho es el camino adecuado hacia la paz. Y finalizo, por tanto, esta intervención deseándoles los mejores éxitos en el Congreso Mundial de Derecho que tendrá lugar el próximo año en la República Dominicana, a cuyo presidente o expresidente del Tribunal Constitucional saludo atentamente, y a su presidente, nuevo presidente, efectivamente también. Muchas gracias a todos por su atención.
Well, we have come to the end of what has been an extraordinary day and a very special day to honor Justice Kennedy, such a defender of the rule of law. Thank you to our speakers. Thank you to all of you who attended. I look forward to seeing you this evening at 8:30 at the gala dinner, and a reminder that tomorrow at 5 o'clock is our final session. Thank you and good night.
Ladies and gentlemen, we are starting the session. Some housekeeping matters. Please turn off or silence your phones. Also, as a kind request to our speakers, please note that you are limited to 5 minutes and we're a bit late getting started. So please confine your comments to 5 minutes. Buenas tardes. Ciao, good afternoon, guten Tag, dzień dobry, Masa al-Khayr, Mesik Wilhelm, President Javier Cremades, Mohammed Al-Issa from Saudi Arabia, presidents and justices of the Constitutional and Supreme Courts, and delegates from more than 24 countries are gathered here today. Welcome. It is my honor to welcome you to the second day of the celebration of the World Jurist Association tribute to Justice Anthony Kennedy, Senior Justice of the United States Supreme Court. He is an example to all of us who are defenders and supporters of the rule of law globally. I am Kim Quarles. I'm the Executive Vice President of the World Jurist Association, and I will be your host this afternoon. Throughout the history of the World Jurist Association, it has been a tradition of ours to host a panel on religions because we believe that through religious interaction and peace, we then support the rule of law. It is that respect for all religions that brings us here together today. So, this panel will discuss religions for peace, advocating for moderated and free practice. So without further ado, I call to the stage Vivian Redding, who will be moderating this panel. Vivian is the Vice President of the World Law Foundation and also a former commissioner of the European Commission. Vivian, I welcome you to the stage. Also, Mohammed Isaac Saka from Argentina, He is the chief rabbi of the Sephardic community of Buenos Aires and president of the Menorah World Organization for Youth. Gerardo del Pozo from Spain, who is the professor emeritus of San Damasio University, and Abdul Latif Al-Rutag from Saudi Arabia, who is the secretary of International Commission of Jurists of the Muslim World League. Ms. Redding, to you.
Thank you very much, dear friend. Dear all, the teaching of yesterday has shown us in a clear and very profound way democracy, rule of law, and human rights are together and they form the modern state order. Individual liberties are the base of the rule of law, and these individual liberties bind governments, which have the responsibility to preserve dignity, equality, human rights, including the freedom of religion. 60 years ago, during our first Congress in Athens, the freedom of religion was already high on the agenda. Since then, this freedom has, in many of our countries, risen to constitutional value. But since then also, these words of the Constitution and the daily reality are often conflicting. And today, well, today we live in a very uncertain time, and the regionally inspiration is not there anymore, as strong as it was times ago. We see killings by misled fanatics, and those are not an exception anymore. We see wars built on religious hatred. We see atrocities which are a blow to peace and human dignity. In this disturbed world, what is the meaning and the value of freedom of religion and of human dignity? And what is the role of the religious leaders to pacify, to avoid violence, to influence conflict resolution and peace consolidation, to lead to a dialogue, not a dialogue of words, but a dialogue of action, of deeds, and how to rely on the role of religious leaders as a force for peacekeeping. This is not unrealistic. Have we forgotten already Martin Luther King, Desmond Tutu? Have we forgotten the chief rabbi of Israel's and the chief Palestinian sheikh and the Archbishop of Canterbury, who united forces in order to set up the Declaration of Peace, which became known as the Alexandria Declaration in 2002? Have we forgotten the civil disobedience of the Buddhist monks in Myanmar, pushing back the violence of the military regime? We should also today count on wise religious leaders, because in our society they are a trusted institution and they have the unique leverage for promoting peace and reconciliation. And this is a discussion we're going to have today. How can the political leaders be an instrument for peace and defeat the instruments of hatred? In order to discuss with us, we have Rabbi Isaac Saka. He's the chief rabbi of the Sephardic community from Buenos Aires. But most of all, he's the president of Menorah, the World Organization for Youth. We have with us Professor Gerardo del Pozo. He's professor of theology in the University of San Damaso of Madrid, and he has seen generations of young people to whom he instilled the freedom of religion. And we have, in order to replace the Muslim leader of the World League, Abdulatif al-Motlaq from Saudi Arabia, Deputy Chief Secretary General of the Muslim World League. Now I start, as you are sitting here, first with the Rabbi Saka. Rabbi, because you are the chief of a very important community, and you are tabling on the future, because you have developed a youth movement, and I suppose you are influencing that youth movement with ideas. So I suppose that you underline, and I have read your speech of 2021, where you underline religious freedom as a fundamental right, and you call for tolerance, acceptance of cultural diversity. And your speech of last year, 23, where, and I speak very bad Spanish, los hijos son la construcción de los padres, meaning that if the parents have hatreds, the children are going to have hatred too. Rabbi, how to avoid that? The floor is yours.
Muchas gracias por la presentación, gracias a los que compartimos este panel y agradezco mucho al doctor Javier Cremades por este ámbito que da en el World Jurist Association para el tema de la religión. Es una estrategia muy inteligente porque vivimos en un Estado de Derecho mundial y la religión sigue teniendo un ingrediente muy importante en la configuración de las sociedades. Y ustedes, los juristas, que son los que dibujan los caminos de nuestra sociedad, deben tener en cuenta todos estos movimientos sociológicos y psicológicos de los seres humanos que conforman nuestra humanidad. Y uno de ellos es la religión. Como usted presentó muy bien, tengo la satisfacción de venir de un país, de Argentina, de Buenos Aires, y soy rabino de la comunidad sefardí. Sefardí significa la comunidad judía originaria de España. Para mí es una gran emoción estar aquí en España, en este foro, viniendo de un país donde se construyó en base a los valores de la libertad y de la igualdad, y conjuntamente con un líder del cristianismo y del islam en España, con un judío más acá también, es como una especie de mensaje de esperanza para este mundo revoltoso y complicado que nos toca vivir. Mis bendiciones a todos ustedes por dar esta oportunidad, por lo menos de un hálito de esperanza. Y como cuentan en nuestros pagos en Buenos Aires, empezando con el tema propiamente dicho, la religión tiene un problema. La religión habla en nombre de Dios, habla de Dios, es una autoridad suprema. El problema es que Dios después también puede ser utilizado por los hombres y argumentando o invocando a Dios se pueden generar guerras, catástrofes e injusticias. De hecho, como usted nombró, muchas guerras se generaron por temas religiosos en Europa, las guerras de Europa que hubo entre protestantes y católicos, guerras entre distintas ramas de distintas religiones. O sea, la religión el derecho a creer en Dios, el derecho a tener fe, es un derecho que debe ser en algún momento controlado para que no sea manipulado después ese elemento tan poderoso que es Dios. Todo elemento poderoso debe ser regulado por la humanidad, ya sea por el derecho, por los gobiernos o por la razón y el sentido común. Entonces me gustaría contarles un cuento muy interesante que cuentan en nuestros pagos en Argentina sobre un cacique. Cacique es un jefe de los indios, ¿no? Que se muere y tiene 3 hijos. Entonces los hijos a la noche duermen, se van a dormir, y se levanta uno a la mañana y le dice a los hermanos: hermanos, tuve un sueño. Vino nuestro padre, el cacique que falleció, y dijo que yo voy a ser el que lo va a suceder en el liderazgo de la tribu. Entonces los hermanos le dijeron a este hermano: mirá, mañana en la noche, cuando sueñes de vuelta con papá, decile que venga a nosotros en el sueño y nos diga que vos sos el jefe. Porque si vos querés imponer en el nombre del Padre tu liderazgo, me tenés que convencer a mí. No lo podés hacer por la fuerza o invocando que a vos te hablaron. Este cuento popular en Argentina es cuando uno viene con una verdad establecida. La verdad, tengo que convencer al otro, no se la puedo imponer. Yo puedo tener el derecho de creer una verdad y la puedo practicar en mi vida. Y en esto está también la materia religiosa, la materia de la fe. Pero yo no puedo imponerle al otro por la fuerza. Si el otro quiere, él tiene un sueño y él quiere, entonces bienvenido sea. En relación a esto, y tocando ya un tema más filosófico y teológico, recién hablaba con el sacerdote, el profesor Gerardo del Pozo, sobre Maimónides, que también, invocando ese nombre aquí en España, que era un filósofo, rabino y médico español, judeo español, que vivió acá en Córdoba, él escribió un libro, La Guía de los Perplejos. Y él ahí, hay una frase que es realmente para nosotros, debería ser como una luz, una luminaria en nuestra vida, para esta problemática que usted también planteó y que hoy nos atañe a todos los seres humanos. Él dice que Dios le dio al ser humano, como dice la Biblia, en hebreo dice, Dios insufló en el hombre el espíritu de vida. Explica Maimónides que en realidad, bueno, no es una exégesis esto, sino es un razonamiento filosófico, racional. Los seres humanos tenemos la capacidad de razonar y de entender las cosas. ¿Por qué Dios nos dio a nosotros la capacidad de razonar y de entender? Porque a través de la razón, dice Maimónides, podemos descubrir a Dios con la razón. Cuando Dios se desvincula y uno accede a Él sin usar la razón, entonces el concepto de Dios puede estar desvirtuado, errado y hasta puede ser peligroso. La razón indica, ¿la razón qué es? El sentido común. Que si vemos que todos existimos, por ejemplo, la naturaleza, Dios, como querramos llamarlo, existimos. Si existimos es porque la naturaleza quiere que estemos. Y si yo de repente mi concepción de Dios me está diciendo que uno tiene que existir y otro no, eso contradice la razón. Entonces ese concepto de Dios es errado. A través de la razón debemos acceder al concepto de Dios. Entonces debe ser como un botón de pánico. Cuando una religión, por algún motivo que sea, porque la religión tiene también, es como una esponja que absorbe elementos políticos, intereses creados, manipulación, intereses económicos, se transforma en una herramienta que está atentando contra la razón, que es lo que se ve del cosmos, cómo funciona el cosmos, que tiene que existir el ecosistema, el medio ambiente, el respeto por las personas, por los niños, por las mujeres, por los ancianos, la ayuda al prójimo, todo eso que todos sabemos más allá del color o la ideología que tengamos. Cuando el concepto de Dios empieza a atentar contra eso, ahí significa que estamos teniendo una apreciación de Dios contraria a la razón o desconectada de la razón. Por eso Maimónides explica esto en la Guía de los Perplejos, cuando dice, nunca separes la razón. No, eso no significa que todo uno lo entiende en la fe. No significa que todo lo que no se entiende no existe, pero sí lo que contradice la razón hay que tener mucho cuidado. Estos son dos expresiones que me parece que todas las religiones, especialmente en las que estamos aquí representando ahora las religiones monoteístas, abrámicas, que nacieron del concepto de que hay un Padre creador de todos los seres humanos. Y así comienza el relato del Génesis, ¿no? Que todos, Adán y Eva, todos somos hijos del mismo Padre, todos somos hermanos. ¿Y cuál fue el primer problema que tuvo el hombre? Caín y Abel. Caín se enojó y envidió a Abel y lo mató. O sea que ya desde el principio del relato bíblico nos plantea la tradición judeo-cristiana musulmana el problema al cual estamos expuestos. Empezamos todos como una hermandad y después empiezan las riñas internas hasta llegar a las manos y hasta llegar a que Caín mate a Abel. Y eso tenemos los líderes religiosos, las instituciones religiosas, la obligación de contrarrestar y mantener siempre el espíritu de la razón que nos conduce a la fraternidad, a la convivencia y a la paz.
Thank you, Rabbi. And you have seen from the applause of the audience how much your words were deep and convincing. Now I turn to another man of words, Professor Gerardo Del Pozzo. Now you are professor of theology in an important university, and you have accompanied I don't know how many hundreds of, how many thousand students from all background, from all kind of character, from all cultures. How do you manage through your teaching to bring them to the persuasion that you have to go from concept to action, and that any peace presupposes dialogue, and any dialogue presupposes that you are listening and respecting your dialogue partner?
Bien, sí, oye, sí. Bueno, yo había traído para hablar de una cosa, pero veo que tal como está esto, ahora hay que hablar de otra, pero bueno, intentaré centrarlo. Intentaré centrarlo en relación a lo que me ha dicho el que me ha precedido. Y yo, para continuar en la línea de lo que él dice, parto de un convencimiento que yo sí que se lo suelo decir a los alumnos. Y es que la religión y la razón, si queremos la fe y la razón, tienen necesidad una de otra, para no caer en patologías. Entonces, por una parte, la religión, por unas razones muy complejas, ¿verdad? La principal de todas es que exige una respuesta total. Tiene una pretensión totalizante sobre lo que es la vida, y de ahí se pasa fácilmente, diríamos, a una especie de totalitarismo también, o no, a lo absoluto de una manera radical en todas las dimensiones. Pero también tiene peligros la razón, tal como se desarrolla en cada momento, si se separa de las tradiciones religiosas. Entonces, tanto la razón como la fe, si fe religiosa fundamentalmente, si se separan una de otra, tienen peligros de patologías. yo esto sí que se lo intento decir. A mí me ha ayudado, en relación a esto que estamos diciendo, yo me dedicaba a estudiar el tema de la libertad religiosa, diríamos, en Europa, por decirlo de alguna manera, y fundamentalmente a partir de la Revolución Francesa, que defendía una cosa que viene a equivaler a lo de la libertad religiosa. Ellos decían la libertad de conciencia y de cultos, pero bueno. Entonces, hay un autor alemán, que yo le he estudiado mucho, y que es Wolfgang Beckenferde. Este Wolfgang Beckenferde, que llegó a ser incluso, diríamos, del Tribunal Constitucional alemán, cuando se estaba discutiendo el tema de la libertad religiosa en el concilio, escribió un artículo a favor, ¿verdad? Y entonces decía él que, animando a los cristianos para que apoyaran la libertad religiosa, pues que de alguna manera el Estado moderno, laico, secularizado, de alguna manera vive de presupuestos que él no se les da a sí mismo, se los da a sí mismo. Con ello quería animar a los cristianos a que a la libertad religiosa era un bien para ello, algo que habían defendido también algunos liberales católicos del siglo XIX. Entonces era como para animar. Entonces este autor es un autor, ha tenido mucho influjo en Alemania, y al final, pues, él se queda sorprendido cuando hay algunos dentro del cristianismo que defienden que la libertad religiosa, eso es lo que está en el Evangelio. Entonces, él, que había animado con razones, diríamos, que él daba, que era la siguiente: al vivir de esos presupuestos es que hay que generar una confianza, diríamos, de alguna manera, en el bien común. Y los que podían colaborar, obviamente, eran los católicos, aunque también los demás, y también otros que tuvieran una visión. Pero si no hay dentro de la sociedad alguien que anime a mirar más allá, diríamos, de sus bienes particulares o individuales, pues es muy difícil que se pueda mantener una sociedad o el Estado por las meras leyes. Necesita también de alguna manera ese sentimiento. Él lo había dicho para eso. Y en relación con ello, la postura que tiene Ratzinger. O sea, Ratzinger en el concilio siempre defendió que la libertad religiosa era algo que estaba en la revelación. Bueno, y al final, siendo ya papa, en el primer año que fue papa, habló de una manera de esto que me dejó sorprendido. Y dijo lo siguiente, que en el Vaticano II, en la Declaración Dignitatis Humanae, el concilio hace propio un principio del Estado moderno, secularizado. Pero al hacer esto, no, diríamos, atenta contra su tradición, sino que más bien, diríamos, recoge la tradición más originaria, que luego por una serie de razones que no nos vamos a detener. Entonces, el juicio que tiene sobre lo que sucedió en el siglo XIX con las condenas es que efectivamente, ante la situación que le ponía la Constitución Civil del Clero, por ejemplo, en Francia, etcétera, no tenía más remedio que defenderse la Iglesia. Pero faltó entonces, diríamos, la claridad para, dentro diríamos, del conjunto de errores y peligros que había también para la Iglesia y para la sociedad, que traía la Revolución Francesa, el principio de la libertad religiosa, pues se podía haber afirmado. No tuvo esa claridad. Bueno, entonces, ¿qué es lo que ha pasado? Beckenferde decía que efectivamente la libertad religiosa no ha sido traída ni por la Iglesia católica, ni por las iglesias protestantes, ni por los teólogos, ni siquiera por el derecho natural cristiano, sino que ha sido traída por, diríamos, el Estado moderno, diríamos, los juristas, y el derecho natural, pero secularizado. Bueno, ¿con esto qué quiero decir yo? Que efectivamente puede haber patologías tanto de parte de la religión, por esas razones que tenemos, como por parte de la razón. Y por parte de la razón, aquí estamos hablando en un contexto jurídico, lo jurídico luego pues está muy condicionado, digamos, por las convicciones, etcétera, y suele tener una tendencia a veces a lo formal o a no tener en cuenta un conocimiento moral de la naturaleza humana, etcétera, y en este sentido pues necesita también el ponerse en contacto con esas tradiciones religiosas que luego en cada uno son de una manera diversa. En este sentido yo creo que el querer establecer desde un punto de partida de una razón abstracta, unos principios normales, es muy difícil, de una manera abstracta al margen de las tradiciones religiosas. Y esto es lo que yo quiero introducir a los alumnos, que sean sensibles, por una parte, a este aspecto que tiene la razón que cada momento se desarrolla y que sirve, diríamos, para que no tenga estas patologías que puede tener, pero también lo contrario, siempre desde la fe en que para nosotros la verdad, desde el punto de vista cristiano, pues está absolutamente clara.
Thank you very much, Professor. And now we come to Abdulatif Al-Motlaq. He is the Deputy Secretary General of the Muslim World League, and he is replacing Dr. Al-Yassa. But before I give you the words, I would like to quote what the very important Muslim faith leader Al-Yassa has said. Well, he issued continuous calls for moral leadership, and that is his words. He said he dedicated his life to healing the divides between Muslims and Jews. And by the way, he has visited Auschwitz with a delegation of Muslim leaders in 2020. And he declared, I quote, "Unity among religion, moderate, is the only antidote to political tribalism and to violent polarization." Oh, would he be listened to? So what can the Muslim League do in order that these very wise words of its leaders are not only listened to, but also followed?
Thank you. أرحب بالحضور الكرام وأسعد بحديثي عن هذا الموضوع المهم جدا، الأديان من أجل السلام، بصفتي وكيلا عن الأمين العام لرابطة العالم الإسلامي معالي الشيخ الدكتور محمد العيسى، وأمينا للهيئة العالمية للحقوقيين. أؤكد أن الرابطة، رابطة العالم الإسلامي، منظمة دولية تسعى بقيادة معالي الأمين ومثلها كذلك الجهات التابعة لها إلى أهداف تسعى لتحقيقها في العالم أجمع، ودون تمييز بين أي تفريق ونحو ذلك من الأمور. كما أن معالي الأمين العام لرابطة العالم الإسلامي لديه علاقات فعالة وعلاقات قوية مع قادة جميع الأديان في العالم، كما أنه يسعى دائما من خلال رابطة العالم الإسلامي والجهات التابعة لها لتحقيق أهداف نبيلة على المستوى الإقليمي والعالمي، ومن ذلك تحقيق السلام ونشر الفكر السليم والحماية من الأفكار المتطرفة، إلى جانب تحقيق نشر السلام والعدل، مثلها كذلك تنمية المعارف والتعارف والتعاون بين الشعوب فيما يعود عليها بالخير والنفع ويحقق المصالح المشتركة. مثلها بعد ذلك قامت رابطة العالم الإسلامي بإنشاء الهيئة العالمية للحقوقيين، وتلكم الهيئة منبثقة من رابطة العالم الإسلامي، تحمل نفس أهدافها ورسالتها للعالم أجمع دون تمييز أو إقصاء، إلا أنها ترتكز في الجانب الحقوقي البحت. نوقن تماما في رابطة العالم الإسلامي أن الجانب الحقوقي يعزز جانب السلام، ولا يمكن أن يكون هنالك سلام إلا إذا كان هنالك دعم واضح وصريح للحقوق. العالم الإسلامي ضد أي إبادة جماعية وضد ممارسة الكراهية، ويحرص ويؤكد على جانب الحقوق وتفعيلها. ولذلك نرى في رابطة العالم الإسلامي أن الأمين العام أقام مؤتمر وثيقة مكة المكرمة التي صدرت من أكثر من 1200 عالم ومفتي ومفكر حول العالم. عززت تلكم الوثيقة الجانب الديني، ركزت على جانب احترام الأديان، احترام حريات أتباع الأديان، وكذلك احترام حقوق المرأة والشباب والأقليات في العالم أجمع. توقن الهيئة التابعة للرابطة برسائل عظيمة جدا، منها تحقيق العدل والتقدم، تحرير الأفكار والعقول من كل ما يؤثر عليها، وتعزز من مفهوم احترام الأنظمة والابتعاد عن كل ما يؤدي إلى عدم تطبيقها أو التقليل منها. كما ستساهم مساهمة فعالة بكفاءاتها العالمية أخطاء ومزالق وثغرات المتصدرين للأطروحات الحقوقية ذات السجال الكبير دون امتلاكهم الأدوات اللازمة. الهيئة بدعم من الرابطة ومن معالي الأمين العام لرابطة العالم الإسلامي ستكون إضافة مؤسسية مهمة لخدمة القضايا الإنسانية العادلة، وستعمل على إبراز الجوانب الحقوقية سواء كانت في وثيقة مكة المكرمة أو غيرها من المؤتمرات التي نظمت وعقدت، وأبرزها بناء الجسور بين الشرق والغرب في مقر الأمم المتحدة في نيويورك. كما ستعمل الهيئة وتحشد كامل جهودها لمناصرة القضايا العالمية العادلة. أشكركم جميعا.
Thank you, Deputy Secretary General, and thanks the three of you for your input. I would like in the second round to bring all what you have said together, because they belong together. You have not been opposing each other, and your analysis has shown to the same direction. Now, how can this same direction be used by the three major Abrahamic religions in order to go to the same direction? And in order to persuade also the political leaders, the young people, the youth who are very quickly excited for an idea to utilize these strengths in order to work together. That means, how can you imagine, you, the rabbi, you're the professor of religion, you, the Deputy Secretary General, to do something together with your institutions so that the responsibility and the trust the people put in you could be listened together. Rabbi Seka, you said that the name of God is very often used in a bad way, and that is why there needs to be some regulation. So could you also, in your answer, tell us a little bit how you see this regulation in order to bring benefit and not to be a barrier to the free spirit?
Muchas gracias. Escuchar sabias palabras de todos que nos hacen pensar, y esta importante pregunta concreta que usted está planteando es el gran desafío de los religiosos de cómo encarar especialmente a la juventud, Yo presido una organización para la juventud menorá en el mundo hispanoparlante y todos sabemos el espíritu. Cuando fuimos jóvenes alguna vez nos entusiasmamos con cualquier cosa, no importa el nombre que sea, música, baile, trabajo, religión, política. Las hormonas están muy activas y a veces el sentido común y la razón está adormecido. Cuando se despierta ya no tenemos fuerzas a veces. Y el gran desafío de los que sobrevivimos a la juventud es atemperar el carácter de los jóvenes de alguna manera y evitar que sean manipulados a veces por las circunstancias en lo que tiene que ver con Dios, en este caso la religión. Es muy fuerte es el sentimiento religioso, el sentimiento de la fe, tan fuerte que combinado con la juventud es peligroso. Por eso los que estudian todas las religiones, me parece que tenemos la coincidencia que se habla mucho en nuestras escrituras sagradas sobre los ancianos. En las escrituras sagradas se habla sobre los zekenim, sobre las personas ancianas, que eran los que, la palabra que se utilizaba para el líder de la tribu, el líder del pueblo, era el anciano. Porque el anciano tenía ese temperamento reconciliador, esa visión racional, tranquila. Y de hecho vemos a lo largo de la historia muchos líderes que en su juventud eran revolucionarios, en su ancianidad se reconvirtieron y reconfiguraron su visión política o religiosa o de trabajo o de vida. La palabra anciano que está en las escrituras como la palabra del líder, eso se debe de alguna manera transmitir a los jóvenes. Debemos explicarle a los jóvenes sobre la importancia de la experiencia en la vida antes de tomar una decisión o de reaccionar, especialmente cuando se trata de un tema religioso. Las escrituras sagradas, también a los jóvenes hay que inducirlos a valorar la opinión del distinto. Imaginémonos una empresa, una familia, donde todos son contadores. ¿Y quién vende? ¿Y quién fabrica? ¿Y quién atiende el teléfono? ¿Y quién usa la computadora? Hace falta una diversidad de ideas para conformar una organización, que en este caso es la humanidad, que sea efectiva y armónica. Entonces la diversidad de las ideas no nos tiene que asustar. Cuando yo veo a alguien que tiene otra religión, no lo veas como con prejuicios y ya te pones a la defensiva, como antropológicamente se sabe que uno ve algo distinto y le agarra miedo. No, velo, observalo como una oportunidad para incrementar tu sabiduría, tu vida, con el conocimiento que tiene el otro y vos no tenés. El ejemplo más llamativo de esto en la Biblia es, si me permiten los colegas, es el relato de la Torre de Babel. El relato de la Torre de Babel en el Génesis cuenta algo que realmente es muy llamativo y parece una paradoja. Dice que en esa época, el relato textual dice, los hombres tenían un solo idioma y una sola idea y construyeron una torre para llegar al cielo. Entonces Dios bajó a ver y vio que así era, que tenían una sola idea y un solo idioma, y bajó Dios y confundió las lenguas. Todos conocen esa historia de Génesis. Dios confundió las lenguas. La pregunta es, ¿cómo Dios viene a separar? Si estaban todos un solo idioma y una sola idea, ¿por qué vino Dios a separar a los humanos que estaban todos unidos? Porque Dios nos está enseñando en la Biblia. Esto es una lección para implementar en nuestras sociedades. No sirve una sociedad donde todos piensan igual, tienen un solo idioma y una sola idea. Tiene que haber diversidad de ideas. Así se construye una sociedad más sana, más pacífica. ¿Hay otro que piensa distinto? Bárbaro, bienvenido sea. Entonces, el espíritu, el clima cambia. Estos son dos puntos que, ante su pregunta, me parece que podemos transmitir a los jóvenes. La ancianidad, el valor de la ancianidad, que yo sumaría a lo que dijimos antes de la razón, y el valor de la diversidad.
The value of new ideas, which change the way young people are looking at reality and observing and analyzing what is around of them. Professor, you have said that belief and reason are two things which need to go together. If not, you do not have humanity. How do you instill that into your students, and what is the result of your students? When they go out, do they have this belief and reason in one person?
Bueno, yo no he dicho exactamente eso. Yo he dicho que se necesita la razón y se necesita, diríamos también, las tradiciones religiosas. Yo no he dicho necesariamente que tenga que ser la fe cristiana, aunque desde el punto de vista sí lo creo, ¿verdad? Sino que cuando la razón se aparta de las tradiciones religiosas y morales y se cree que puede construir por sí misma la moral que va a guiar de alguna manera al mundo, eso no es posible. Claro, nosotros aquí es como que nosotros estamos educando para que no surjan fanáticos, diríamos, entre los católicos. Pero es que yo creo que el mundo en el que nosotros nos movemos, este mundo como puede ser el español, europeo, en general, yo que estoy en casi todos los países, pues no es precisamente ese el problema. El problema es que se va abandonando la tradición religiosa y se va haciendo una razón que tiene muchos peligros, y muchos peligros como puede ser, el fruto de la razón es la bomba atómica, o fruto de la razón los armamentos que hoy en día, pero eso no conduce a nada. Yo he estudiado otro tema, que es el tema del transhumanismo, que un poco menos que venga de América, pero bueno, fundamentalmente allí se ha desarrollado. Y el no tener capacidad para ver en la naturaleza humana, en la experiencia del hombre, de sí mismo, nada más que lo que es pragmático, eso lo considero yo que es peligroso. En este sentido, como digo, no es exactamente que yo tenga que decir que todos los que tienen tengan que tener fe, sino que el abrirse a la experiencia humana completa. Y esa experiencia humana completa para guiar la vida, tanto a nivel personal como familiar, es familiar o diríamos social, es muy difícil si uno se aparta de las tradiciones religiosas, que se pueden repensar, pero nada más que en diálogo con ello. Todo lo que es fruto de la mera razón, que eso es, a mi modo de ver, uno de los peligros del racionalismo moderno, todo eso puede conducir, diríamos, a los monstruos de la razón, que podríamos decir con Goya. La razón por sí misma es peligrosa siempre. Si no tiene una guía moral, es peligrosa. En este sentido, es importante, efectivamente, recordar los peligros que puede tener también la religión. La religión, la fe religiosa, la tradición religiosa, pero no debemos olvidar también los otros. En el siglo XX ha habido muchos abusos, muchos extremos, desde el punto de vista, diríamos, de las dictaduras, de la época lo que precedió a la Segunda Guerra Mundial, etcétera, y se había desarrollado mucho y más bien ya había comenzado el periodo de secularización, y se pueden llegar a extremos, la razón por sí misma, mayores. A mí una cosa que me llama mucho la atención es en las memorias de Rudolf Hess, hace unas observaciones increíbles, que en el modo de realizar, diríamos, las cosas que allí hacían los crematorios, se seguían las últimas novedades científicas. Me llamó mucho la atención, ¿verdad? Es decir, solamente con una razón instrumental se muere el humano, no se atiende al humano, no se fomenta al humano. Y en ese sentido también digo yo lo contrario, para no exagerar solamente en un aspecto.
Well, thank you very much. And now the difficulty is with our youngest member. You, Deputy Secretary General, you have now heard two wise men coming to the same conclusion, that we need dialogue. You have also said that, and you have explained that how you do the cooperation between nations and people in your own religion. Could you imagine, as a young person having heard the wise men speaking now, that this cooperation would be extended to all the Abrahamic religions?
أنا سعيد أولاً أن أكون برفقة الحاخام والأستاذ البروفيسور، أؤكد وأستفيد منهم قبل كل ذلك. أؤكد على أن التعاون بين قادة الأديان، التعاون المتزن دون انخراط ودون تجافي، مع احترام كامل لدياناتهم وحقوقهم وحرياتهم واعتقاداتهم وما ينتمون إليه. لا شك أن هذا الأمر في حال سعت إليه المنظمات الدولية والهيئات الحقوقية وقادات الأديان سيكون له أثر بالغ على الشباب وعلى جميع من يهتم في هذا المجال وعلى المفكرين، وقطعا سيكون له أثر بالغ وملحوظ، وبذلك يتحقق السلام للعالم أجمع. هنالك مفهوم يعني خاطئ أو مفاهيم خاطئة منتشرة بين الوسط الشبابي ومنتشرة ربما بين كبار السن أحيانا. متى ما عولجت هذه الأمور وهذه الأفكار بحكمة ودراية وعقلانية وحوار ناجح ومؤتمرات تقام بين الحين والآخر ويكون لها أثر فعال على الواقع، لا شك أننا سنلمس نتائجها في القريب العاجل.
Well, thank you very much for our panelists. I hope that the analysis and the calls for bringing young people into dialogue will be heard. Let me finish with a quote from Hans Küng, who said, there cannot be peace among nations without peace among religions. And I think what we have heard this evening is a good beginning, and I hope that our organization can continue this and bring this to a very concrete way of action. Thank you very much.
I would like to thank everyone for participating in this very informative and very important dialogue on how the great religions of the world work together to cooperate. To further that discussion, I would now like to bring Javier Cremades to the stand. He is the president of the World Jurist Association and also the president of the World Law Foundation. Mr. Cremades, please take the stand.
His Excellency, Secretary General of the Muslim World League, King Carlos, Vice President of the World Jurist Association, Vivian Redding, Vice President of the World Law Foundation, President of the Constitutional Court of Guatemala, Justice of Guatemala, Justice of the Constitutional Court of Uruguay, one of the most important countries in the south of Latin America, Chief Rabbi of the Sephardi community of Buenos Aires, Mayor of Madrid, Juan Luis Cebrián, President of the Environment Commission of the European Parliament, Ambassador Bastarreche, the Attorney General of Spain, Juan Ortiz Urculo, Vicente Conde, Magistrate of the Constitutional Court, President of the Dominican Constitutional Court, my friend Milton Rey Guevara, World Law Trustee Javier González, James Black, Vice President of the World Jurist Association, Antioco, World Law Trustee, World Law Foundation Trustee, José Antonio Carnevali, my dear friend, Ambassador of Venezuela to Canada, and all friends, Juan Altimas Vares, representative of the Merceros community in Spain, Gerardo, Adil, all my friends, and Luis Nasser, all my dear friends, Paolo Zambelletti, President of Constitutional Court of Kosovo, my dear friend as well, Ines, thank you for being here. We are just coming to an end and bringing this discussion over 48 hours on the rule of law. And I want to try to make a summary of what we have discussed this morning with the Spanish King. By the way, I would love to bring someone, the Secretary General, a possibility of translation, if it's possible. Jackie, please. ¿Podéis traerle un traductor, por favor?
I understand.
Okay. So this morning we had more than an hour discussion with the Spanish King. It was a great circle where we started with some points. One of the points is 60 years ago when the World Jurist Peter, thank you for being here also. When the World Jurist Association was created, the world was in tension, in a Cold War, but quite simplistic. We had a line there on continent. On one line, we had rule of law states. On the other line, we had autocracies. And there were the threat of a nuclear holocaust, but there were, again, a world where everybody knew where you stand. Today, the rule of law is not anymore the framework of the conversation in our societies, but it's the main topic. We're discussing in Spain, in Brazil, in Poland, in Hungary, in the US, everywhere. We're discussing whether the rule of law is being attacked, is going to survive, is a real rule of law. And we need to understand that we are already there, just putting together the fundamental of living together, talking about the Constitution. Has been the Constitution violated? So it's not anymore that we had bad guys outside, it's that we are divided inside. And it's some kind of declining of the rule of law or democracies, and looks like that other systems are prevailing. Another topic we discussed today is King said to us, I am truly happy to see that you have included a conversation about the role that the religions play in a democracy. And I explained to everybody that it was not our idea. From the day one, the World Law Congress in Athens included a round table with the 3 monotheist religions of the world on how can they contribute to peace. I was making the point that what are the threats on current democracies is the absence of truth, is polarization, is the disconnection of citizens with the system, and what religions teach to the people: to tell the truth, to pay taxes, to be good citizens exercising their rights. It's not the Christian one, is a Christian, is a Muslim, is a Jewish. So we need any resources available to revitalize democracy and rule of laws. Otherwise, we're just losing the feet on the floor and just having, like in the US, 70 million people think today that the current president is not legitimate. They believe that the elections were not all right, so it's a big problem. And again, we need the connection with the community. Otherwise, the rule of law is not just a constitution, formal laws, tribunals. You need, as Peter Hebele said, everybody constructs the rule of law. So we really need to have engagement again. Juan Luis was explaining today on the lunch and with the king the importance of public opinion. And public opinion is exactly the engagement of the people in the meaning and the purpose on where the society shall have to go. If public opinion is working on false facts or alternative facts, as we say, how can you make decisions? Let's imagine we are the owners of this building. And they say there is a fire upstairs, but there is no fire. And they say the mortgage cannot be paid, but the mortgage can be paid. We're going to make wrong decisions. We're going to damage ourselves. So we really need to bring together all the resources to be, again, a role model for our citizens first. That was the second point that we discussed with the Spanish king. And Secretary General also brought a point in that discussion, which is we shouldn't be just reflecting and talking, but taking action. So this is my last point of the discussion today. What we are doing here today is trying to learn from each other and remember the purpose of any jurist in the world. So we are, and there has been a current argument all the time, we are architects and ambassadors of the rule of law. Because what that generation taught to us many years ago, 60 years ago, is if we don't live in a world ruled by laws, we will live in a world ruled by force. So we better take care of our rule of law system. Because this is, and we should remember it, I remember Professor Arnold explaining the first day that rule of law democracies are anthropocentric. Human dignity is at the center. Everything is created in order to protect any single individual to live in peace and liberty, with also dignified means to develop their lives. So we need a lot of education. We had a discussion in Bologna 2 weeks ago with the World Jurist Association, and the freedom of speech has a very high standards of protection in our democracies, even higher than other fundamental rights, but because it's an institutional guarantee of the functioning of the whole system. So without free public opinion, there is no democracy. Without democracy, there is no rule of law. Without rule of law, there is no respect for human rights, the whole human rights system. So, but this digital environment now is being abused and is creating a mess inside democracy. So shall we diminish the protection of the rule of the freedom of speech in order to protect democracy now? It's already a discussion in the academia. It's very dangerous. So the only way to go out of the labyrinth, and my way means education. So what do we do if we want to keep the streets clean? What do we do if we want people to be behaving okay. People needs to be part of a system where everybody wants to take care and not to transmit fact. Thank you. Yes, and not to transmit the facts that are just false facts. So this is very important that we really engage each of us in this beautiful task of promoting rule of law, explaining to people that their liberty and their dignity is connected to the rule of law. So let me also finish with the last point, which is, yes, rule of law is based on a system where power, particularly public power, is limited by the Constitution. It's only legitimate if its exercise is controlled by laws. But it's also legitimate because this public power is divided and has checks and balances. And what we really have here is that the weakest of the three powers, imagine which is the weakest. It's not executive power, it's not legislative powers, it's the judiciary. It's very easy. We had also this conversation with the king. The president of the Albanian Constitutional Court said, they attack us, the politicians attacked us, that we are using lawfare and whatever. And so we need to protect the independence of the judiciary. I am remembering what Alexander Solzhenitsyn brilliantly said. A dignified justice is the most belated fruit of the most mature of societies. So, yes, independence of judiciary is the most significant step in the construction of the rule of law. And this is what we have to protect. Without, that was said by Spanish King Felipe, when he received in Madrid the World Peace and Liberty Award, without respect for the laws, there is neither coexistence nor democracy, but insecurity and arbitrariness. Let me finally thank all of you, Nicolás Santis as well, and my friend, the Bonillo trustee from Dominican Republic, the big attorney, Valdez, and let me also thank all of you for being here, coming here, but I want to thank particularly Justice Kennedy. We want to see 3 videos, one on the history of the World Jurist Association, the other one, Anthony Kennedy giving thanks, and the President of the Supreme Court of the United States, which sent a video to this gathering as well, John Roberts, and we're going to see them, but I want to thank the team that make it possible. Diego Solana, Jackie Rodríguez, Miguel Larios, Carlos Bastarreche, Teodoro Toma, Teresa del Riego, Juan Luis Cebrián, Irene Esteve, Leopoldo Lelo, Yolanda Sánchez, Julia Gutiérrez, Juan Miguel Olri de Labri, Encarnación Roca, Carlos de la Mata, Gabriel Fernández Rojas. So many others make it possible, but they were working that everything from the small details to the big ideas were really working. So thank you very much. We will be together very soon. It's a pleasure to have you in Madrid. It's a pleasure to leave you with these videos, and then will be a pleasure to hear the final speech. We have been working very much to make it possible that you came here. Thanks God, our King had the time to meet privately with you, and that was our honor and also our opportunity to learn more from the Islamic world, from the Saudi Arabic world, and from your culture. Thank you very much. Thank you.
Peace through law. During the Cold War years, faced with the threat of a nuclear holocaust, a few good men set in motion a singular initiative in favor of peace. It was July 1957 when, on the occasion of a gala hosted in London in honor of the American Bar Association, its president, Charles Ryan, the Chief Justice of the United States, Earl Warren, and Sir Winston Churchill agreed to create a program to promote world peace through law, the rule of law against the use of force. It's at that moment they decided to launch what would later be called the World Jurist Association. Years later, in 1963, Charles Ryan and Earl Warren, in their tireless struggle for human rights, inaugurated in Greece the first World Congress of Law. Numerous presidents of Supreme and Constitutional Courts from different countries throughout the world, general attorneys, egregious lawyers, and eminent professors, a group of more than 3,000 jurists centered around a single purpose, defined by President Kennedy in his message to the Assembly. It gives me great pleasure to send greetings to the First World Conference on World Peace through the Rule of Law. This conference represents 5 years of effort and brings together lawyers and judges from overseas from 100 countries in the attempt to develop and strengthen the legal machinery that must form the basis for peaceful relations among all nations. 2 years later, Lyndon B. Johnson inaugurated the Second World Congress in Washington, whose organizing committee was chaired by Presidents Truman and Eisenhower. 25 more assemblies of this kind, organized by the World Jurist Association, have taken place since then in various countries worldwide. Thousands of men and women united in this formidable association to promote peace through law throughout the world. Three world statesmen were also honored years ago with the World Peace and Liberty Award. Sir Winston Churchill, René Cassin, father of the UN Declaration of Human Rights, and Nelson Mandela. In Madrid, within the framework of the 26th World Law Congress, the largest association of jurists in the world, King Felipe VI of Spain is awarded the World Peace and Liberty Award for his defense of democratic and constitutional values that has presided over the 40 years of greater freedom and prosperity throughout the history of his country.
In February 2020, the World Jurist Association and the World Law Foundation, chaired by Javier Cremades, present the World Peace and Liberty Award to U.S. Supreme Court Justice Ruth Bader Ginsburg. Upon the passing of the U.S. Supreme Court Associate Justice, the World Jurist Association, along with Professor Jane Ginsburg, decided to confer the Ruth Bader Ginsburg Medals of Honor to female jurists who have promoted the rule of law and gender equality throughout their careers.
I would like to first of all acknowledge and celebrate the creation by the World Jurist Association of the Ruth Bader Ginsburg Medals. Not so much because we were just awarded the medals, but because it is a very effective way to promote the legacy of a giant on the shoulders of whom we all stand. Not only did she consistently and resiliently promote the equality of all before the law and the defense of the rule of law, but she was also a magnificent agent of change for good in society and in the world. The WJA is part of the contemporary history of the struggle for a world ruled by law, not by force.
For the first time, this award that many consider the Nobel Prize of Law is not given to a person. The World Jurist Association awards to them the World Peace and Liberty Award as its 2021 World Law Congress. Congratulations, people of Colombia.
For 60 years now, the WJA has worked to strengthen the rule of law around the globe so we can build a peaceful, more inclusive set of societies where the rights of all are respected.
Freedom, equality, rule of law. And here we are in the midst of it. Here we are. Can we? And none of us knows. None of us knows. All we know is that we can try. All we know, as you said, we can do our best. That's it. That's it. But that's what you're trying to do. And that's what you've been trying to do in this organization for quite a few years. And that's what you have quite a lot of people going out and actually doing it. So we have 3 languages where they produce a challenge. And we are in a building where they tried to meet it. And we are in an organization that itself is trying to meet that challenge. And all I can say is, thank you for recognizing me as a part of it. Thank you.
You may ask what the World Jurist Association is doing here at the United Nations today. We are here because we share President Kennedy's belief that law is the strongest link between humanity and freedom. We are here to bolster the rule of law, to lay claim to the hard work of lawyers and judges and jurists across this country and around the world who risk imprisonment and torture and death every day, day after day, day after day.
5 outstanding women will be receiving the Ruth Bader Ginsburg Medals of Honor.
A world ruled by law and not by force is the key mission of the World Jurist Association. Promoting the rule of law worldwide is a key enabler for progress in all other policy areas.
Andrew Young is a powerful voice of peace.
So I want to thank you for your faith in justice and your willingness to work for peace.
On behalf of the World Jurist Association, welcome again to New York.
What an honor to receive this award on behalf of the European Commission. And this on the occasion of the 60th anniversary of the World Jurist Association, a network of jurists that would defend fundamental rights and the rule of law across the world as a contribution to global peace. 60 years on, you are still faithful to your foundation and your principles. And I want to thank the World Jurist Association not only for this recognition, but for your enduring service to all humanity.
This is a consequential moment, and it calls for thoughtful leadership and strong institutions. And I cannot think of a better embodiment of those than Ursula von der Leyen and the European Commission. You show us how respect for the dignity of all leads to the strength to protect peace, no matter what. And this is what we honor today.
I would like to pay tribute to 2 jurists from the US who, together with Sir Winston Churchill, set out to mobilize the international legal community in order to promote the rule of law over the rule of might. To this purpose, they founded the World Jurist Association. The legacy of these 2 men, Charles Ryan and Earl Warren, must be preserved and handed down to future generations.
Un cordial saludo a todos los participantes presentes en este evento especial en Madrid, and greetings to leaders and friends of the World Jurist Association as you award the WJA Medal of Honor to Justice Anthony M. Kennedy of the Supreme Court of the United States. Justice Kennedy is a fitting honoree for WJA because he is a tireless and committed advocate for the rule of law as the path toward world peace. In 1963, he started practicing law in his hometown of Sacramento, California. The same year, Earl Warren, one of my predecessors as Chief Justice of the United States, helped lead the inaugural Congress of the WJA. Tony Kennedy became a judge 12 years later, in 1975. And over nearly a half-century on the bench, he has exemplified commitment to the highest ideals of the law. Like WJA, Justice Kennedy has worked to foster common cause across borders. He has traveled around the world to learn, to teach, and to help build an international community of respect for courts and the judicial process. He is a good listener who has remained curious and humble despite his towering contributions in the United States. And the WJA has chosen a fitting day to honor Justice Kennedy. 235 years ago, on March 4, 1789, the new Constitution of the United States came into effect. Justice Kennedy has been a guardian of that founding charter throughout his career. Today, I join you in celebrating him as a model of judicial decency and a champion for the French.
To each of you, to so many, please accept from me, from my colleagues on the court, and from my family, our deepest thanks for this splendid award. It will inspire me. It will inspire me in my remaining years to find new avenues, new ascents, new aspirations, new adventures on the path to the rule of law. His Majesty the King of Spain honors us all by his recognition that the World Jurist Association brings the idea and the reality of the rule of law to so many parts of the world. And to President Javier Cremades, to my own colleagues who are with you either by tape or in person, the Chief Justice and Justice Sotomayor, and to so many distinguished members in our profession, in the judiciary, the bar, and the academy, please accept my warmest expressions of gratitude. This award should remind us all that we need to honor the rule of law with renewed commitment to its purpose as we continue our careers day to day and year to year. On earlier occasions, when it's been my privilege to be with you, we had the hope and the fulfillment of coming away with a renewed resolve to ensure a civility within our profession. For that civility is the beginning of civility in society. We must try to ensure that these same lessons, these same hopes and aspirations will inspire other nations to respect the dignity and decency of all persons. This is what your association means. This is what this treasured medal means. This is what our oath of office as professionals must mean to us and to the people of every nation. My hope is to be with you in the Dominican Republic at the next World Law Congress. Between now and then, please be assured that it would be my honor and pleasure to meet and converse with you often by talking and conferring with each other from time to time. We can find ways not only to have closer friendships among us, but to have closer cooperation as we seek to bring respect for the rule of law to nations around the world. And as for this splendid medal you have given me, let me quote from what England's great poet wrote: "For your gifts we can no other answer make, but thanks and thanks and ever thanks."
It is now my great privilege and honor to introduce, I'm going to butcher your name, I apologize. Al-Saleham. Assalamu alaikum.
كده بعد كده صديقي العزيز السيد خافير، الحضور الكريم، أسعد هذا اليوم باللقاء بكم، وأعلم أن هذا اللقاء يجمع نخبا حقوقية من حول العالم، وهذا ما يجعل لقاءنا متميزا جدا. وأسعد أيضا بأن هذا اللقاء يجمع تنوعا من هذه النخب، والتنوع يشمل التنوع الديني والتنوع الإثني والتنوع الثقافي، وهذا جميعا يصب في مفهوم التنوع الحضاري. عندما نتحدث عن التنوع الحضاري نتحدث عن تاريخ طويل يتعلق بهذا التنوع، تاريخ طويل من المتاعب والسجالات الإنسانية، وذلك حيث إنها فهمت هذا التنوع في مساراتها السلبية، فهمته فهما خاطئا. نعم، فهمت هذا التنوع فهما خاطئا، ونتج عن ذلك صراعات إنسانية طويلة جدا، وهذه الصراعات غالبها في التاريخ الإنساني ذات أسباب حسبت على الأديان، وحقيقة الأديان بريئة من هذه السجالات والصدامات. ومن هذه الصراعات صراعات تتعلق بالسيادة السياسية، وهي مدفوعة بمصالح مادية أو مصالح تتعلق بالسيادة الحضارية، وكأنه لا بد أن يكون هناك صراع بسبب ذلك الاختلاف الحضاري. ينقص ذلك السجال عبر تاريخه الطويل شيء واحد، وهو الوعي. ولكن نسأل أنفسنا: الوعي بماذا؟ إنه الوعي أولا بحقيقة هذا التنوع، ماذا يعني هذا التنوع؟ الثاني، ماذا يجب علينا أن نفعله حيال هذا التنوع؟ هذا التنوع لا بد أن نفهمه بأنه من طبيعة هذه الحياة. هذه الحياة التنوع فيها حتمي، وما دام حتميا فهو قضاء رباني، هو اختيار إلهي لوجود حتمية التنوع. وإذا قلنا بأننا يجب أن نفهم ذلك التنوع، وهو الخطوة الثانية، بأن لا بد أن يكون هناك سيادة حضارية تنتج عن صدام وصراع يؤدي إلى الاقتتال والمواجهة من أجل فرض تلك السيادة الحضارية بالقوة، فعندئذ سنقول بأن الخالق جل وعلا قضى علينا بحتمية أن نتصارع منذ أن خلقنا متنوعين. وكأن هذا التفسير يقول بأن الصراع والقتال هي إرادة ربانية، والخالق جل وعلا منزه عن ذلك. ولهذا ينقص عالمنا اليوم ذلكم الوعي، كما نقص السجل التاريخي السابق ذلكم الوعي. هذا الاختلاف والتنوع هو من أجل أن نتعارف ونتحاور ونتقارب ونتفاهم. هناك مشتركات يجتمع حولها الإنسانية، وهي القيم الإنسانية المشتركة، وهذه القيم وبحسب استطلاعاتنا 10% منها فقط كفيلة بإحلال السلام في عالمنا والوئام في مجتمعاتنا الوطنية، غير أن الجهل والشر لا يستوعب ذلك ولا يريده، وبالتالي كانت هناك نظرية حتمية الصدام والصراع الحضاري، وألفت في ذلك كتب انتشرت عالميا وطبعت بلغات عدة وبعشرات الطبعات، وبتلك اللغات من ذلك، وهي تمثل نظرية بالنسبة له، وإن كان لا يدعو هو إلى الصدام والصراع، لكنه يقول بأنه حتمي الوقوع، وهي نظرية صدام الحضارات للدكتور صامويل هانتنغتون. نحن لا نوافقه مطلقا على نظريته، غير أن هذه النظرية بدأت تظهر مؤخرا بعد الحروب التي حصلت في عالمنا مؤخرا، فبدأت نظرية صراع الشرق والغرب ونظرية السيادة الحضارية والثقافية بالقوة وبالهيمنة السلبية. علمنا بأن هذا الأمر يشكل خطورة على عالمنا ويشكل خطورة على أجيالنا القادمة، وأطلقنا مبادرة بناء الجسور بين الشرق والغرب. أطلقناها بترحيب وبدعم من الأمين العام للأمم المتحدة، فأطلقت داخل مقر الأمم المتحدة في نيويورك. كان هناك تفاعل من قبل قيادات الأمم المتحدة بحضورهم وبكلماتهم لدعم هذه المبادرة بناء الجسور بين الشرق والغرب. نتحدث عن القيم المشتركة التي تجمع الجميع. أيضا كان هناك حضور من القيادات الدينية من جميع الأديان، وأيضا من مفكرين وسياسيين وتحديدا برلمانيين مؤثرين حول العالم. كانت هناك هذه المبادرة من أجل أن نقول للعالم بأسره بأن عالمنا وإن اختلف إلا أن هناك قيما ومشتركات تجمعه، قيم إنسانية، قيم حضارية، قيم دينية يشترك فيها الجميع. وهذه القيم ما تفعلناها ولم تكن مجرد نظريات، فإننا بمشيئة الله تعالى سنقضي على كل التصورات السلبية في تفسير ذلك الاختلاف والتنوع الديني والعرقي والثقافي وحتى الفكري، وهو كما قلت قبل قليل ينتهي إلى مفهوم التنوع الحضاري. الأمم المتحدة شاركت معنا أيضا عبر منظمة تحالف الحضارات، وكانت مشاركة مهمة، ونقدر للأمم المتحدة بأنها أنشأت هذه المنظمة، منظمة تحالف الحضارات، وإن كان وعيا جاء متأخرا بعض الوقت، لكن أن يأتي خير من أن لا يأتي أصلا. فجاءت هذه المنظمة وقدمت رؤيتها ورسالتها وأسهمت بإسهاماتها وتعاونت مع رابطة العالم الإسلامي، ولدينا تواصل مباشر مع الممثل السامي لتحالف الحضارات في الأمم المتحدة من أجل تحقيق هذه الأهداف المشتركة. أعود لأقول بأن تعزيز الوعي بهذا الاختلاف والتنوع في عالمنا من المهم أن يأتي في وقته وأن لا يأتي في الوقت الضائع. من الخطأ أن نعالج ثم نتعب في العلاج، وقد ينجح العلاج وقد لا ينجح، لكن أن نبادر بإجراءات وقائية لتعزيز الوعي، فهذا هو التصرف الحكيم والسليم. ولكن كيف لنا أن نصل إلى ذلك الوعي الوقائي في وقته المبكر؟ لن نصل إليه إلا من خلال صياغة عقلية أجيالنا القادمة من الصغر. ولهذا ما أسهل أن يصاغ العقل صياغة سليمة وهو في بداية تشكله. نعم، في بداية تشكله، ولا يحصل ذلك إلا في الأسرة ابتداء، ثم لدى التعليم في المرحلة الثانية. والتعليم يقوم على أمرين: المنهج والمعلم. وتأثير المنهج وبحسب دراساتنا لا يتجاوز في هذا 10% فقط، أما المعلم فدوره يصل إلى 90% في التأثير. وهذا التأثير لا شك أنه يصوغ عقل النشء صياغة سليمة. من الصعب أن تعدل أفكارا نشأت على تصورات سلبية حتى بلغت سنين طويلة، لكن عندما أصوغ من خلال الأدوات الحضارية لدي، بدءا من الأسرة ثم التعليم وكذلك منصات التأثير ولا سيما منصات المجتمع المدني، عندئذ أستطيع أن أفعل شيئا لصياغة عقول الأجيال القادمة من خلال تعزيز الوعي. المشكلة في مناهج التعليم حول العالم، وبالتالي نجد أن المعلم أمام نص منهجي، هي أنها تركز على المواد العلمية، ولكنها لا تعير اهتماما إلى القيم. تعليم الأطفال والشباب القيم، ومن خلال هذا التعليم نستطيع أن نصوغ أفكارهم صياغة سليمة من خلال التفكير الناقد، من خلال التصور الحر، التحليل الحر، ومن خلال الحوار المنطقي والتأسيس على الحوار المنطقي. عندئذ نصل بهم إلى صياغة سليمة لأفكارهم. عندما نجد أحدا من الأشرار وهو يقود أي مؤسسة، منظومة، دولة، أيا كانت هذه القيادة، وهو يمارس شره، نسأله: من الذي علمك ذلك؟ نعم، لأن الذي يحرك الناس هي الأفكار. الذي يحرك الناس عموما هي الأفكار، وكذلك القيادات التي تقود الناس تحركها الأفكار. وهذه الأفكار إذا لم تتربى، لم تنشأ نشأة صالحة بتفكير سليم، فإنها ستتصرف تصرفا سلبيا، وبالتالي يؤثر ذلك على شعوب العالم. هناك مصالح براغماتية، هناك براغماتية بين الدول، وهي براغماتية إيجابية. هذا أمر طبيعي من حق أي دولة، نعم من حق أي دولة أن تبحث عن مصالحها، وهذا شيء طبيعي. ولكن أن تضر بمصالح الآخرين، بمصالح الدول، فهذا غير مقبول. ولكن حتى لو كان هناك اختلافات بناء على هذه البراغماتية، فإنها بين الدول تتصالح أو تتفاهم أو تتفاوض، تتقايض، لأنها تبحث عن مصالح دولها. ولكن أن يصل الأمر في صدامه وصراعه إلى الشعوب، فإن علاج ذلك صعب جدا. أن يصل الصدام والصراع إلى الشعوب، فهذا أمر صعب جدا، وهو الذي يقود في النهاية القيادات السياسية إلى الصراع الدائم الذي لا يمكن الرجوع ولا المفاوضة حوله، لأنه مبني على ثقافة وعلى قناعة شعبية، وهنا الخطورة. ولهذا من أعظم الأمور التي يمكن أن يقدمها المصلحون هي تعزيز الصداقة والتعاون بين الأمم والشعوب. نعم، أممنا تحتاج إلى تعزيز الصداقة، ولكن كيف نعزز هذه الصداقة؟ لا يمكن أن نعززها بمجرد محاضرة تقال ثم تنسى في يوم إلقائها، أو في كتاب يحمل تنظيرا وأفكارا لا يطلع عليها إلا قلة من الناس ثم تنسى، أو قرارات أو بيانات حتى لو كانت دولية ما لم تكن ذات أثر فاعل منفذة فإنه لا قيمة لها. لا بد من أثر ملموس، لا بد أن يخطو عالمنا خطوات استراتيجية نحو تعزيز الصداقة والتعاون بين الأمم والشعوب، تعزيز الوعي الحضاري، تعزيز دور الأسرة. نعم، تعزيز دور الأسرة، ومن خلال المجتمع المدني الذي يهتم في بعض اختصاصاته بتعزيز دور الأسرة، وكذلك أيضا التعليم. هي باختصار مسؤولية تضامنية مشتركة بين عدد من المؤسسات، لا بد أن يتضامن عالمنا من أجل ذلك. ولهذا نحن نقول لا نريد مزيدا من الأحاديث، وإنما نريد أفعالا. لا نريد مبادرات، وإنما نريد أن نبادر، نفعل شيئا للمبادرة. المبادرات كثيرة، المحاضرات كثيرة، البيانات كثيرة، ولكن ما هو الأثر؟ نريد أثرا ملموسا. أعتقد أن هذا يبدأ من البداية، وهو الصياغة السليمة للأفكار المتعلقة بصناعة الأجيال القادمة في تأسيسهم العقلي، الفكري، الثقافي، الحضاري، إلى غيرها من المصطلحات التي تصب على معنى واحد. أيضا أشير إلى تحدي يتعلق ببعض الفلسفات التي ربما فهمت الحوار بين الأديان أو الحوار الثقافي على أنه لا يشكل بعدا أو يشكل أهمية، لأن لكل أمة دينها وثقافتها وحضارتها، وبالتالي نتصالح فيما يتعلق بالتبادل المادي البحت فقط، ولكن لا نصل إلى الوجدان، لا نصل إلى المشاعر، لا نصل إلى تعزيز الأخوة، وهذه كارثة. ولذا يجب أن نقف إزاءها من خلال ما أشرت إليه قبل قليل، من خلال هذه المنصة، من خلال هذه الجمعية. نتفاءل كثيرا لأنها بقيادة صديقي العزيز السيد خافير متحمسة بقوة نحو تعزيز هذا الدور، ونحن نضع يدنا مع يده من أجل القيام بهذه المسؤولية، وهي مسؤولية يجب أن نلمس أثرها. لا يكفي أن نسمع فقط، لا بد أن نلمس بشيء ملموس، تنجب ملموس، وليس فقط كلمات أو عبارات تقال ثم تنتهي. لا أحب أن أطيل، وفيما ذكره صديقي وزميلي قبل قليل الكثير من الإشارات والإضاءات حول هذا الموضوع، ونلتقي إن شاء الله تعالى في لقاءات أخرى من خلال برامج فعالة. تحدثنا اليوم عن فكرة رائدة ورائعة أرجو أن تتحقق، وزملائي ونحن على الغداء ناقشوا هذا الموضوع، وهو إقامة أكاديمية أو معهد أو منتدى لتعزيز سلام عالمنا إلى التبادل الثقافي، إلى التبادل الحضاري من خلال القيم الإسبانية وامتدادها الدولي لتجمع الجميع حول مفاهيم مشتركة. هذه الأكاديمية وهذا المنتدى يصب في أهدافه نحو ما تحدثنا عنه قبل قليل، وهو تعزيز الوعي من أجل السلام، من أجل الوئام، من أجل فهم طبيعة هذه الحياة وكيف لنا أن نتعامل مع تنوعها واختلافاتها، ومن أجل إيجاد برامج فعالة، من أجل أيضا تقديم نصائح للمؤسسات المسؤولة عن الأسرة في عالمنا، أيضا تقديم نصائح من خلال مبادرات للتعليم كمناهج تعليمية، وتقديم ذلك أيضا للأمم المتحدة من أجل تحفيز الدول الأعضاء على العمل على ذلك. طبعا من خلال مؤتمرنا بناء الجسور قدمنا بعض المبادرات. من هذه المبادرات هو دعوة الدول الأعضاء لتعزيز مفاهيم الصداقة والتعاون بين الأمم والشعوب، وأيضا تعزيز المفاهيم الصحيحة نحو الاختلاف والتنوع في هذه الحياة، وأن يختار لذلك المدرسون الأكفاء من أجل القيام بمسؤولية هذا الوعي، وأيضا أن يكون هناك يوم عالمي يتم الاحتفال به على مستوى العالم احتفالا فعالا وليس احتفالا شكليا، وهو اليوم العالمي لتحالف الحضارات، وهذا أمر مهم جدا، ونرجو أن تتحقق هذه الأعمال المشتركة. وأعلم يقينا أن في هذا العالم الكثير من الخير، لكن لا بد أن يكون هناك بوصلة نسير على ضوئها نحو أهدافنا المشتركة. وشكرا لكم.
Please take your seats. No, I'm going to do this off the top. Please take your seats. Thank you, Excellency Mohammed Al-Khasir. For your very important comments regarding the criticality of family, how important it is for family, because family either teaches hate or teaches love, on the importance of friendship, on the importance of diversity, all critical components. And I especially appreciated your comment that we needed something tangible. I think that it's very important at this critical time that we all work together to try to do something tangible, to bring together the world's religions, to bring together the world's peoples. I think that your closing comments at this very important panel summarize everything that the World Jurist Association is and does. And your comments encapsulate what we now need to do, we need to focus on these values because they are critical to us being able to move forward and have the religions of the world impacting the rule of law through peace. Thank you so much. Thank you very much, everyone.
So I just want to declare finished these days. Thank you, His Excellency. I think you all know this is a world-class figure. He's a very important leader of the world and has been a real pleasure. I understand your tears. I understand your emotion. And it has been very important for us to hear what we just heard. And now it's a call for action. So thank you so much. Thank you for your participation. And I hope that you get engaged with Madrid in a long term and you come back to share with us your thoughts and your heart. Thank you very much. Thank you, everybody.